CRP, new map, fresh matter, my lord. We are seeking for posting up tomorrow, my lord.
Mosque. My lord, interim prayer. Next week, no. Some land acquisition matter.
Land acquisition matter. This case, my lord, on 9/9/2022, my lord, it was original matter, KLR matter. Thereafter, my lord, the last is, my lord, directed the office to reclassify as earlier, my lord. Since from that, the matter not posted. Now, not the, on that day, my lord, the dishonorable court directed the counsel on record that the instruct your officer not to release the compensation. In that regard, my lord, the KADB also issued. ನನಗೆ ಸಮಯ ಇಲ್ಲ ಈಗ ಅವ್ರಿಗೆ ಆರ್ಡರ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ ಅದರ್ ಸೈಡ್ಗೆ ಅದಕ್ಕೋಸ್ಕರ ಮಲಾಡ್ ಐ ಸಾಟ್ ಫಾರ್ ದಟ್ ಇಂಕ್ರೀಸ್ ಮಾಡರ್ ಇನ್ ದಟ್ ಕೇಸ್ ಆಫ್ ಟುಮಾರೋ
My lord, land acquisition matter, my lord, on 16/11 it was listed and notice was ordered, but interim prayer was not considered. It is pending. Sarvagide sir. Interim prayer still it is pending. It has to be considered. Maybe listed on 7th, my lord.
For adjournments, page number 9, seal number 35, page number 10, seal number 36 to 38, page number 11, seal number 39 to 45.
Serial number 42, my lord. Appear for respondent number 2. 2 weeks time, ma'am. Or ಹೇಳಿದಿರಾ? ಇದರ ಅಲ್ಲ objection file ಮಾಡಬೇಕು. Next week, my lord. Next week. And date may be given, my lord. 11th, my lord.
11th. Page number
39.
Next week. Serial number 46, my lord. I am for the respondent file objection. ಅವ್ರು ಹೇಳಿದಾರ ಅವ್ರು ಮೂವ್ ಮಾಡಿದಾರ ಅದಕ್ಕೆ
46 to 53.
Serial number 47, notes. Preparing for petition in this case. You kindly have it on next week, notes.
next week.
Page number 13, seal number 54 and 55. Fresh matters, list number 1, serial number 1.
Sorry, list number 2, serial number 1. Our throat infection ಆಗಿದೆ ಸೀನಿಯರ್ಗೆ. ನಾನು ಒಂದು 3 days accommodation ಮಾಡ.
ನೋಡಿ
throat infection can't speak.
230 list 230 ಮೆನ್ಷನ್ ಮಾಡಬೇಕು.
Please. Sorry.
Serial number 1. Manjaya Shetty.
It's 4 days delay. For continuation.
What is the matter about?
It's an IP matter, my lords. We have challenged the jurisdiction of the trial court, saying it's a commercial dispute. My application for rejection of plaint was dismissed. On that, I filed this appeal.
Where's your application?
I'm a proxy counsel appearing. The counsel is from Delhi. They've requested that I be served, that I be permitted to serve the counsel appearing for the respondent in the
You have
trial.
to first make out a case for issuing notice, isn't it?
Please, no, there is a delay, my lords.
So automatically I should issue notice.
I'm sorry, my lords.
Where would be a question of rejection of the plaint? If your argument is accepted, the plaint will be returned for representation, isn't it?
My lords, when the Commercial Courts Act was being brought into effect, then if it was pending, then they could transfer. Now, if it is filed before the court, which does not have jurisdiction, then they'll have to reject the prayer itself because valuation itself is incorrect.
No, but okay, there's a question of rejecting the plaint. They'll have to return the plaint for you to present it before the law appropriate forum.
Please, my lords, but that application itself was dismissed, saying there is jurisdiction. The suit, my lords, was valued at 1,000 rupees based on the relief. There is a division bench judgment also.
Not a ground to reject the plaint, is it?
At least, my lord, the court could have returned the plaint, but the court has said that it has jurisdiction.
Then,
My lords, may I seek a pass over, my lords? The counsel is from Delhi. I was only asked. Please, my lords.
next week.
There is some urgency, is what they've told
There's
me.
a delay of 4 days. I can't do anything without
Issuing notice, let us see, I can't grant you any interim order,
Please, please.
then what
I may
is
be
it?
permitted to take advance notice on the counsel appearing for the response.
First, make out a case for issuing notice. Why are you insisting on a notice we shouldn't? Suppose I dismiss your petition without notice,
Please, may I seek pass out to the afternoon minutes?
Monday, next Monday.
Grateful.
Appeal number 2, Shri B. Sharat Kumar.
Permission to convert the writ petition.
The counsel for the files amendment, no permission to convert this revision into a writ petition. Amendment is accepted. Counsel proposes this revision and disposed of petition to form an amended writ petition.
Appeal number 3, Shri H. V. Ramachandra Rao. H. V. Ramachandra Rao.
Serial number 3, my lord. I appear for the petitioner counsel, my lord. The
Yes.
office has raised an objection that to the IA, which is filed for stay, it is accompanied by the affidavit of the counsel, not by the party. That is the objection that is raised, my lord.
ಏನ್ ಮಾಡ್ತೀರಾ ಆಗ್ತೀರಾ party affidavit?
And the party is in America, my lord. My affidavit may be considered, my lord. The advocate affidavit may be considered, my lord.
How can you swear to the facts of the case, madam?
Then I pray for a week's time, my lord. I'll appraise the counsel.
Weeks.
Appeal number 4, Shri K. R. Ganesh Rao.
My lord, the writ petition was disposed on 12/12/23, my lord. Prayer number C was not, no order was passed in that. It was not heard and no order was passed. In respect of prayer number C.
You did not argue, therefore it was not considered.
No,
Whatever was argued was considered.
no, this prayer C was, no order is possible. Page number 24 of writ petition.
You never argued, the argument was.
No,
not-
argument was legal representative, and also I started, but an order was passed, my lord.
Not a
without-
ground for review.
No, I please issue a notice. please.
No. I find no grounds for the review.
No, but this prayer is not at all considered.
That can't be a ground for review. If you don't argue the matter, I can't assume that you would have argued the matter. Whatever is argued is considered.
No, I started arguing, but an order was passed, my lord.
Rejected.
Kindly issue notice, my lord.
It's rejected.
Appeal number 5, Shri Sampath A.
Lord, this writ is for seeking a mandamus to direct to execute a sale deed, my lord, with regard to the layout formed in Arkavati and Narayanpura village, my lord. Seeking for an interim prayer, my lord.
Shri H. Devendrappa to take notice for respondent.
The interim prayer may be
Grant
granted.
asked him to reserve a seat. Let us see.
Appeal number 6, Shri Sachin B.S. Seeking writ of mandamus to pay the compensation for the land acquired by the Lokopayogi Ilakhe, my lords.
AGA
Public
to
Work
take
Department
notice
for the formation of roads.
Respondents, relist.
I think
Date may be fixed, my lords.
Want to file secretary instruction.
Date may be fixed.
11th.
Much. Appeal number 7, Shri Rajeshwara P.N.
Seeking the writ of mandamus, my lords, to pay either compensation or grant TDR, my lords. The property, petitioner's land is utilized, my lords, without acquiring the land.
AGA to take.
As per
notice
annexure H, the petitioner is entitled to TDR also.
Shri Kiran C to take notice for respondents 2 to 4. Relist on.
11. Appeal number 8, Shri Ramesh K.R.
Appeal for petition this matter, my lord. My lord, matter for writ of mandamus. My lord, the petitioner filed an application on 5/11/2022 for the change of land. My lord, the respondent number 1 to 3 is not considered till today. My lord, the property is not in dispute.
J to take notice for R1. Shri Pawan Kumar G to take notice for R2 and R3. Relist on.
Mohan.
Pawan Kumar.
For preliminary hearing, seal number 9, Shri Puneet Singh.
The petitioners of the legal age of one Channamma, please, my lord. She acquired land bearing survey number 123 under his sale deed. Respondent Muda, please, my lord, they issued a preliminary notification in the year 1992 for formation of Alnalli residential layout, please, my lord. Subsequently, in the year 1996, final notification was passed. No award was passed, please, my lord, within 2 years as so provided in section 11A of the Act. My lord, this being so, the other landowners, please, my lord, they filed a writ petition in a several batch of writ petitions, please, my lord, annexure H to K, wherein the orders of the order of acquisition was set aside by this honorable court, please, my
What
lord.
was the acquisition for?
My lord, it was for formation of Alnalli residential layout, please, my lord. Annexure H to K are the connected matters wherein this honorable court has,
Who appears to the respondent?
my lord, T.S. Vivekananda is already on record. TP Vivekananda. In fact, please, my lord, on last occasion, 2 occasions, they sought time to file statement of objections. Till today, they have
Wanted
not.
to pass it over.
My lord, it's a batch matter. I'll leave it to the court, please, my lord.
Without hearing him, you want me to?
Allah, my lord, it is only a submission. It is.
If you want, I'll pass it over or I'll have it next week, your choice.
Pass over, please. my lord. Please.
Seal number 10, Shri Appanna Gowda.
Lords, I am appearing for petitioner. Lords, I am challenging annexure A, my lords.
Next year?
A, my lords, in page 23. Lords, under which, my lords, the site allotted in favor of the petitioner is cancelled, my lords, for non-payment of cital amount, my lords. Lords, the brief fact says, my lords, have paid the amount even prior to issuance of this impugned order, my lords.
Issue notice.
Lords, in the meanwhile,
Shri K. Krishna to take notice. For
please.
petitioners. Till the next date of hearing. There's an interim stay of all further proceedings pursuant to annexure A.
Please, oblige, my lords.
Seal number 11, Shri Bharat K.
Also, I'm petitioner. It's for on a writ of mandamus. Make you the residential layout developed by reliable developer. One.
In Murugesh, we charity to take notice for R2. Relist on.
18.3 na?
18. Seal number 12, Shri Raghavendra Kattimani.
Lord, the matter pertains to acquisition for nice. Lord, the preliminary notification got issued in 1990. The matter pertains to acquisition for the nice, my lord, nice project, BMICPA. Lord, the notification got issued in 1998 under 28(1). And 2008, my lord, 28(4) got issued. My lord, after all almost 15 years, the award came to pass in the year 2023. So almost 25 years has been over. Now the award came to be effected in at page number 49, my lord.
Page
49, my lord.
Was there any interim order granted?
No, my lord. No interim order. This is a fresh matter.
No. Was an interim order granted for them to?
There is no such interim order as such, my lord. Since, my lord, the acquisition itself, my lord, almost 2.5 decades. And that too, my lord, the ignoring the amendment came into to the KD Act at page number 74, my lord. The amendment, my lord, did
Issue notice, then it AGA to notice for respondents 1 into PV Chandrasekhar to take notice for R3 to R5. Who takes notice for R6 to?
DMIC, some Ravindra Reddy.
Shri Nitin Prasad take notice for R6 to R8. R6 na sir. You?
R8, Yogesh Nayak.
Shri Yogesh Nayak to take notice for respondent number 8. Relist on.
18.
please.
Seal number 13, Shri Govind Raju K.
In this case, my lord, I sought for a mandamus directing to change the Khata in my favor, my lord. That originally the site was allotted during the year 1993.
Shri T. Vachan to take notice for respondents 1, 2, 3. You react madidara? R4.
R4 is he was originally allotted 681, 682, my lord. That subsequently.
He'll have to be heard in the matter. On notice kodlebeka.
Houdu.
Issue notice to R4.
Number 14, Shri Sharat Kumar Shetty.
Let file objections. Who's for the respondent?
Be my answer. R2 to R.
National Highways. Kaveri Niravarni. Case be made to take notice. Idara, Tondidara. For R2, AJ to accept notice for respondents 1, 3 and 4, relist on.
Interim order.
In interim.
Interim order.
You're asking for consideration of representation.
Pardon.
You're asking for consideration of representation.
Pardon. I thought it's a different matter.
This is release of excess supply.
Interim order is more than the final order.
Sorry.
Pawan Kumar ji.
Hearing for the petitioner, my lord. My lord, all these batch of matters, my lord, land is being acquired for integrating the peripheral ring road with the nice road. The peripheral ring road, my lord, for the last 25 years has not seen the light of day. Who appears for the respondent? Have they filed the counter?
My lords,
My lord, please.
seek 2 weeks time to file statement, my lords, in this case.
My lord, the matter can be disposed of in my humble submission because in 2010, my lord, additional land was sought to be acquired for a interchange for the toll plaza. That was challenged before this honorable court. This honorable court set aside the acquisition saying, once you finish the PRR, then you acquire any other land if you require it. That was taken in appeal. That was taken all the way to the honorable Supreme Court, my lord. And it is it has been upheld that once you finish the PRR, then you can acquire any other land in regard to PRR. If I could take my lords to those judgments, I'm covered by those judgments, my
My
lord.
lords, I have written a letter to the BDA seeking instruction on this, my lords. My lords, post it after 2 weeks, my lords, I will file my statement along with the details, my lords.
You have an interim order in your favor.
My lord, I checked with the buyer interim order sikkidre, then if they go ahead with the acquisition, then I lose out, my lord, in that
Preliminary
circumstance.
notification ಅಷ್ಟೇ
No,
ಆಗಿದೆ, ಇನ್ನು final notification is not yet issued, my lords. Preliminary,
You don't get ready because it says it is covered by a decision.
no, my lords, in the Supreme Court, my lords, in Shivaram Karanta layout, my lords, in so far as PRR road is concerned, 500 and odd acres is directed to be acquired for the formation of road and toll plaza, my lords.
My lord,
I'll
page
produce all
318.
those judgments, my lords.
What is preventing you from producing it immediately?
My
Because
lords,
If I grant an interim order, then it will affect the entire
Yes, my lords.
process. Then
my lords, it may be posted on Monday, my lords, by then I will.
release.
My lord, may please just page 318, just to draw the honorable Supreme Court's judgment.
It's not ready. What is the point?
Somewhere.
20th.
Grateful, my lords.
For orders, C number 16, Shri Chandrasekhar R.
16 and 17, my lord, appear for petitioner. Lord, matter has been remanded from the apex court. Court notice was ordered, my lord. Lord, yesterday one of the petitioner has called me, there are 6 petitions. Lordship may kindly have it after the week, my lord, I will.
Shall I say that you accept notice?
Please.
The G. Chandrasekhar sir, R. Chandrasekhar submits that he has instructions to appear on behalf of the case for a week's time. View of the above. The notice, court notice to the petitioners are deemed to have been served, relist on.
Name.
Petitioner.
16, 17.
Very good. 17 also.
Number 18, Shri Karumbai Ati.
For the petition. But I am not on the system, but
Then office objection ಅದಕ್ಕೆ ಇಲ್ಲ ಪಿಟಿಷನ್ ಸರ್ ಮಾಡಿಲ್ವ ಅಂತ ಪರವಾಗಿಲ್ವಾ ಪಿಟಿಷನ್ ಸೈನ್ ಮಾಡಿಲ್ಲ ಅಂತ ಪಿಟಿಷನ್ ಹ್ಯಾಸ್ ನಾಟ್ ಸೈನ್ ಯು ಹ್ಯಾವ್ ಸೈನ್ಡ್ ಬೇಡವಾ ನಿಮಗೆ counsel for the petitioner submits that he has instructions to withdraw the writ petition. In view of the above, the memo filed by the petitioner is accepted and the writ petition is dismissed as withdrawn.
with liberty is the case.
In liberty ಕೇಳಿದ್ರ
Under section 24. They want to. 24(2). 13 Act 1 ಮೇಲೆ ಆಗಿರೋದು.
liberty is reserved to the petitioner to file a fresh writ petition.
Number 19,
Appear on behalf of the respondent B. But your lordship said on the last occasion directed BDA to file an affidavit. But it appears, my lord, that the affidavit is already, only pray for a short accommodation in this matter.
After tomorrow.
7th or, my lord, on 9th, 8th or 9th, 8th or 9th, or we'll try to give a copy of that to him before that.
11th.
Please.
Till about 20.
Intermodal, the intermodal kind earlier should stand extended.
Yes, my lord. On Thursday, my lord, it is posted today to my lord to ascertain the information from the KDP. My actual submission is, my lord,
Bill number?
20. Yes, I need, my lord, the 1 week's time to file objection. Since, my lord, what exactly they are contended, like raising the rival dispute in respect of the property to receive a compensation by the KDB. That is, my lord, completely nothing to do with my claim. And the suits which have been referred to in my direction issued by the Assembly Court, my lord, something different.
Petitioner.
Lakshmi Menon.
Have filed an application for impleading, my lord, on behalf
Who appears for the petitioner?
Lakshmi Menon.
They are challenging annexure A.
Yes, my lord. It's a closure of the LIC proceedings, my lord, by at the instance of the KDB.
That was heard last time, isn't it?
Yes, my lord. But my lord, what exactly their plea, my lord, relying on the pendency of suit, where, my lord, we are not party. And that suit is nothing to do with our property.
Let them come.
Kindly, my lord, then next week, I'll file my objections, my lord. Since, my lord, my property is something.
Let them come first.
At least, my lord, my Wednesday.
Copies of the
I'll
writ
place
petition
my
minutes is also
application, my
not,
lord.
I appear for respondent number 11 minutes. Copies of the writ petition minutes is not served.
But I have filed an
Wednesday.
application for impleading also.
Next Wednesday. The next Monday.
4th, 11th. 11th. Number 21, Shri Sanat Kumar Shetty.
Who's filed the application vacating?
Nationally.
In office objections in. Respond 1, 2, 3 ನೀವು appear ಆಗಲ್ವಾ? Shilpa Shah. The Shilpa Shah to take notice for respondents. 1, 2, 3. Shanti Bhushan to take notice for R4.
Respondent number. I'm appearing for respondent number 4. Our respondent number 4.
Area, central government.
Sir.
ಯಾವ ಮ್ಯಾಟರ್ ಹೇಳಿ?
21 serial number 20.
ಡಿಮೈ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ಯಾರು?
R123 months.
R123 ಇದಾರಲ್ಲ ಅವ್ರು ಪಾರ್ಟಿ. ಪೆಂಡಿಂಗ್ ಸ್ಟೇಲ್ ಇದೆ. It is not on record. ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಅಲ್ವಾ?
Pardon.
ಹೆಸರು ತೋರಿಸಿಲ್ಲ. Ministers Goa Associates have filed an application for vacating the interim order. The office has raised an objection that they are not on record. Or it is noticed. That in the connected matter, they wanted appearance. Of the office objections are overruled. office is there to print the name of Mrs. Go Associates in the cause list and relist it on.
Interim order making.
The motor grant should stand extended to the next.
Bill number 22, Narayan Bhatt.
Interim order. My submission is that, my lord, the notification issue has lapsed having regard to passage of time of 1 year.
What is this affidavit that was required to be filed?
One of the connected matter affidavit came to be filed, my lord. And it requires, I have filed my statement of objections in other matters. I have received the records and parallel remarks also. I may be permitted to file my statement of objections.
When was the order directed?
It's in the November, my lord. In one of the connected matter affidavit came to be filed,
Yenanta?
saying that under section 21 of the General Clauses Act, government has got power to review the refixation of the award.
Respondents 1 to 3 are directed to file affidavit. Whether there's any other extension under section 19(7),
Yes.
proviso 2nd and 3rd of the Land Acquisition Act along with the relevant records.
That
ಇನ್ನು 2
effect-
ತಿಂಗಳಾಯ್ತಲ್ಲ madam.
To that effect, in one of the connected matter affidavit came to file saying that under section 21 of the General Clauses Act, state has power to extend the time beyond 1 year, my lord. Because their contention is that immediately after the preliminary notification, final notification has to be passed within 1 year.
2013 Act. 2013 Act.
Otherwise, I'll file my detailed statement of objections in
You have
rest of
not
the
filed it, madam. It's been 4 months. The affidavit was asked to
receive ಆಗಿದೆ. Parallel remarks ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
2013 Act.
One 2090 of 23.
One.
1209, 22.39.
Where an award came to be passed, thereafter it was rescinded and another award came to be passed, my lord, for a lesser value.
As the beneficiary passes an award at the higher rate, my lord, state feels that it is exorbitantly award came to pass. So under section 21, by exercising the power, it has reduced the award amount.
Suppose ಆಗಿಲ್ಲ.
Sorry, 2013 Act. 2013 Act.
In 21 of General Clauses.
Method is similar to section 19. Within subsection 7.
But this extension can be indefinitely. 12 months was, is the requirement.
Relying upon the reasons quoted by the Special Land Acquisition Officer, the state.
Please read subsection 7.
Yes, ma'am. So where no declaration is made under subsection 1 within 12 months from the date of preliminary notification, then such notification shall be deemed to have been rescinded, provided that in computing the period referred to in this subsection, any period or periods during which the proceedings for the acquisition of the land were held up on account of any stay or injunction by the order of any court shall be excluded. Provided further that the appropriate government shall have the power to extend the period of 12 months. So if in its opinion circumstances exist justifying the same.
Then next provision.
Provided also that any such decision to extend the period shall be recorded in writing and the same shall be notified and be uploaded on the website of the authority concerned.
Has it been done?
That is not the.
At least I have to verify, I'll get the instructions whether
What is
they
the
have
date of the
uploaded or not.
Preliminary notification is dated 11/3/2020. And it was published, my lord, in the official gazette on 23 April 2020.
They should have done it before 22/4/21.
Yes, ma'am.
Where is the extension?
Extension, my lord, the lordship gets it at annexure C.
Next year?
C, my lord, page 44. I'm sorry, annexure B, my
Yav
lord.
case, yav case.
My lord, first case. Page 43 ಸ್ವಾಮಿ. ಚಿಕ್ಕಮಗಳೂರು ಜಿಲ್ಲೆ ಕಡೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಕುರುಬರಹಳ್ಳಿ ಗ್ರಾಮದ ವಿವಿಧ ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಒಟ್ಟು 43 ಎಕರೆ 27 ಗುಂಟೆ ಎಕರೆ ಜಮೀನನ್ನು ಭದ್ರಾ ಮೇಲ್ದಂಡೆ ಯೋಜನೆ ಪ್ಯಾಕೇಜ್ 4.
This is up to 39/2021.
Yes, my lord.
Let us assume that time was extended in accordance to the third proviso. Have they now issued a declaration?
My lord,
Have they issued a declaration, madam, now that within this time?
That's why I have received entire things. I will file in detail. Statement of objections.
my lord, 2 submissions, my lord. One is beyond 1 year, my lord, there cannot be any extension. And if extension is required to be done, before the lapse of time, it is required to be extended.
When was this done under annexure C?
My lord, it is done on 22nd of September. April, my lord, if last notification published in the official gazette is taken into consideration. It comes to an end, my lord, on 22 April 2020. After about 5 months, my lord, it is done.
Then it is extended from 5/3/21 to 5/6/2021.
No, but can you do it after that period of 1 year is over? 1 year is over on 22/4/2021.
But section 19(7) says that, my lord, I finds that bona fide.
Correct, but
finds
when? So after 3 years, you can extend?
Within 1 year.
No, you have done it beyond that 1 year. The extension is on 30th of September 2021.
That period itself has been extended. That
Correct.
is our contention.
If you had passed an order before 22/4/2021,
Yes, ma'am.
extending by, let's say, 6 months, it will be valid. But after that, the provision says it's deemed to have been rescinded. So when you don't pass a declaration, issue a declaration, it is deemed to have been rescinded. After it is rescinded, where is the question of you extending the time?
According to my information, before rescinded only it has time. 1 year period has been extended periodically.
Where do you get that?
So I have received the paravise remarks.
Is she correct?
It is not correct. My lord, it was argued on the last occasion. This very query was put to my lord friend, my lord. Someone else had appeared on that.
Yes, Mr. Yogesh Naik has appeared.
But till today, no declaration is passed.
My lord, as it goes to my knowledge, my lord, no declaration. And my lord, this does not contain any reasons. My lord, the second proviso further says, and not published in the official gazette also. Sorry, my lord, on the website.
Site. I'll place it, my lord, whether they have posted or not, I will place it.
Wednesday.
Yes.
Your lordship, may kindly have it on Thursday. Thursday, my lord.
My lord, on submission, my lord. Respond number 4. ವಿಶ್ವೇಶ್ವರ ಜಲ ಮಂಡಳಿಗೆ ನಾವು ಇನ್ವರ್ಸಿ ವಕಾಲತ್ ಮಾರ್ನಿಂಗ್ ಫೈಲ್ ಮಾಡಿದೀನಿ.
ಯಾರು?
ಇನ್ವರ್ಸಿ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿ.
ಅವ್ರು ತಾನೇ ಮಾಡ್ಬೇಕು ನೀವು.
ನಾವೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4ಗೆ ಇನ್ವರ್ಸಿ ವಕಾಲತ್ ಟುಡೇ ಮಾರ್ನಿಂಗ್ ಮಾಡಿ.
Shri Nagaya submits that he has entered appearance on behalf of R4. Office
Vishnu
verify
Nagaya.
and print his name in the call.
Till number 23, Shri Chandrasekhar R.
Office objections are being raised.
Till number 24, Shri Ramesh Chandra.
They appear for the petition.
Who's R12?
R12 is a case worker. It can.
ಮಾಡಿದ್ರ?
ನಾವು ಹೋಗಿದ್ವಿ ತಗೊಳ್ಳಿಲ್ಲ. ಅವ್ರ ಹತ್ರ ಕೊಟ್ಟಿದೀವಿ ಕಾಪಿ. ತಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರು.
ಕೋರ್ಟ್ ನೋಟಿಸ್ ಹೋಗಿ ಅವ್ರು ತಗೊಳ್ಳೋದಿಲ್ಲ. ಓನ್ಲಿ ಲ್ಯಾಂಡ್ ಆಕ್ಷನ್ ಆಫೀಸರ್ DC ಅವ್ರ ಕಮಿಷನ್ ಮಾತ್ರ ತಗೊಂತಾರೆ. ಅವ್ರ ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ ಕೋರ್ಟಿಂದ ನೋಡ್ಲಾ
ನಿಮ್ಗೆ ಅವ್ರು ನಿಮ್ಮ ಎಂಪ್ಲಾಯಿ ತಾನೆ?
ಅದು ಎಂಪ್ಲಾಯ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡಿ ನಮಗೆ ಓನ್ಲಿ ಸಂಬಂಧ ಬರಲ್ಲ ಅವರೇ.
I directed you to ensure that services are effected on R12.
ಅಲ್ಲ ನೋಟಿಸ್ ಹೋದ್ರೆ ಅವ್ರು ತಗೊಂತಾರೆ ನಮ್ಲಿಂದ ಕೋರ್ಟ್ ಇದು.
ಈ court order ತೋರಿಸಿ. What kind of an employer are you?
ಅಲ್ಲ ಅದು
There is an order of the court. As the head of the department, service on the head of the department is sufficient.
ಅದಕ್ಕೆ ಮಾಡ್ಬೇಕಷ್ಟೇ. ನಾವು ನಾವು ಲ್ಯಾಂಡ್ ಆಕ್ಷನ್ ಆಫೀಸರ್ ತಗೊಂಡಿದ್ವಿ ಸ್ವಾಮಿ R2, R3 and R4.
ನೀವು R12 ತಗೊಳ್ಳೇಬೇಕು. ಇಲ್ಲಾಂದ್ರೆ I ask the land acquisition officer to be present before the court.
ಅಲ್ಲ ನಮಗೆ ಡೈರೆಕ್ಷನ್ಸ್ ಇರೋದಿಲ್ಲ ಓನ್ಲಿ ಇದು ಮಾತ್ರ.
ನಾನೇ ಮಾಡಿದ್ದೀನಿ.
This is a private
Senate
party.
counsel is there to furnish a copy of the petition to the counsel of will respond KDB and to ensure that the copy is served on respond number 12. ನಿಮ್ಮಲ್ಲಿ ಜವಾಬ್ದಾರಿ ಇರೋದು ಸರ್ ಮಾಡಕ್ಕೆ.
ಅಲ್ಲ ಅವರು ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ ಇದೆ. ಓಕೆ ನೀನು
Is your employee, he's been arraigned only because some malefits are alleged to against
Yes,
him.
ma'am. Yes, ma'am.
You are bound to serve notice on him.
ಟ್ರೈ ಮಾಡ್ತೀನಿ ನಾನು ಸರ್ ತೊಗೊಂಡೋಗ್ತೀನಿ. ಅಲ್ಲಿ ತೊಗೊಂಡಿಲ್ಲ ನಾವು
File an affidavit saying that he has not taken.
ಬರಲಿ ಅದು ಹೋಗಿ ಬರ್ತೀನಿ ಸರ್ ಟ್ರೈ ಮಾಡ್ತೀನಿ. ಇಲ್ಲಾಂದ್ರೆ ಇಲ್ಲ.
ನಿಮ್ ಜವಾಬ್ದಾರಿ ಸರ್ ಮಾಡ್ಲೇಬೇಕು. ನೀವ್ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತೀರಿ ನಿಮ್ಮ ಎಂಪ್ಲಾಯಿಗೆ? ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದ್ರು.
ಇವರು ಎಲ್ಲ officer kindly directed to officer to undertake.
That is the direction.
Try ಮಾಡಿ.
Despite the direction
2 weeks
26/2/2020.
ವಕಾಲತ್ ಬಂದಿಲ್ಲ. ನಮ್ಮ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಬ್ಜೆಕ್ಷನ್ 2 weeks.
KDB has not served the copy of the writ petition on the 12th respondent.
Copy not
to be the case worker in the present case. As a last chance, a week's time is granted to
2 weeks.
the managing director of the managing director CEO na ನೀವು. ನಿಮ್ಮ KDB head ಯಾರು? MD na?
Legal advisor.
Managing director head?
CEO
KDB is directed to ensure that the writ petition is served on the 12th respondent. Relist on
5 to 11 ನಾನು ಸರ್ವ್ ಮಾಡಿದ್ವಿ ಸರ್. ಬೇರೆ ತಾವು ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಹೇಳಿದ್ರೆ ನಾನು ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಗೆ ಇದೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ತಂದಿದ್ದಾರೆ ಅವರು.
ಹಾಕಿದಾರಾ?
ಇಲ್ಲ ನನ್ನ ಕೈಲಿದೆ ಈಗ.
ಫೈಲ್ ಮಾಡಿ.
2 weeks ವಕಾಲತ್ ಬಂದಿಲ್ಲ.
Next week.
11th. ಇವಾಗ ಸರ್ವ್ ಮಾಡಿ.
For hearing 11th. For hearing I number 25, Shri Rajesh Shettigar.
For the petitioner's counsel, this is
Yes.
a defendant's application, my lords, which had been filed under order 7 rule 11D. That's been rejected. We have filed this, my lords,
Where
on
is
the
the
ground.
plaint?
Lords, your lordships would get the plaint at page,
Your defend number 7.
yes, my lords, 39, subject to correction, 39, my lords, running page. If your lordship kindly come to the prayers and the cause of action, lords, how the term is at page 79.
You said your defend number 7.
Yes, my lords, it's one branch. My lords, if your lordship comes to 39, my lords, the plaint, running page 39. I am the third defendant there if your lordship gets the plaint.
Right.
H. Jagdish. 39 minutes. Annexure B anta ide.
Yes, by D3, na?
Milots?
Application by D3.
Yes, by D3. That's our D1 to D5, milots, up to D4 are all the family members of one branch.
What is the suit for?
But suit is for the plaintiff claims partition saying that she is the granddaughter of my grandfather and my lords setting aside sale deeds, gift deeds from 2005 onwards. If the prayer, if your lordship sees, please come to the prayer in the suit plaint, my lords, which your lordship should get at page 80 minutes. Running page 80. Please see prayer to declare gift deed dated 25/7/2008. All are these registered documents and the sale deeds where layouts are formed.
But they are consequential, isn't it?
Lords,
They are consequential.
no, our claim is that these are all hit by limitation and she is not even a member. That apart, I can't go into that issue.
This is consequential. If she's entitled, she doesn't have to seek for the second prayer at all.
Yes, if she is entitled to. Our thing is that she was aware of all these transactions. My lords, that's the law which has been laid down, my lords. Otherwise, my lords, please see this, one of the latest judgments which was. And my lords, there are two other judgments, Daib and my lords, which we relied on, which says that, my lords,
Which paragraph? are you referring
lords,
to?
in this, please come to the issues which were framed, my lords, at page 46, running in page 46, para 13, my lords. Two issues, identical issues, my lords.
What was the suit there?
That's also for partition and consequential declaration that sale deeds are to be declared as null and void. Please see para 2 at page 3, my lords. The plaint prayers are called out. In fact, my lords, limitation issue, my lords, in 2020,
No, but as this question been considered as to what should happen to the consequent relief? She's entitled for the first prayer.
yes, but
Then
my
the
lords,
Consequence, she
I
doesn't
know,
have
my
to
lord,
ask
but
for.
this entire thing, our case is, it's a vexatious plaint itself.
It's all right, but
And-
that ground you
and-
can't really
Lord,
reject the plaint.
I would only submit, my lords, this question has been gone into in detail.
You show me in this judgment that a consequential prayer
My
can
lords,
be a ground to reject the plaint itself.
lords, that's the, if your lordship comes to the contentions,
Contentions and finding.
I- findings your lordships would get on issues, my lords, from para. Just take out the para. My lords, running page 47.
Yes. Where have they considered this question as to in a suit for partition? The consequential relief has been sought for.
Yes.
If the main prayer is not illegal
My lords,
or barred by any law.
no, the issue is like, my lord, subject to correction by my lords. If she was aware that there were sales which are happening,
That is on the merits.
no, that's how it's treated.
I have
That
to
you're,
re-
I
have to read
understand.
the plaint on its.
If she is entitled for a share, your lordships are saying those, whether she seeks for declaration or not, she gets. But my lords, her cause of action arises when the sales took place from 2008 itself, she keeps quiet.
If the first prayer independently survives.
My lords, I would,
Question of cause of action arising
17
for a-
point, my lords, please come to para 17 onwards, my lords. The answer to point number 3. Whether in a suit, that's at page 57, running page 57, my lords. Whether in a suit for partition and declarations that certain would the main relief be a declaration of partition? Then at 17.1 onwards, it's considered. Though the plaintiffs have sought for a declaration as a consequential relief in present case, such a relief is not consequential.
See 17.5, it says in the present case. the
No,
suit
no,
having been-
17.1 minutes. Though the
Understood.
plaintiffs have sought for a declaration as a consequential relief in the present case, such a relief is not consequential, but has to precede the decree for partition, since unless a declaration is granted, there would be no property which would be in existence for a partition. Then, my lords, 17.5.
No, I've already taken the view that you don't have to seek for a declaration
No,
in respect of a CLD to which you're not a party.
but that's how this court has dealt with that issue, my lords. The lordships may consider this judgment because I can understand if that was not an issue raised, not answered.
That has not been considered the.
My lords, but then, no, but 17 itself considers the entire thing because those were the contentions raised. Please come to 17.5 also, my lords, at page
I
60.
have a copy of the judgment which I rendered saying that you want to be a party to this deed. To seek for a declaration.
Pardon me.
The judgment that I've rendered saying that you don't have to seek for that prayer at
No,
all.
I don't have that.
I'll have this next week get that.
But till then, at least let the suit proceeding, my lords, otherwise,
This is directly against my judgment. If I disagree, I'll have to refer it, isn't it? Next
because
week.
the other judgment, of course, is on limitation. So on a different aspect, my lords, in 2020, Supreme Court says you have to weed out the,
I have taken the view that partition, she gets a right by birth. Unless she's a party to the document, she doesn't have to challenge it.
very well.
That if I've taken that view, I can't accept this view. Next week.
My lords, I'll just try to scout that, my lords. 11.
Number 26, Shri Naveed Ahmad.
But seeking leave of this court, my lords, to file RP, my lords, because I'm not a party before the London single judge, my lord, before this court. But in
You're not a party.
my right have been affected, my lords. I'm not a party, my lords.
Who are you?
Lords, I am a neighbor, my lords. I'm owner of survey number 112. I'm lords, this court, my lords, kindly see, my lord, the order.
What was the subject matter of the writ petition?
Lords, order of deputy commissioner was under challenge, my lords. Challenging, my lords, the order of the assistant commissioner. Lords, to mutate Khata in favor of the, my lords, the petitioner in the writ petition.
Who are you?
Lords, I am the neighbor to that.
Were you a party in those proceedings?
Not a party. Neither a party in the before the deputy commissioner. Not a party before this court.
So,
I'm going to kindly see the order of this court, my lords, at page number 26, my lords.
20?
26, page number 26, my lords.
Yes.
Lords, paragraph 13. However, in respect of survey number 112, it is stated by the counsel for the petitioner that Subbabayamma so-and-so had entered into compromise along with her children in OS number so-and-so, and as per the compromise, 3 acres that Subbabayamma and her children had purchased has been allotted to so-and-so, the petitioner herein. As a result, the revenue authority shall enter the name of the petitioner in respect of 3 acres of land in survey number 112. And in respect, lords, up to this, lords, I have no objection, lords. Lords, thereafter, in respect of remaining extent of 1 acre 34 guntas of land in survey number 112, the revenue authority shall enter the name of the 5th respondent. Lords, my right is affected here, my lords. I am the owner of this property, my lord.
What was the order of the assistant commissioner?
Lords, assistant commissioner, my lords, only to the extent of lords, 1 acre 34 guntas, my lords.
So you did not challenge the order of the assistant commissioner?
Lord, that is, lords, to the petitioner, not to the 5th respondent. 5th respondent,
An order
lords,
of 1 acre 34 guntas in favor of the 5th respondent.
is not granted, my lords. Nowhere it is granted.
Whether it's granted or not, there is an order of the assistant commissioner in his favor.
Not in favor of the petitioner. That is one Mr. Krishnaji Rao.
The list was between him and the 5th respondent.
And the 5th respondent.
You did not participate in the procedure.
No, there was no dispute at all, my lords.
File a civil suit, not a ground for review.
Lord, they have purchased during the pendency of the suit got dismissed, not declaratory suit.
File a suit. No, I can't review this order.
Lords,
on the basis of a neighbor's complaint.
Lords, permit me to say this, my lords. Lords, without, my lords, the authorities, my lords, recognizing his right, my lord. Lords.
So you should challenge the order, isn't it, of the authorities?
No, this is the only order. No, this is the only order, my lords. He has got, my lords, and he has got mutated RTC, my lords. Other than this, my lords, he has no other right, my lords.
The writ petition arose out of a proceeding under 136.
Yes, my lord. And that proceedings is
in that 136.
only to the extent of 1 acre 34 guntas of the petitioner, not with respect to, my lord, the 5th respondent.
You're not a party to this order, should it not affect your rights? This is a list between the two of them in a 136 proceeding.
Yes, my lord.
If you have a separate grievance about this particular thing, you know what.
Lords, it is not a separate proceedings, my lords. Kindly, my lords, permit me to clarify this, my lords. My lords, nowhere, my lords, respondent number 4 has, my lords, established his right before the authorities. Not, and that was not least before the authorities.
You cannot challenge that unless you are a party to the proceedings, isn't it?
I'm not a party to the proceeding.
Then how can you challenge, how can you seek for review?
Not only because not this order, not the last two lines of this order, my lord, not is affecting my rights, my lord. Not up to, my lord, the right of the
You
petitioner.
have an independent right. This order will not come in your way.
It will not come in the way.
Then go to whatever you want to do. In a list between these two people, I have passed this order in which you are admitted not a party.
Yes, my lord.
So if you have an independent right, you know what to do.
Let's kindly see, my lord.
If you have not been a party in the revenue proceedings, I can't permit you to come and review and question that order.
Lords, without title, my lord, she is getting this order, my lords, lords, kindly see, my lord. Lord, no title, no authorities are
Where
not
is the order
recognized.
where is the original order of the Tahsildar?
Lords, permit me to show, my lords,
Show me the original order of the Tahsildar, which is the cause for all these proceedings.
yes, my lords. My lords, I'll show, my lord, the order of the deputy commissioner first, my lord.
Show me the order of the Tahsildar first.
Yes, my lords. Lords, still the order is not produced in the petition, my lord, therefore I have not produced along in the RP, my lords.
Produce the order.
I will produce, my lord.
Tahsildar, AC and DC.
I will produce it, my lord.
Further, there is an observation by the Samba Court, my lord. It is open to any of the parties if they are so agreed to approach the civil court. Paragraph
Lords,
14.
my lords, permit me to, my lords.
You will honestly get an adverse order by. You are not a party in any of these proceedings.
No, my lords, not at all.
So it does not affect you. If you are an independent right, I'll say you can go for initiate whatever proceedings that you want.
Already it is there, my lord. Paragraph
It
14.
is not in dispute that the review petitioner herein was not a party to the revenue proceedings against which the writ petition was directed. In view of the above, if the petitioner has an independent right, as already observed in the order,
Paragraph
will be
14.
open for the
Page
parties
27.
to approach the civil court. I find no ground to review the petition. Review petition is dismissed.
27, Shri S. Prakash.
Stay is there since 2015.
I'm for. No. It's already is put up final hearing, isn't it? Your Honor, what happened? From 20.
This application, there is a order by this court.
Allah,
that it
early.
should be posted.
It's very difficult for the Olalkere town. It's already taken the compensation error. Simply as prolong the interim order, they have to take an advantage. It's very difficult for the commissioner. One more, already they decided the writ petition.
The lordship may have it next week, my lord, any day.
They already decided. The court has to be decided in the year of 2014.
It is not covered by.
Covered by. It's already is covered by same notification.
In prayer,
Same notification.
I
has
have
covered-
challenged, my lord, the notification.
Same
Requiring,
covered-
my lord, on several grounds, on limitation and also, my lord, on the ground that they have not provided, my lord, the,
2010 notification.
yes,
Please.
no, immediate, immediate. But other connected matters, my lord, which were
No.
later on connected or dismissed on the ground of delay, latches on the part of the petitioner.
ನಿಮ್ದು 2011, 2014 ಅಲ್ಲಿ challenge ಮಾಡಿದ್ರಲ್ಲ.
ಅಲ್ಲ, our writ petition, this was not, my lord, covered by that.
ನೀವು ಹಾಕಿರೋದು 2014 ಅಲ್ಲಿ.
ಹೌದು.
Challenges to notification of the year 2011.
Yes.
ಹೌದು.
3 ವರ್ಷ ಆಯ್ತಲ್ಲ.
No, my lord, it is not like that. I will argue 2012, my lord. He published in the newspaper on 8/2/2012.
2 ವರ್ಷ ಆಯ್ತಲ್ಲ.
ಆಗ್ಬೋದು.
What is your ground?
ಅಲ್ಲ, ಇವತ್ತು ರೆಡಿ ಇಲ್ಲ ನಾನು.
ಅಲ್ಲ, once. One submission. Yes, ಅಲ್ಲ, one submission. Last thrice or fourth.
10 ವರ್ಷ ಕಾದಿದ್ರೆ ಇನ್ನೊಂದು ವಾರದಲ್ಲಿ ಏನಾಗತ್ತೆ ನಿಮ್ಗೆ?
ಅಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ 13 ಅಲ್ಲ, 23 ಅಲ್ಲಿ.
ಅಲ್ಲ, ತಗೊಳ್ತಾನೆ ಇದಾರೆ ಸ್ವಾಮಿ. Some other reasons ಹೇಳ್ತಾನೆ ಇದಾರೆ. Last time ಅದೇ ಹೇಳಿದ್ರು. Some. Last and finally, please. Sorry. A copy. Date maybe next week, 11th. Much over.
Syllabus 28, Shri Somsekhar Naidu B.
Yes, my lord, I pay for the respondent. By oversight, I have not filed the objection. A date may be fixed, by that time I will get this.
Only early hearing application, my lord. And this was the earlier.
ಆಗಿದೆಯಾ? ಆಗಿದೆಯಾ? Post in B group 1.
Please,
Earlier
meanwhile I'll get it.
It was disposed of on merits by writ orders. It was not being complied. It is arised out of acquisition proceedings by the KIDB. Compensation.
Have it in B group. I'll have it in B group.
19.
Please.
Obliged.
Number 29, M. Srinivas.
Back to upper for the petitioner. My lord, seeking for my lord the mandamus, directing the special land acquisition officer, my lord, to deposit the amount before the civil court. 2010, my lord, it was acquired for a metro station, 1 acre, 38
Beneficiary, my lord,
acres.
the respondent 2 and 3 beneficiary. We have deposited the
No, I am
compensation
seeking
before the
against the LAO.
compensation before the.
Argument ಮಾಡಕ್ ಬಿಡಿ ನೀವು argument ಮಾಡಕ್.
ಅವ್ರು ಮೆಟ್ರೋ ಸ್ಟೇಷನ್ ಅವರು ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. LAO ಮೇಲೆ ಕೇಳ್ತಾ ಇರೋದು ನಾನು.
Data instruction that they have.
2010, my lord, the award was passed, then it was approved by the government. My lord, of course, it is internal family dispute, my lord, among the members of the family, but they have not deposited the amount.
OPS or KDB.
No, it is the acquisition by the
KDB.
state government.
LAO.
Fourth
2008 preliminary notification.
Acquisition.
State government acquisition.
ಏನಕ್ಕೆ?
Metro rail.
Metro station, Benninganalli. Metro station.
KDB ಮಾಡ್ಲಿಲ್ವಾ?
ಅಲ್ಲ ಇದು ಫಸ್ಟ್ ಇದು ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಇಂದ ಮಾಡಿದ್ದೆ.
2008 my lord, state government, 2012 onwards KDB.
No, for the past 14 years, compensation is not deposited.
I'll ascertain whether they have.
But the Supreme Court, my lord, say there is a delay of 14 years present case and also another case, my lord, the same matter.
ಮೆಟ್ರೋ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಈಗ ಅಲ್ಲಿ.
ಹೌದು ನಾವು ಅಲ್ಲ ನಾವು ಕಾಂಪನ್ಸೇಷನ್ 2008 ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೆ.
Already award dispersed about.
Metro has deposited the amount with the KDB ಇದು special land acquisition.
Is it not referred then?
File. Not with the file, my lord. File has not put a file ascertain.
2022 Supreme Court judgment, my lord, says they have to liable to pay the penalty also 3%.
Let's keep the land acquisition officer present.
I'll ascertain.
Number 30, Rahul Kariappa.
The suit for injunction, my lord, filed by the appellate itself in the trial court, impeached by the order dated
Suit for injunction.
27/3/2015.
You can see Waqf board. Please read from para 10. Para 10.
Para 10. The petitioner has learned that the respondent number 1 passed by
Para 10 of the trial court judgment.
trial court judgment. It is an admitted fact that the defendant number 1 has filed OS number 1415 of 80 for the relief of declaration and injunction, and the said suit came to be decreed and disposed of on 31/1982. Advocate for defendant 1 argued that as the Masjid Committee has attempted to interfere in the peaceful management of Dargah Arifullah Qadri, Nilasandra, defendant number 1 has filed OS number 342 of 76, restraining them from the peaceful activity of Sandal and Urus of said Dargah before the City Civil Court, Bengaluru. And the Honorable City Court has allowed the interim application, which has been challenged in RFA number 160 of 76. Further, he argued that the order of the IA passed by the City Civil Court was set aside by the Honorable High Court of Karnataka, and the said OS number 342 of 76 was renumbered and as 1415 of 1980, and the judgment and decree in OS number 1415 of 1980 is marked as Exhibit D3. As I mentioned above, OS number 1415 was filed by the first defendant for the permanent injunction restraining the present plaintiff from performing sandal and urus, and also holding any of its connected activity, and also for declaration that he is entitled to manage the Dargah of Hazrat Baba Mian Arifullah Shah Qadri, situated within the compound of Neelasandra Eidgah and Graveyard, Neelasandra, and also to restrain the present plaintiff from breaking up the two platforms from where the religious lectures are delivered. The said suit was decreed as prayed for. Advocate for the defendant number 5 argued in view of the approved scheme of management dated 9/3/1988 in KTW. The scheduled properties are attached to the plaintiff institution. It is true that as per the approved scheme of management, earlier notification dated 7/6/1965 does not hold good, but the defendant number 1 has contended that he has challenged the approved scheme of management dated 9/3/88 in OS number 4 of 2004, which came to be dismissed for non-compliance of the mandatory notice.
So you have suffered a decree in this OS 1415/80.
Yes, my lord. That was filed by.
How can you file a separate suit for injunction afterwards?
My lord, that is because the defendant number 1 was performing the urus only for the 3 days, my lord.
Correct,
That is
but
the separate.
rightly or wrongly, the trial court has decreed that suit.
Yes, my lord.
You have not challenged that decree. How can you file a separate suit?
I may be given a week, my lord. I'll get proper instruction again.
For
from
what?
senior. I'll.
How can you get over the decree? OS 1415
regarding
was
the-
filed by defendant number 1 against you.
Yes.
He has succeeded.
Yes.
You have not challenged it.
that-
How can you file one more suit for injunction against him afterwards?
This is regarding only the property of the graveyard and the religious, that where the lectures were being delivered. Whereas now, this suit, where the dismissed suit, it was for complete mosque property.
Where is your plaint?
It is in page number 49, my lord. I'm praying for their interference with the management and supervision and administration, my lord. That suit was only with respect to the conduct of urus, wherein here I have sought a prayer for management, supervision and administration by the plaintiff.
You can't.
Lord, what has happened in this case is exactly through that suit or that decree, they're claiming entire power over the property. They're coming to supersede the power of the mosque itself.
Where is the decree passed in OS 1415 of 1980?
That is not attached
Exhibit
here in this. It
P3.
is there in
Mark.
Exhibit D3, ala? 3 in the trial court it is.
What happened to the other suit, OS 5/2004? That you
That's
have
pending,
filed?
your lordship. That's pending for consideration.
No,
But clear admissions are there, lordship. In this
Even
suit
after
itself,
20
the
even after-
suit for, please,
Even after 20 years, it is pending consideration?
one more suit that is there in the page number 38 of the judgment.
It's still pending.
That is according to judgment. After dismissal of the
Judgment
suit in.
ನೀವ್ ಹೇಳಿ ನೀವ್ ತಾನೇ ಹಾಕಿರೋ ದಾವಾ ಅದು.
ಅಲ್ಲ, ನಾವು defendant. We are for defendants.
No, you have filed that suit, OS 5/2004, challenging the
Earlier suit.
decision of the management committee.
That is pending.
20 ವರ್ಷ ಅದು.
ಇದರಲ್ಲಿ ಹೇಳಿದ ಇದ್ದಾರೆ. But here in this permanent suit for permanent injunction, there is a clear admission, lordship. You further proceed ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ. Page number 16 ಅಲ್ಲಿ. Clear admissions with regard to the enjoyment of the property by the defendants, lordship. May I read the relevant part, lordship? In the cross examination.
ಕಾಪಿ ಇದೆಯಾ, ಜಜ್ಮೆಂಟ್ ಕಾಪಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? OS 1415.
ಹಳೆಯದು.
It's 9 of 2010. OS 9.
OS 9?
Nine.
9 ಇಲ್ಲ.
10. Para number 10 ನಲ್ಲಿ further proceed ಮಾಡ್ತಾರೆ ಎಲ್ಲ admissions ಇದೆ sir. Attends. May read it. Relevant portion.
Lord, this, in that case, the prayer was very limited to the performance of.
There is a decree.
That decree copy is not there here with me, my lord.
What can I do?
No, I'll produce the document. I'll bring
No.
the document to the light of.
You should have got it.
No, I
The
have.
2015
Yes,
revision.
I understand, my lord.
I'll read a relevant portion of the findings.
You want to say anything else?
No, my lord. That case itself was very limited to the performance of gurus and their religious activities, my lord. Wherein this suit, we have filed an injunction from restraining them from interfering with the management and getting involved in the managerial activities or administration of the mosque itself, my lord. That was only with respect to the only performance of religious activities, wherein this was a whole suit and a larger suit, wherein we have asked for the prayer of not interfering with the administration of the mosque activities.
The petitioner had instituted a suit seeking for a decree of permanent injunction to restrain defendants 1 to 4 from interfering with the day-to-day management, supervision, and administration of the plain scheduled property. A decree of injunction was also sought to restrain them from demolishing the graveyards and from putting up any structure around the plain scheduled property. Next, the trial court, the tribunal has recorded a finding that the first defendant had instituted a suit in OS 1415/1980 for relief of declaration and for injunction against the present plaintiff. And the said suit, in fact, came to be decreed on 31/82. It is observed by the trial court that in view of the decree passed in OS 1415/1980, the plaintiff would not be entitled to re-agitate the entire matter by filing a fresh suit. The trial court has also taken note of the fact that the plaintiff himself admitted that defendants 1 and 2 were celebrating the Urus and conducting sandal peacefully. Sandal antane word. And in this view of the matter, there was no justification to entertain the suit for injunction. Next part. If it is not in dispute that the earlier suit filed by the first defendant in OS 1415/80 had ended in a decree in favor of the first defendant, and if it is admitted by the plaintiff that defendants 1 and 2 were celebrating the Urus and sandal peacefully, the suit for injunction filed by them cannot be entertained. The trial court has therefore rightly come to the conclusion that there was no merit in the suit and it has accordingly dismissed the same. I find no reason to interfere with the well-reasoned order of the trial court. Revision is therefore dismissed.
Bill number 31, Shri Prakash MH. Please.
This may kindly be called on next Monday, next week. Of course, stay order is there in his favor. List next.
Monday, my lords. 11th, please. Great. See number 32. Supreet, yes. Wait, please.
My lord, the petitioner is due 4,20,000 towards the arrears of rent.
What is the suit for?
Last ejectment and for arrears of rent. At the time of filing this suit, it was 88,000 due. Now it is 4 lakhs and odd. Because miscellaneous was filed by him for setting aside the ex parte order. The miscellaneous was allowed on payment of rupees 2,500 costs. Even that is not deposited. That is what the observation of the court.
This
also.
revision is directed against which order?
My lord?
This revision is against the order passed in
You see,
the small cause suit.
small cause case, my lord. Ejectment suit. All that I request to the court is let him deposit the arrears of rent.
Let us see if we can make out a case first. Yes,
Page number 18 is the impugned order.
you're challenging the decree passed in
SC 920 of 2017.
you were different number.
I was not arrayed as a defendant. The petitioner was not arrayed as a defendant.
It is shown as D3, Pushpanjali.
ಹೌದು ಅವ್ರು ತೋರಿಸಿದ್ದಾರೆ ಬಟ್ ಒರಿಜಿನಲಿ ದೇ ವರ್ ಪ್ಲೇಸ್ಡ್ ಎಕ್ಸ್ ಪಾರ್ಟಿ
And so you were made a party. You chose to remain absent.
it was stage managed, but be that as it may, summons was not served. And therefore they obtained an ex parte order of eviction. Now, the ground is that there is no relationship of landlord and tenant. Now, this petitioner who filed the petition for ejectment came to the, to be the owner of the premises subsequently because originally I was inducted under a trust, a charitable trust inducted me as a tenant. That is my father. Now subsequently, of course, without the court's permission or otherwise under the Trust Act, they seems to have obtained a sale deed. And based on the sale deed, earlier also the trust has issued a notice to me. That was replied subsequently. The sale deed came to be executed.
On you becoming aware of this ex parte decree.
Please, I filed a miscellaneous under 9 Rule 13.
What happened to that?
That was allowed.
Allowed.
That was allowed.
And then after.
That was allowed and the suit was restored and parties were directed to appear on 21/3/2022, page number 17 of my petition.
23/5 alva.
23/5.
23/5/2020.
23/5/2022.
What happened thereafter?
The
Then
court
then why have you challenged this decree?
ಅಲ್ಲ
As to nine-
ಅದೇನಾಯ್ತು ಅಂತಂದ್ರೆ page number 19 on 4/7/2022.
What is your prayer, Supreet?
The prayer is
challenging
to
the order.
provide me an opportunity to contest the suit and establish my case before the small connects.
Your miscellaneous petition was allowed.
Please.
So the ex parte decree that was passed, when was the ex parte decree passed in the first occasion? 23/10/17.
Please.
That was set aside.
That was set aside.
And you were asked to appear
Yes.
on 23/5/2022.
Yes.
Did you choose to appear?
Now, both the parties did not appear because the file did not come that day.
I am talking about you.
Please,
Your petition was
he did
allowed.
not appear on that day. On 4/7/2022, it was adjourned to 4/7/2022. On 4/7/2022, the file of course came late. Initially the court ordered that, we did not appear, there was no representation from our end and confirmed the judgment that was passed earlier. That is the order that has been passed.
So you, after getting an order, you chose not to do anything.
Subsequently, we appeared on the same day itself.
Where is the order?
Page number 18.
The written statement of defendant is taken as not filed.
The order,
judge-
the order was there, specific that both of you should appear, isn't it?
Both of us
So-
could appear.
You did not appear on that day.
On 21/3/2022, I did not appear.
No,
On
23/5.
4/7/22, I appeared.
Come to page 25, page 41, sorry. It says you should appear
ಹೌದೌದು.
on 23/5/2022.
ಹೌದೌದು. ಅವತ್ತಿನ ದಿವಸ ಜಡ್ಜ್ ಇರ್ಲಿಲ್ಲ, ಕೇಸ್ ವಾಸ್ ಟ್ರಾನ್ಸ್ಫರ್ಡ್. On
ಏನ್ order ಓದಿ?
23/5/2022,
ಓದಿ ಅದು.
PO was on training, therefore it was urgent.
ಅಲ್ಲ, case taken on board in view of the order of this court Muslim number so and so. The court, the counsel for defendant number
Counsel for defendant
appeared.
Defendant appeared and petitioner absent, no representation. Appearance of both parties as per the
So
order.
you appeared on 23/5/2022.
Yes, before the
Then what
in-charge
happened?
court. And then it was urgent to 4/7/2022. ಅಲ್ಲೇ to file return statement finally by 13/7 ಅಂತ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರು. ಮೇಲ್ಗಡೆ
ಇನ್ನು ಒಂದೇ ದಿನದಲ್ಲಿ ಮಾಡಿದಾರಲ್ಲ.
ಒಂದೇ ದಿವಸದಲ್ಲಿ ಮಾಡ್ರು. ಅಲ್ಲ, ಆಕ್ಚುಲಿ ಫಸ್ಟ್ ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರು.
Kindly see the order, my lord, that one day order. Kindly see.
4/7/2022 is
Yes.
adjourned.
What,
On
what
that,
the-
on that day itself.
what the court has said is, he has not complied with the order. Kindly see, no representation by the
ಇಲ್ಲ,
defendant.
ನಾವು
On
ಬೆಳಿಗ್ಗೆ
going to the
representation
case
ಮಾಡಿದ್ವಿ.
file, it is found that after passing the ex parte judgment and the defendant had preferred the miscellaneous petition 1 of 18, wherein it was ordered to set aside the judgment and decree by imposing cost of rupees 2,500. And the defendant was permitted to contest the case. In spite of giving sufficient opportunities, the defendant did not choose to file the written statement and also not pay the cost. And the written statement of the defendant is taken as not filed. The judgment and award which is already passed by this court is confirmed. Hence,
ಮಾಡಕ್ ಬರುತ್ತಾ? ಮಾಡಕ್ ಬರುತ್ತಾ? ಒಂದ್ಸಲ ಡಿಗ್ರಿ ಸೆಟ್ ಸೆಟ್ ತಿರ್ಗಾ ಅದನ್ನ ಕನ್ಫರ್ಮ್ ಮಾಡಕ್ಕಾಗತ್ತಾ?
because no further evidence is related.
ಇಲ್ಲ, ಬಟ್ on that very day, a mention is also made.
Later order, later counsel for the defendant appeared and praised time to file written statement. The defendant is not diligent in prosecuting the case. Since the written statement of the defendant is already taken as not filed and the matter is also closed, the submission made by counsel for the defendant is not considered.
ಒಂದೇ ದಿನದಲ್ಲಿ.
Huh?
ಒಂದೇ ದಿನದಲ್ಲಿ.
ಒಂದೇ ದಿವಸದಲ್ಲಿ.
Instantaneous justice.
My submission to my lord is in any eviction case, the first duty is to deposit the rent.
No, are they admitting the relationship?
My lord?
Are they admitting the jural relationship?
Yes, they don't admit it. They say they are under the mortgage.
I'll set aside this order and ask the trial court to give him a chance to file his written statement and then make an application, whatever you want to do there.
My lord, from 2015, I am fighting, not one
No,
or
but,
2 days.
You could have graciously allowed this application and asked him to file a written statement.
All that could have been done. But what is not done is I am representing before the court. My submission to my lord is from 2015.
You are a tenant of whom?
No, he says
The Public
mortgage.
Charitable Trust.
So
Mortgage ಅದು.
are you paying rents to them?
ಇಲ್ಲ, ಭೋಗ್ಯ.
Registered mortgage.
ಇಲ್ಲ, registered ಭೋಗ್ಯ ಅಲ್ಲ, unregistered ಭೋಗ್ಯ. But nevertheless,
basically,
there is a receipt indicating the fact that
you're basically squatting on the property free.
ಇಲ್ಲ 10 ಲಕ್ಷ
Where is the property?
Properties in Chamarajpet.
Out of 3 properties, my lord, I have
Can
taken.
deposit whatever is the reasonable rent, start depositing into court. I'll
Reasonable rent ಅದ determination ಆಗಿಲ್ಲ.
now, whatever both of you agree, I'll direct you to start depositing in the court and also deposit the arrears.
ಅಲ್ಲ, there is, the relationship is not admitted at all.
You will never admit, but you can't squat on the property free. There's no registered mortgage deed.
There is no, technically, there is no registered usufructory mortgage. But
Technically,
nevertheless, 2001, I have paid, there is a receipt. I will be able to establish before the trial court of the receipt and other things.
You'll become a mortgage on the basis of receipt.
On the receipt of consideration for having allowed me to stay in that property.
How can you?
Now, in fact, I approached my friend. I told him that let the money be given back. Now, ಒಂದು 6 ತಿಂಗಳು ಟೈಮ್ ಕೊಟ್ಟರೆ ಖಾಲಿ ಮಾಡ್ತೀನಿ ಅಂತಾನು ಹೇಳಿದೆ. but of course some
ನೀವು 10 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ರೆ ಚೆಕ್ ಅಲ್ಲಿ ಕೊಟ್ರಾ?
ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಷ್ಟಂತ ರಸೀಟ್ ಇದೆ.
ಇಲ್ಲ ರಸೀತಿ ನೀವು 10 ಲಕ್ಷ ಕೊಡ್ಬೇಕಂದ್ರೆ ನೀವು ತುಂಬಾ ದೊಡ್ಡ ಮನುಷ್ಯನಾಗಿರ್ಬೇಕಲ್ವಾ? ಅದೇನ್ ಕ್ಯಾಶ್ ಕೊಟ್ರಾ ಚೆಕ್ ಕೊಟ್ರಾ? ಚೆಕ್ ಕೊಟ್ಟಿದ್ರೆ ಯಾರಿಗೆ ಅಂತ ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ. ಸುಮ್ನೆ 10 ಲಕ್ಷ ಇದೆ ಒಂದು ರಸೀದಿ ನಂತರ ಇದೆ ಅಂತಂದ್ರೆ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ಅ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಪರ್ಟಿ.
ಇಲ್ಲ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಹೌಸ್.
And how can you sit on somebody's property?
Residential house of only ground floor. Of course, it was given by my father, 2nd June 2001.
In fact, my lord, only one of the LRs is contesting. Now 3 LRs for the parties tenants. In we filed the case earlier.
Looks like Supreet's client wants some money from you to
ಇಲ್ಲ
extract some
ಆಗಲ್ಲ,
money and-
ಅವ್ರ ಪ್ರಕಾರ ಅವ್ರು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರೆ.
Correct. ಏನಿಲ್ವಲ್ಲ
born out of- there is a
ನಿಮ್ ತಂದೆ ಇಂಡಕ್ಟ್ ಆಗಿದ್ರೆ ನೀವ್ಯಾಕೆ 10 ಲಕ್ಷ ಕೊಡ್ತೀರಾ?
ಅಲ್ಲ ನಮ್ ತಂದೆನೆ ಕೊಟ್ಟಿರೋದು.
ಅದೇ ಯಾವ್ದು ಏನ್ ಕೊಟ್ರು? ಕ್ಯಾಶ್ ಕೊಟ್ರಾ ಚೆಕ್ ಕೊಟ್ರಾ ಯಾವಾಗ ಕೊಟ್ರು ಯಾರು ಕೊಟ್ರು?
ಅದಿದ್ರಲ್ಲಿ ಏನು ಹೇಳಿಲ್ಲ, but they have given a receipt saying that money has been received.
You can't squat on the property. Admittedly, it's not your property and you're not claiming title on that property.
No, we are not. We are not claiming any independent right as such.
They are not even replied to the legal notice
Of
of
course we have.
committees of tenancy,
Of
my
course
lord.
we have given
What is
a-
your stand then?
What, we have given a detailed reply.
What is your stand?
Earlier, the one Mr. Lakshmikant Gupta, that is the vendor.
What is your stand? What is your status in the reply? Do you admit that you're a tenant or a mortgagee? What is your stand?
So far as his client is concerned, we said you don't acquire the title, but nevertheless, we come under the
Answer my question.
charities.
What is your status?
Yes, the status stand is that we are the mortgagee. We have paid the money.
So you cannot recover that mortgage money because there's no registered mortgage deed.
Adana, I think my respectful submission is, I think we'll be able to place it before the trial court if an opportunity is provided.
You can't squat on somebody's property for all time to come.
Now, let there be, if that is the case, I think it is open for my friend before the trial court to seek for determination of the rent also. There is no difficulty.
It's open for me to pass an equitable order so that
I do understand. But so far as what would be, so far as economic repercussions are concerned, I think I will.
you have no right to sit on somebody's property forever. You are there since how many years?
2001.
The litigation started in 2017. You are there for 7 years now. I'm not going into the past. For 7 years, you're squatting on the property free.
ಅದು ಆ ಮುಂಗಡ ಹಣನು ವಾಪಸ್ ಬರಲ್ಲ ನಮ್ಗೆ.
ಅಲ್ಲ ನೀವು ಬರಲ್ಲ ಯಾಕಂದ್ರೆ ನಿಮ್ಗೆ ಇಲ್ಲ ದಾಖಲಾತಿ ಇಲ್ವಲ್ಲ.
ದಾಖಲಾತಿ ಇದೆ.
ಕೊಟ್ಟಿಲ್ಲ ನಿಮ್ ತಂದೆ ಕೊಟ್ಟಿರ್ತಾನೆ.
ಅಲ್ಲ ಅದು ದಾಖಲಾತಿ ಇದೆ. That original receipt is available.
That basis can you see sue for recovery?
We will at least call upon the vendor to acknowledge that particular document. In fact, we have said so.
ಎಷ್ಟು ಬಾಡಿಗೆ ಕೊಡ್ತೀರಾ ಯಾವಾಗ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ I'll set aside this order and send it back.
And I will continue to ask my client and I will come back tomorrow. So far as that is concerned. Day after tomorrow?
Day after tomorrow. Please. ಎಷ್ಟು ಬಾಡಿಗೆ ರೀಸನಬಲ್ ಬಾಡಿಗೆ ಹೇಳಿ ನೀವು.
Please, madam.
ರೀಸನಬಲ್ ಬಾಡಿಗೆ ಹೇಳಿ.
ಅಲ್ಲ ನಾವು ಕೇಳಿದ್ದು 4,000 ಬೇರೆ ಟೆನೆಂಟ್ಸ್ ಅಷ್ಟೇ ಕೊಡ್ತಾ ಇದ್ರು, ಎಲ್ಲರೂ ಖಾಲಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದು ಒಂದಕ್ಕೋಸ್ಕರ ನಾವು ಐ ಆಮ್ ನಾಟ್ ಏಬಲ್ ಟು ಇಂಫಾರ್ಮ್. 4,000.
So 48,000 into 8 years. Deposit that money, then let us see something.
With great respect, they feel that, it may be unreasonable because they've already paid 10 lakhs.
There is no proof. If you had given it by check, I would have straight away accepted your submission.
I'll find out how it has been.
You don't know what your father has done.
I do not know. I have to ask my client
I
about.
told you 4,000 into 12 into
80, almost 8 years, madam.
ಅದ್ ಮಾಡಿದ್ರೆ you'll get some order.
I'll find out.
ಅಂದ್ರೆ dismissal.
I will find out from my client.
Day after tomorrow.
6. Please.
Number 33, Shri Rupesh Kumar S.
Favor the exponent. Suit for partition. File application under order 7 to 11A and D.
Where's the plaint?
Plaint is at paragraph page number 21.
Your different number?
Defendants.
Ibro.
Sorry for the intrusion. Remark may kindly be extended till next.
Remark till then.
Paragraph numbers 5 and 6, my lord, are the important paragraphs. Paragraph number 5 and 6 of the plaint at page 22.
The plaintiff submitted that plaintiffs and defendants are members of the Hindu undivided joint family. The plaintiff and defendants have acquired the suit schedule properties by inheritance, and they being joint peaceful possession and enjoyment of the suit schedule properties. The suit schedule properties are not partitioned till the date. Paragraph 56. The plaintiff submit that suit schedule properties original belongs to one B. N. Ramaya. The said properties are self-acquired properties of the said B. N. Ramaya. After the
You sold it to your own son.
no. After his death, all the properties came to be mutated in my name.
Your
Different number.
Rajgopal.
Rajgopal, yes.
See, you sold the property to your son Raghavendra.
By gift deed.
22/9/2020.
By gift deed. By way of gift, I have given it. So
If the property is a self-acquired property of B. N. Ramaya.
Yes.
Will she not get an equal share?
Yes, ma'am. But the further reading of the same paragraph says, acquired properties of the said B. N. after the demise of B. N. Ramaya, his son R. Rajgopal, who is defendant number 1, have got the Khata and Pani in respect of the scheduled properties by way of Pavati Barsawide mutation proceedings number so and so in the year 2006 and 7 by dated 2011-2006. And he is the Karta of the joint family, and he has maintained the affairs of the joint family, and all the revenue documents were stated in the name of the first defendant. So all these revenue documents stood in the name of the first defendant way back in the year 2006. So the defendants, my lord, plaintiffs, my lord, who say that they are in joint possession and enjoy.
Whether they're in joint possession or not, the moment the father died,
Yes, ma'am.
they acquired 1/3 share.
Yes, ma'am.
How can you deny them that
My
share?
lord, it is not, the question is, my lord, they were aware of this, my lord, the
So
reading
that-
of the Khata.
On that ground, can I reject the plaint that they were aware?
And no, my question is, my lord, the other cause of action, my lord, they were supposed to approach the trial court, my lord, within 3 years from the date of
Why?
that change of Khata, my lord.
Why?
Because it is,
So Khata confers state law on you?
yes, ma'am, that is the main deed, my lord.
Shtana?
Khata and RTC. The cause of action arose during 2006 itself, my lord, since they say that they were in joint possession and enjoyment. And their name was never there in the RTC and mutation, my lord, after the death of the
They are your
B. N.
sister, they are
Ramaya.
your sisters, alwa?
Yes, yes.
Anything else?
My lord, the cause of action, my lord, shown is that at paragraph number 10, my lord.
Cause of action mentioned, there is not the cause of action. Cause of action is those bundle of facts which the plaintiff has to prove in order to get a decree. If
Yes.
she is able to prove that the property was the self-acquired property of the father, and on his death, she has 1/3 share, that's it. Whether the Khata is in your name, whether you execute a gift deed, it's of no consequence. Gift will be valued only to the extent of your share.
Yes, ma'am. But the entire properties were mutated in my name in the year 2006 itself, ma'am. And even they were aware of that because it is their admission, ma'am.
All right.
However, my lord, they have not challenged the mutation entries and the RTC entries also, my lord, within 3 years, although they were aware of it.
One minute. The sisters of the first petitioner, Srimati Ratnamma and Varalakshmamma, instituted a suit seeking for partition of the suit properties. It was their contention that the suit properties belonged to their father B. N. Ramaya and were his self-acquired properties. And after his demise, they had acquired a share in the said properties. Next, it is a further case that after the demise of their father, the first petitioner got the revenue entries changed in his favor, and thereafter proceeded to execute a gift deed in favor of his son, the second defendant. And the same was not binding on them. Next, on the suit being instituted, an application was filed by the defendants seeking to reject the plaint. The said application has been rejected by the trial court, and hence this revision. Learned counsel for the petitioners contend that the plaintiffs were aware of the mutation which was effected in the year 2006 and 7, and yet the suit was filed only in the year 2022, and this was clearly barred by time. In my view, this cannot be a ground to reject the plaint. A mere change of Khata in the year 2006/2007 will not be the starting point for limitation in a suit for partition. The suit for partition is based on the premise that the plaintiffs acquired a share in the suit properties on the death of their father, and they seek to partition the property and get their share determined. In my view, there's absolutely no ground to entertain this revision, and the order of the trial court on rejecting the plaint is just and proper. Revision is therefore dismissed.
Say number 34, Srimati Vinita PC.
Lord, it's on 7 to 11 application. Your lordships have heard last time. Lord, I have obtained a specific performance decree in my favor.
I forgot the facts. Can you tell me again?
My lord, you see, I have entered into an agreement to purchase the property, and I have filed a suit for the specific performance. That was decreed in my favor. And the respondent, my lord, you see, he has filed a suit. Kindly see, my lord, page 92, the prayer.
Page
92.
Yes.
Direct the defendant one to quit and vacate and hand over the vacant possession of the Schedule 3 property to the plaintiff.
You said he has preferred an appeal against that order, isn't it?
But specific performance, so that is pending. On the face of that, this also suit cannot be decreed. Is a decree. Put me in possession of the property. I am in possession. I have constructed the house. I have let out.
Maybe, like I said, section 10 application may be appropriate, but how can you ask for rejection of the plaint?
Respectfully agree with your lordship's view. Kindly observe it and my lord this also.
The
Section 10 application.
respondent preferred a suit, institute a suit for ejectment of the petitioner herein. Petitioners alva? Petitioners herein. Contending that he was the owner of the property and was entitled for possession. In the said suit, an application was filed to reject the plaint, contending that the defendants had instituted a suit for specific performance in OS
3145.
OS
3145. OS number.
3145. 3145 of 2020 in respect of the very same property, and had secured a decree which was pending consideration in RFA 1135 by 2022. It was considered since the defendants had secured a decree of specific performance, the suit filed for ejecting them could not be entertained and the plaint deserved to be rejected. This argument has not found favor with the trial court, and the trial court has rejected the said application, and hence this revision. From the facts narrated above, it is clear that in the event the appeal filed by the defendants challenging the decree of specific performance is granted, the petitioner would stand reverted as a person in possession of the property, and in such an event, the suit for ejectment cannot be said to be not maintainable. In this view of the matter, the trial court was justified in rejecting the application that had been filed to reject the plaint. Consequently, I find no grounds to interfere in the impugned order. However, it is open to the petitioner to make an appropriate application to stay the proceedings in this suit if it is found that the said suit has been instituted subsequent to the filing of the suit for specific performance.
Section 10, your lordship.
Stay and stay under section 10 number.
For hearing B group, seal number 35. Fatima.
Respondent 3 in this matter.
Yes.
The petitioner has shared minutes. I just take my lordship to the facts. 2018-9 total extent of the land the petitioner owns is 33 guntas. Out of the 33 guntas, in the year 18-9, the state government had issued notification under section 4. Then final notification also was issued. Possession was never taken. The possession always was there with the petitioner itself. And thereafter, in 2005, what happened is the BDA issued preliminary notification only, with respect to that's first. Then again in 2009, they issued preliminary notification again with respect to 20 guntas. So total 30 guntas out of 33 guntas. No final notification was issued. This was for the formation of outer ring road, Agadi Road Junction. So they formed the road without even passing a final notification. That the assurance given to the petitioner was they had given compensation for 10 structures. So 22 lakhs and odd was given to the petitioner only with respect to the shed in 10 guntas initially. With respect to the land, there was a resolution by the BDA saying that 75% of the total extent they will give an alternative land. So they gave it to the other my neighboring adjoining neighbors, they have given to them. When it comes to me, they had not given. So I had being aggrieved by the action, I filed a writ petition before the.
Where's that resolution?
It is at
Copy ತೆಗೀರಿ.
That's it.
That prayer was given up by the.
No, I will still respect to that. Thereafter, but I'll show thereafter what happened, this.
No, from what you have told me, there was a declaration that there was only a preliminary notification.
Please.
Under section 17, no declaration.
No.
And yet you had given up the lands.
Please, because there was a resolution, saying that alternative lands will be given. Assurance was given as well as they had given us the compensation for the structures initially. Only for the sheds what we had. What happened?
Is there a resolution passed in your favor specifically?
With respect to, yes, my name is also there. It is at page 95 on Ejectment.
Where is the resolution?
Annexure 95, page 95.
95 is the second page of the communication dated 11/2/2014.
This is that, my lordship may kindly see the writ petition 30381 of 2018, not 14. Has all the annexures. There are two matters.
What is annexure A here? Read annexure A, page 33. Same petitioners?
Please, annexure A, is the endorsement issued during the contempt proceedings. And they said that we are entitled only for they've utilized only 16 point. And we are entitled for 4 crores and 94,060. Check was given to us.
Done by the road. Bridge. What is necessary there?
They afford to pay you 4 crores.
These, during the millers, we are agreed saying that 30 guntas they've taken. Their own report, my lordship might see at page 184. It's a joint inspection report. Each place, my lords, before this honorable court, before each court, they've made different endorsement has been given, my lords. First, they say before the division bench that they'll be giving about 7 crores. They issue an endorsement again, that is at page 180, my lords. They've utilized 16 guntas, 16.72 guntas, and they will give 7 crores, 72 lakhs and 1,920 rupees at page 180.
What exactly are the facts, Sachin? Because you.
That's I'll assist me.
Because this annexure indicates that whatever they said is true because you agreed to pay them 4 crores.
No, 4 crores is paid.
I'll assist.
It's paid.
Now, if you have paid 4 crores, that means you also admit that you've taken possession of this 30 guntas of land.
No, that is a problem here. My lord's total extent is 30 guntas of land.
What is the survey number?
My lord, survey number
Bar 7.
57/7.
Of Srigandha.
My lords, out of 30 guntas of land, my
The
lords.
total extent of this is 30 guntas.
33 guntas. 33.
Then
ಅದರಲ್ಲಿ 30 ಗುಂಟೆಯಲ್ಲಿ 11 guntas of land.
33 ಗುಂಟೆಯಲ್ಲಿ 30 ಗುಂಟೆ ಏನು?
30 guntas out of 30 guntas. 3 guntas, there is no problem. They are not claiming any compensation. My lords may
They are
keep,
retaining 3 guntas?
Please.
they have retained 3 guntas.
30 guntas remains.
Remains. My lords, 39/1989, government issues a notification, state government, for the purpose of construction of bridge. Beneficiary is the state government itself.
4-1
3/9/1989,
for bridge. Extent?
that is 11 guntas of land.
Yes.
My lords, 3/9 ಅಲ್ಲ 3/1/1989. ಮತ್ತೆ 23/2/1989, final notification was issued by the state government.
11 guntas.
11 guntas. Thereafter, my lords, award was
30
passed.
30 minus 11 is
Yes,
19 guntas remain.
correct. Thereafter, to that extent, award also was passed by the state government.
When?
My lords, award was passed, that is on 15/1/1990.
90. There is no dispute about this 11 guntas.
My lords, they also, because revenue entry shows the name of the government as on today. So 11 guntas of land. Thereafter, what BDA has done is that, my lords, BDA has issued a preliminary notification dated, preliminary notification dated
17/6/2005.
17/6/2005 for the entire 30.
No, well, it's 10 guntas.
10 guntas of land, 10 guntas.
Page 62. at
For
Ejectment.
for what purpose did you say for?
For the purpose of formation of road.
Ring road
Outer ring.
between
Outer ring
Magadi and Mysore Road. Outer ring road.
ಮತ್ತೆ ಇನ್ನೊಂದು ಹೇಳಿಲ್ಲ?
10 guntas, huh?
10 guntas.
Therefore, 19 minus 10, still 9 guntas remain.
9 guntas. Again, another notification was issued, that is dated,
That's one date may be taken. I'm sorry for the interruption. 4/7/2006, BDA resolved that the landowners would get 75% of extent of the land acquired.
and let
I
me
asked you for
complete the facts.
I asked you for that resolution.
Page 95, annexure K,
4/7/2006
6. Page 95, annexure K,
in this writ petition.
please, 2018 report.
No, this was, how can they issue a notification? This is after 17/6/2005.
How?
Please. This is 4/7/2006.
My lords, let me complete,
95.
my lords, let me complete the dates, my lords, so that.
No,
my-
this,
I'll come to that resolution. On 7/6/2005, my lords, a notification was issued for
17
formation.
or 7.
7/6/2005
Yes.
and 21/5/2009. So there are two preliminary notifications.
21/5/2009.
Yes, that is for 10 guntas and 20 guntas, in total 30 guntas.
Same purpose for outer ring road.
My lords,
1 minute, 1 minute.
yes,
What was the extent notified here?
my lord, 7/6/2005 ಅಲ್ಲಿ 10 ಗುಂಟೆ ಜಾಗೆ, 21/5/2009 ಅಲ್ಲಿ 20 ಗುಂಟೆ ಜಾಗೆ.
There was only 19 guntas remaining after the government notification.
Yes.
So you propose to acquire the entire 20 guntas.
30 guntas total.
Same survey number 30.
Same.
They acquired.
Already acquisition ಆಗಿರೋದು, again we have issued a preliminary notification.
The name shows in the notifications as the petitioner.
And it's-
So, but the fact remains that there's no declaration after these two.
No final declaration was issued by the BD.
In effect, apart from the 11 guntas that the government had acquired, the remaining 19 guntas, title remained with them.
11 gunta yes, title remains with that, because we have issued only a preliminary notification.
No, therefore, title remained. The title never came.
So
to
in
you.
the notification, my lords, out of 30 guntas, 11 guntas shows the name of the government.
Whatever the government, the fact that you state in that 30 guntas you wanted to notify, and the fact that 11 guntas were already vested in the state, 19 guntas remains.
Yes, yes.
On 19 guntas, you either have to pay compensation
Again,
or give them the land as per this BTA resolution.
there is another event. Out of 19 guntas, BBMP, my lords, has used to the extent of that is 2.28 guntas.
When?
My lords,
After your notification, before your notification?
my lords, after that,
Date.
after.
On what basis do you say that they've used it?
We are not in position because they are in position. That is the reason why BBMP also is made a party in the proceedings.
Who appears of BBMP? When did you take possession of this 2.28 guntas?
2.28 guntas.
When did you take this possession? Or why did you take the possession?
My lords,
Septic tank
septic tank.
treatment.
ಯಾವ ವರ್ಷ ಏನು ಇಲ್ವಾ ಇದ್ರಲ್ಲಿ?
No, they have utilized because we thought.
ಯಾವಾಗ? Because this is before they declare, after the 17 notification.
Final notification.
After 17 notification.
ಅದು ಡೇಟ್ ಯಾವತ್ತು ಎಕ್ಸಾಕ್ಟ್?
Both of you will have to fight amongst yourselves as to who's to pay compensation or the land.
No, insofar as our stand is that we have utilized the land to the extent of 16.72 guntas of land.
16.72
72 guntas of land, which BD has used the land of the petitioner without acquisition.
2.28.
It is BBM. So therefore, I am sticking on the ground that to the extent of 16.72 guntas of land, for which I had paid compensation of rupees 4,94 lakhs
You had not paid,
106.
you had prepared the check and you kept it ready.
No, sir. 4,94 lakh 106. Then another for structure also we have paid 22 lakhs 17,294.
Total how much?
Total 4,23,11,310, which is already paid to the petitioner.
So you got the compensation for the entire 19 guntas.
16.72 guntas we have paid.
Tell the facts, what has actually happened? Even the, my lordship may just turn to page 184 for a moment. The last page, my lord.
My lords,
184 for a moment.
just I'll complete, my lord.
Joint
We
inspection
passed a
report.
resolution, just to shortcut the time. We passed a resolution saying that we are going to give 75% of 16.72 guntas of land as an alternative land. That was our resolution earlier. Yes.
This 4.23 crores.
How?
When did you pay?
Yes, I'll just come to that. That resolution, my lords, since we have not implemented the resolution, the writ petition has, in a connected writ petition, has a filed a writ petition to execute the sale to the extent of 75% of 16.72 guntas of land. learner single
The
judge.
resolution was this 4/7/2006.
Correct.
Whereby you agreed to give 75%
Of
of
the alternative land,
75% of 19 guntas or 16.
16.72 guntas of land. Then, my lords, that was not acted upon. Then therefore, the petitioner had come before this court. In that writ petition, an interim order was passed to implement that order. Against that interim order, we went in writ appeal. My lords, kindly see the writ appeal order.
This against that non-implementation of the resolution 36480.
Howdu. Then we went in writ appeal. Page 59 is the benchmark for which, my lords, we have issued an endorsement as on today, which is under challenge.
In writ appeal ಏನಾಯ್ತು?
Writ appeal was disposed of, wherein the division bench has directed the BDA to pay compensation in accordance with law as on April 18, 2016.
Writ appeal number ಎಷ್ಟು?
Writ appeal number 1392 of 2016. Page 50. Please.
DD?
Writ appeal. DD.
Disposal.
Yes, disposed date on 20th September 2017.
To pay compensation.
Yes, my lords, in that, kindly see page 59. This division bench has directed the BDA to assess the compensation of the property in accordance with law payable as on April 18, 2016. That is the date of the order of the Honorable Single Judge, and to pay compensation to the writ petitioner as expressly as.
The order has become final?
Yes, this is. Next parallelly, in view of the order passed today, so and so learned counsel advocate appearing for the respondent writ petitioner submits that he will not be pressing the writ petition before this court single judge. Ade connected writ petition iruvantadu.
That should be dismissed as not pressed now.
Not pressed. Adu writ petitioner has to be dismissed as not pressed. In that writ petition, a prayer is sought to implement that 75% of the. Now, as on today, we should pay the compensation. My lords, according to us, I have placed the material record to show that this is the market value of the property for which we have paid.
What is the second writ petition about?
Second writ petition to implement our promise, which we have stated that that 75% ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ. ಅದರಲ್ಲಿ interim order ಆಗಿರುವಂತದ್ದಕ್ಕೆ writ appeal is filed.
Madam, you are a party to this order in writ appeal.
Well,
Let us read the order once again.
Page number 143. We were agree. Even the connected writ petition survives, with respect to the interim order only.
No, but the submission was made that you will not press the writ petition.
Let's see, kindly turn to page 185 for a moment.
No, if you have accepted this order.
That was never complied, my lords. That was the assurance given to us that they will comply. That's
No,
never
there
been
was no
done.
assurance. The order was at paragraph 5. We therefore modify the order, impugn and dispose of this writ appeal by directing the BDA to assess compensation of the property in accordance with law
Please.
payable as on April 18, 2016. That is the date of the order of the Honorable Single Judge, and to pay such compensation to the writ petitioner as expeditiously as possible.
Please, my lords.
So they have assessed and paid you this 4 crores 23 lakhs.
No, my lords, that was not assessed. My lords, what was the?
No, if there's improper assessment, that is one thing, but they have assessed according to them and paid you 4.23.
I'm sorry, my lords. What they had done is, my lords, before the honorable division bench, they said they will assess, and they had issued an endorsement with respect to, there was a dispute there also, my lords, with respect to the extent of the land. Because my 30 guntas, my lords, are not with me. Admittedly, it's not with me.
No, 11 guntas is out of the picture.
It's even 11 guntas. That is what I'm trying to tell, my lords. My lordship,
The
kindly
award-
turn Page
the-
184 for a
Madam,
moment.
let's go step by step. This award was passed in respect of this 10 guntas.
My lords, no award was given to me. My lord. No, it's not passed, my lords. Let the state government say that it has deposited, have taken, it has attained finality. In fact, state government has given a letter saying that we have never utilized this land. The same land is acquired. Kindly turn to 184 for a moment.
No.
That's
You
the
ad-
joint inspecting
you
report
admit-
says.
You admit there's a 4-1 notification, a 6-1 declaration.
But it was never taken. The notified land itself was re-notified by the BDA, showing me as
Said
the
about
owner.
the renotification. If an award is passed,
My lords, it was never, my lords. It was, kindly turn to page 184 for a moment.
are you saying no award is passed?
That's the instructions, my lords.
Because if the award is
No, my lords,
passed,
no, my lords, award. We have not taken the award.
may not have taken the award, but if an award is passed,
No, my lords.
and if you don't seek for reference, your entitlement for the 11 guntas comes to an end.
No, my lords, no, what, as per my instruction, my lords, no, what, kindly turn to page
If they were-
184 for a moment. my
You
lords.
first satisfy me about the facts that I want. If 11 guntas of land was acquired and an award is passed, you don't seek for reference. Your entitlement regarding 11 guntas comes to an end,
Please,
isn't it?
whatever is there, I have to take.
That is all.
If it is,
Who pays for the state?
my lords, one, for a moment. my
Let us
lords.
go one by one. I'll come back to you after the 11 guntas problem is over. I'll come back to you.
Page 184, petition number.
Award pass ಮಾಡಿದ್ದೀರಾ?
ಅವಾರ್ಡ್ ಆಗಿದೆ, ನಾನೇ ಅನಕ್ಷರ ಆಗಿ ಮಾಡಿದ್ದೀನಿ.
ಯಾವ next year?
ಮೈ ಲಾರ್ಡ್ಸ್, ನನ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಪೇಜ್ 21,
Page
21.
December 7 ಅಲ್ವಾ?
ಹೌದು.
ಆಗಿದೆಯಲ್ಲ ಮೇಡಮ್?
ಮತ್ತೆ ಇದು ಅಪ್ರೂವ್ ಆಗಿದೆ ಪೇಜ್ 30.
Page 22.
ಪೇಜ್ 21 is the award. ಅದಾದ್ಮೇಲೆ ಇದು ಅಪ್ರೂವ್
1,59,197.
ಹೌದು.
So 11 guntas, you have no claim.
No, my lords, one second, I'll just give one the letter by the state government itself, my lords.
Award is dated 30th of April 1992.
ಹೌದು.
There is a letter given by the state government itself, my lords, because there is a spot inspection done by the BDA itself stating that they have utilized this land, 30 guntas.
So that is of no concern who utilizes the land. You lost the land in the,
My lords, the possession was with me for the very same land.
madam, how can you say that after the award?
No, my lords, the possession, that is what I have claimed even in my writ petition.
Even,
My
let
lords,
us assume,
turn to
let us
185.
assume that you're in possession. But in the light of this award, how is it that you can claim compensation?
Notifications were issued by the.
Forget about the second notification. It has not culminated in an award, therefore there's no consequence to it.
That way, when BDA two notifications, only by preliminary notifications, what they have taken. they
Because there
themselves
is-
Have done a spot inspection.
Because there is no declaration, they get no right over the 30 guntas. As things stand,
But
because of the declaration and the award.
on the as a matter of fact, their own spot inspection report they have told.
So you want me to modify the award
No, my lords,
without
not-
you seeking for reference?
no, not-
If I accept your argument, what is the effect? The 11 guntas award that was passed in the year 1992 will stand nullified and you will now be paid compensation by the BDA for that 11 guntas afresh, isn't it? Can that be done?
That's the land is acquired, the land was acquired for the bridge, construction of the bridge, which was never done, my lords. It was abandoned. It was never,
Madam, you are not answering my legal question. If there is an award in respect of this land, without you seeking for reference, how can this award be ignored? 19 guntas, there's no difficulty. This 11 guntas, an award is passed. So you can't make a claim for this 11 guntas at all, except the compensation that is deposited.
my lords, if you kindly turn to page 184 for a moment, please. This request.
Yes.
My lords, this is surveyed on 26/10/2013. My lords, here they have clearly told that out of 50, in survey number 57/7, 30 guntas, out of the total extent of 13 guntas, with respect to the very same petitioner, 27.72 guntas were utilized for the.
So BDA has utilized even the 11 guntas that the state government had acquired. So who will be aggrieved by it? You are not the owner of that 11 guntas.
My lords, in the notification, preliminary notification, they have issued my name only, one notified my name.
Maybe
only,
so, but they have not issued a declaration. How will you get title once again?
Neither of them have to give me compensation, my lords. detailed
Compensation was given in the form of an award. If you have not challenged the award, there is a consequence to it. 19 guntas, they have given you 4 crores.
No, it's not for 19 guntas. They again claim that it is before the honorable division bench, they say that we are entitled to about 7 crores 70 lakhs something. And then.
If
the
you
entitlement is there.
if you are agreed by the 4 crores and if you want a higher compensation, what is the remedy for you?
That's with respect to the reference, filing of reference with the civil court, my lords. Here, the issue is before the honorable division bench itself, they filed a memo saying that, look, we have utilized only 16.72 guntas. and they're entitled for guideline value up to 7 crore 72 lakhs
For 27 guntas.
for 16.72 guntas. That is at page 181. Before the
Page?
page 181. 180 is in Kannada, my lords. This is what they have filed, my lords, not. They are produced before the honorable division bench. Translated copy at 181, my lords.
If you have calculated 7.72 crores for this 16.72 guntas, how can you reduce it now to?
No, my lords,
4
we have
crores?
allotted for, we have made a calculation, just I'll point out, for what reason we have done such a calculation. I draw my lords.
No, did you produce this before the division bench and did you tell the division bench?
Illa.
This was the document produced. given
Oh,
by
my
them,
lords. Division bench ಅಲ್ಲಿ ಹೇಗೆ produce ಮಾಡಿದ್ರು?
It was produced by them, my lords. We were disputing with respect to the market value, not even the guideline value. What the 4 crores, what they've given is not even the guideline value, my lords.
Is not a part of record in a writ appeal. In a writ appeal, I went to the writ appeal only in so far as grant of interim order is concerned, because which is in the nature of final order. Therefore, in a writ appeal, my lord, this division bench has said.
You have taken, apart from this 11 guntas, you and the BBMP have taken 19 guntas of land.
90
Not-
BBMP or 19 guntas ಮಾಡಲಿಲ್ಲ.
Both of you together have taken 19 guntas of land. If this calculation annexure AE is correct, according to you, for the 16.72 guntas, the value is 7 crores 21 lakhs. If annexure AE. This
No.
is for 16.72.
Yes.
By the same yardstick, they would be liable to pay for the 2 point and odd acres. Isn't it?
Correct.
So if this calculation is correct, you will have to abide with this calculation and give them the right to challenge this also.
My lords, I'm sorry, my lords, I'm not enlightened. This is an official note which is not been communicated to the petitioner.
Was it produced with the division bench?
By
Where?
memo, my lord.
My lords, it is
I
not
will-
produced before the division bench, which is
And how
factually
will I get
incorrect.
it?
It is not a part of record in a writ appeal. It was not communicated to the petitioner.
But it
The
is there-
communication is this impugned endorsement is a communication.
But it is there in
It is
your,
an unofficial. Yes, I have placed that material on record. For what reason, my lord, we have arrived at a conclusion. We made a best efforts. Of course, my lords, what my lords has said is that because it requires evidence, this endorsement has to be
you
treated.
should have thought about all this section before you took possession without acquiring it.
ಮಾಡಿದೀವಿ
So
ತಗೊಂಡು
therefore, there's a penalty that you pay.
ಬಟ್ ನಾವು ನಮ್ಗೆ ಎಷ್ಟು ನಮಗೆ
ಯಾಕಂದ್ರೆ ತಾವ್ ತಪ್ಪು ಮಾಡ್ಬಿಟ್ಟು ಇಲ್ಲ ನಾನು ಒಳ್ಳೇದಕ್ಕೆ ತಪ್ಪು ಮಾಡಿದೆ ಆದ್ರಿಂದ ನಾನು ಕ್ಷಮಿಸ್ಬಿಡಿ ಅನ್ನೋದು
my lords is right. But we are compensated. We are
not to your satisfaction,
Yes,
My lords, it's
not to your satisfaction. Compensation should be adequate, just,
yes.
not in the terms that you think is just.
My lords, I'll just point out to show that my compensation.
And there must be a penalty for taking taking possession of lands without acquiring it.
My lords, we have arrived at the this thing, conclusion.
ಎಲ್ಲಿದೆ?
ಅದು ನೋಟ್ ಶೀಟ್ ಅಲ್ಲಿ ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ.
As of 18th April 2016.
ಹೌದು. My lords, have a look at the page 74 of my statement objection. I have pleaded also, my lords, kindly compare with
Page?
Page 74. And compare my pleading with para 15.
ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
Page 74 may be looked into.
74 ಏನೇನೋ ಟ್ಯಾಬ್ಲೋ ಕಾಲಮ್ ಇದೆ. How have you arrived?
ಅದೇ ವಿಲೇಜ್ ಗೆ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ ನಮಗೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಸಿಗ್ಲಿ, ಬೇರೆ ಅಡ್ಜಸೆಂಟ್ ವಿಲೇಜ್ ದೆಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ತಗೊಂಡ್ವಿ.
ಅಲ್ಲ, ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ಎಷ್ಟಿತ್ತು?
Yes, just. My lords, the guideline value which you have indicated at page number, that is page 76 ಅಲ್ಲಿ, after taking into account of all registered sale deeds.
No, forget about sale deeds. I want to know the guideline value.
Guideline, yes. Guideline value, 23,700 ಚದರ ಮೀಟರ್, ಚದರ ಅಡಿ, ಸ್ಕ್ವೇರ್ ಫೀಟ್ಗೆ 2,202 ರೂಪಾಯಿ ತಗೊಂಡಿದ್ವಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್.
You have taken it as 2,200
2,202 per square feet.
per square feet.
ಹೌದು.
Per square feet. How much is it? 19 guntas?
19 ಗುಂಟಾ ಸಿಗಲ್ಲ, 16 ಗುಂಟೆಗೆ ಚಿಲ್ಲರೆ ಅಷ್ಟಕ್ಕೆ ಮಾತ್ರ ನಾವು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ದು. ವಿಚ್ ಕಮ್ಸ್ ಟು ದ ಟ್ಯೂನ್ ಆಫ್ ರುಪೀಸ್ page 77 may be looked into. ಇದು
Comes to 4.55 crores.
ಹೌದು.
Then what about solution?
ಇದೆಲ್ಲ ಮಾಡ್ಲಿ
ಮತ್ತೆ
ಮಾಡ್ಬೇಕು.
2016 ಅಂದ್ರೆ you'll have to apply the 2013 act. Then and interest on that? It will be double 4.
ಮತ್ತೆ ಇನ್ನೊಂದು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟಿದೀವಲ್ಲ, ಅದು ಬಿಲ್ಡಿಂಗ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಬೇರೆ, ಲ್ಯಾಂಡ್ ಗಂತೂ ಕೊಡ್ಲೇಬೇಕು ತಾನೆ. 4.55 crores plus 4.55 crores ಕೊಡ್ಬೇಕು ತಾನೆ. 100% solution.
My lords may take it as 4,23,11,000.
ನನ್ನ ಪ್ರಕಾರ ಬಂದಿದ್ದು
ಇದು ಜಾಗಕ್ಕೆ ಬಿಲ್ಡಿಂಗ್ ವ್ಯಾಲ್ಯೂಗೆ 22,17,290.
ಅದು ಚಿಕ್ಕ ಅಮೌಂಟ್. ಇದ್ರದೇ ಬರುತ್ತಲ್ಲ 9 ಕೋಟಿ ಬಂದ್ಬಿಡುತ್ತಲ್ಲ. Plus interest from the date of taking possession. Then on what basis are you not playing around with somebody? You take their land illegally. You determine compensation in direct contravention of the 2013 Act. You don't even give them interest on that amount. And you're saying that they are the ones who have cheated you.
ಚೀಟ್ ಅಂತ ಹೇಳಿ
ನೀವು ಅದೇ ಹೇಳ್ತಿರೋ ತಾನೆ ನೀವು. 11 ಗಂಟೆ ಬಿಟ್ಬಿಡೋಣ ಸದ್ಯಕ್ಕೆ.
ಮತ್ತೆ BBMP ಅವರು ಜಾಗ ನಾವು ಸ್ವಾಧೀನದಲ್ಲಿ
19 ಗುಂಟೆಯಲ್ಲಿ 16.72 ಗುಂಟಾಸ್ಗೆ ಎಷ್ಟು ಕೊಡ್ತೀರೋ ನೀವು 2,200 ರೂಪಾಯಿಯನ್ನ ತಗೊಂಡಿದ್ದೀರ. ಅವರು ಅಷ್ಟೇ ಕೊಡ್ಬೇಕು ತಾನೆ.
ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ದುಡ್ಡು, ನಾವು ಇಷ್ಟು
ಅದಕ್ಕೆ ಅವ್ರು ಕೊಡ್ಲಿರತ್ತಾನೆ. ಸೊ 4,000 ರೂಪಾಯಿ per square feet ಪ್ರಕಾರ ಲೆಕ್ಕ ಹಾಕಿ ಇಂಟ್ರೆಸ್ಟ್ ಲೆಕ್ಕ ಹಾಕಿ ಕೊಡಿ.
4,000 ರೂಪಾಯಿ ಬೇಸಿಸ್ ಅಷ್ಟಿಲ್ಲ ಅಲ್ಲಿ ಜಾಗ.
ಅಲ್ಲ 100% ಸೊಲ್ಯೂಷನ್ ಅಷ್ಟೇ ಆಗುತ್ತಲ್ಲ.
Page 178 may be seen the guideline.
2,202. According to you, what 2,202?
My lords, can I make a request subject to what my lord said? My lords may treat our endorsement as an award and make a reference to this civil code, so that they can get more.
This is what I don't like. You take the law into your own hands and then you push them into the court for the next 10 years. They are now fighting for 8 years. You have taken their land.
That's 2,000.
You've given them half the compensation. And you're asking them to again struggle?
ಇಷ್ಟು ನಾವು ಕ್ಯಾಲ್ಕುಲೇಷನ್
ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ಕೊಡಿ ನನಗೆ. According to the 2013 Act, for the 16.72 guntas, ಎಷ್ಟಾಗುತ್ತೆ ನಿಮ್ ಪ್ರಕಾರ ಕೊಡಿ. We'll put it across to them. Let us see.
ನಮ್ಮವ್ರು ಮಾಡಿದ್ರೆ ತಾವು ಆರ್ಡರ್ ಬರ್ತಿದೆ.
ಇಲ್ಲ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ನಾನು. Once I pass an order, you can't go back. That's why I'm telling you.
Lordship, may kindly turn to the.
Nimshari, I'm with him. Please wait.
ಡಿವಿಷನ್ ಬೆಂಚು ಈ ತರ ಬರ್ದಿದ್ದಾರೆ, ಆಕ್ಚುಯಲ್ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಕೊಡ್ಬೇಕು.
2016 ಆಕ್ಚುಯಲ್ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಅಂದ್ರೆ ಅಕಾರ್ಡಿಂಗ್ ಟು 2013 ಆಕ್ಟ್.
ನಮಗೆ BD ಆಕ್ಟ್ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ. ನೀವು
ಇಷ್ಟ ಬಂದಂಗ ಆಗುತ್ತಾ?
ಆತರ
ಇಲ್ಲ ಕೊಟ್ಬಿಡಿ, ಸುಮ್ಮನೆ ಜಮೀನ್ ಕೊಟ್ಬಿಡಿ ವಾಪಸ್ ಅಷ್ಟೇ. ಡೋಂಟ್ ಡೂ ಎನಿಥಿಂಗ್, ಜಸ್ಟ್ ಗಿವ್ ಬ್ಯಾಕ್ ದಟ್ ರೋಡ್ ಕಿತ್ತಾಕ್ಬಿಟ್ಟು ಫ್ಲಾಟ್ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ. ಅವ್ರೇನೋ ಮಾಡ್ಕೊಳ್ತಾರ. ಅರ್ಧ ಎಕರೆ ಒಳ್ಳೆ ರೇಟೇ ಬರುತ್ತಲ್ಲ ಈಗ. You have a choice, you don't have to pay anything.
In accordance with law payable as on April 18, 2000.
What is the law?
Accordance with law.
2013 Act.
Acquisition ಆಗಿಲ್ಲ.
Accordance with law ಅಂದ್ರೆ ಇನ್ನೇನ್ ಮಾಡ್ತೀರಾ? This is worse than compulsory acquisition. You don't even hear them. You first. I think the solution should be 200%, not 100% here.
ತಪ್ಪಾಗಿ ತಾವು ಆರ್ಡರ್ ಬರೀ.
ಏನು
ನನ್ನ ಕನ್ಸೆಂಟ್ ಬೇಡ.
ಸೊಲ್ಯೂಷನ್ ಹೇಳಿ.
ಅದೇ ಸ್ವಲ್ಪ ಕಮ್ಮಿ ಆದಂಗಿದೆ, ಅನ್ಯಾಯ ಆದಂಗಿದೆ.
And interest ಎಷ್ಟು ಬರುತ್ತೆ? ನಿಮ್ಮ ಆಫೀಸರ್ಸ್ ask them to calculate according to 2013 Act and give me a figure by day after tomorrow.
13 ಅಂದ್ರೆ acquisition ಆಗ್ಲಿಲ್ಲ.
For determination of compensation, you can adopt that. Or else give back the land. You have that option.
Because we utilize the land before commencement of new act.
Illegally, you are bound by the order of the division bench.
That was passed in 2016. So what was the law prevailing in 2016? 16. Apply that. I'll have a deputy tomorrow, ask him to calculate and let me know. If I pass an order, it's going to be a final order. You have no option. I don't want to do
I'll
that.
make a request to the, I'll make a request.
Ask them to prepare exactly in accordance with the 2013 Act as to what is the exact compensation for 16.72 guntas as if it was notified on that April 2016,
I'll make it.
day after tomorrow. That 11 guntas, you can't do anything. I will dismiss this writ petition not pressed in the light of the statement that you've given before the revision.
Day after tomorrow.
No, I'm telling you what I'll do day after tomorrow.
The number 36, the SP Prakash.
Petitioners are owners of the property situated alongside PB Road, Old Road in Davangere City. But the authorities wanted to widen the road.
Who's opposing you?
But our apprehension is, Lord, the authorities, they would take the portion of our property facing road without, Lord, following the procedures, Lord, established by law. That is our apprehension. We have filed a petition and there is a stay granted by this court. But a similar petition, Lord, the other petition, not only one, several petition have been disposed of. And with the observation that if they want to take the private property, they have to follow the.
Contract idara. Contract idara.
Day before yesterday, my lord, given a good time, that the file is not raised. So, my lord, remember.
ಕೇವಟಲ್ಲಿ ಹಾಕಿದ್ರೆ ನೀವು
ಸಿವಿಲ್ ಕೋರ್ಟಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ, ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. And they contend that we have encroached the road. Then will not they have to hold an inquiry, giving us an opportunity. It is not so, will not they unilaterally, they started placing marks on the portion of our building. And they start demolishing. The lordship, when you see the photograph, they have made marks on it.
So successfully you have stalled the widening of the road. Successfully you have stalled the widening of the road for the past.
We have no objection.
10 years.
If we have, Lord, encroached, they should have taken, Lord, action in accordance with, not by this way. Lord, kindly see the photographs, my lord. And the publication, my lord, paper publication, lordship at page 133. They announced that they are going to widen the road. And they say that compensation they won't pay because there is encroachment. But page 131, your lordship, 132. My lord, they have put marks on our buildings, page 133.
Petition withdraw ಮಾಡ್ಕೊಂಡು first petition.
ಅದು first petition ಮಾತ್ರ.
ಇಬ್ರೇನಾ ಇಲ್ಲ?
The remaining, my lord, the others have not. But I have paid.
First and fourth. First and fourth. Either acquire it under this act or if there are unauthorized portion, you take action in accordance with law.
Yes, my lord, because file is not, this file is not given for.
Our prayer ಅಷ್ಟೇ, declaring that the action of the respondents to demolish the portion of the building exiting the scheduled property to this writ petition without following the mandatory provisions contained under the 2013 Act.
That's how the other petition.
I will simply say that either if there is unauthorized possession, you will take possession in accordance with the PP Act.
Please,
If it is not acquired, you shall take recourse to the official proceedings before you demolish the proceedings.
I will collect the ones, I will collect copy, my lord, day after tomorrow, my lord. I will collect the copy because.
But you know,
Day after.
Number of petitions just followed up.
ಅಲ್ಲ,
ಒಂದ್ಸಲ ಫೈಲ್ ಇಲ್ಲ ಅಂತ ಇದಾರೆ. ಮಂಜುನಾಥ್ ಅವ್ರು ಇದ್ದಿದ್ರೆ ಅವ್ರನ್ನ ಕೇಳಿ ಮಾಡ್ಬೋದಿತ್ತು, ಅವ್ರು ಫೈಲ್ ಇಲ್ಲ ಅಂದಾಗ. Day after tomorrow.
37, EM Siddhappa.
Yes.
Last occasion, it's a Gale matter. One prayer ಬರಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
Next year.
validity ಇದ್ರ ಮೇಲೆ. Last I filed a memo along with decision. Memo for disposal ಅಂತಲ್ಲ, the last date of hearing. ಅದು ಒಂದು prayer ಬರಲ್ಲ, but
In disposal.
can I pass it on? Last date like in 24/2. ಅಲ್ಲ 26/3.
In prayer ಏನಿದ್ರಲ್ಲಿ?
ಇದರಲ್ಲಿ
ಸೆಕೆಂಡ್ ಪ್ರೇಯರ್ ಉಳ್ಕೊಳ್ಳಲ್ಲ.
ಸೆಕೆಂಡ್ ಪ್ರೇಯರ್ ಫಸ್ಟ್ ಪ್ರೇಯರ್ ಇರುತ್ತೆ, ಅದನ್ನ they have to argue.
ಫಸ್ಟ್ ಪ್ರೇಯರ್ ಏನು? ಕೊಟ್ಟಿದ್ದಾರೆ.
Directing in the manner of it, quashing the order passed by the non-principal district and session judge Chitradurga in miscellaneous number 245 of 12 and 253 and 254 of 12 dated 5/12/2013. Produced annexure D to the petition and then.
Please read the reasoning.
Internal page number 35, para 9, madam.
Para 8 ಅಲ್ವಾ?
Can I read it, madam?
Para 8, page 47.
I am reading the repetition 19069, my lord. ಅದು ಎರಡು ಕನೆಕ್ಟ್ ಆಗಿರ್ಬೇಕು ಅನ್ಸುತ್ತೆ.
I have 3436.
34. Okay. Yes, madam. At page number 47, madam. Point number 8. Para number 8.1 and 2. The counsel for the claimant petition.
Para 9 in the wood. Para 9.
Para 9. The counsel for the respondent who has filed the objections in detail and also submitted the written arguments wherein it is contended that the compensation claimed by the petitioner does not hold any base and she has to produce any documents to establish her case against the respondent to seek adequate compensation in respect of lands to an extent of 22 guntas acquired by the respondent authority in respect of survey number 360/3 of Siddha Halli village, Chitradurga Taluk, as well as the petitioner is the owner of the said land property. In fact, the respondents have acquired the land to an extent of 21.5 guntas, but not 22 guntas. The petitioner has contended that she is getting sufficient water sources from the bore wells dug in her land for the purpose to grow the crops such as onion, cotton, various flowers, plants, banana plants, horticulture crops, pomegranate and lemon plants, coconut trees, arecanut, and the land which acquired by the respondent authority is a fertile land, and though she has taken such contention, but she has not produced any document to establish her case against the respondent for seeking adequate compensation urged by various grounds. Though the petitioner has examined her power of attorney holder as PW1
and also got marked exhibits P1 to P14. Section 10+4 of the PMP Act 1962. It provides for payment of compensation calculated at 10% of the market value of the lands as is the date of notification issued. For the right of user of the lands as vested in the state government, the central government or the corporation on 24/9/2010. As per the PMP Act 1962, the notification is issued and therefore the market value of the was considered for the year 2009-10 only for rupees 1 lakh as the market value and the landed property for the year 2009-10. But the petition has taken as a contention in her petition that the land to an extent of 22 guntas, which was acquired by the respondent authority, is valid for rupees 20 lakhs and seeking compensation of 83.14 lakhs for the crops damaged and other damages, and the same is very evasive and abnormal. The petitioner has not produced any document to show that the lands belonging to her is valued for rupees 20 lakhs for the year 2009-10 as urged in the petition. Therefore, the market value assessed by the competent authority for the year 2009-10 as only rupees 1 lakh, and the same is correct market value. Therefore, the contention as taken by the petitioner by urging various grounds in the petition does not hold any substance. Therefore, the counsel for the respondent to consider the written argument submitted in detail based upon the statement of objections rejected the petition filed by the petitioner. In the instant petition, keeping in view of the various contentions taken by the counsel for the petitioner as the respondent who has submitted the written arguments in detail, it is necessary to state that section 10(3) of the PMP Act 1962 states regarding the competent authority has to fix the compensation on the account of damage or loss or injury sustained by the person interested in the lands in respect of matters mentioned in clause small I 3 herein. Whereas section 10(4) of the PMP Act 1962, it provides for the compensation calculated at 10% of the market value of the land. Continue, my lord.
You are saying it's 1 lakh per acre.
ಅದು ಅವರೇ ಕೊಟ್ಟಿರೋದು.
ಯಾರು?
ನಮ್ಮ ಅಥಾರಿಟೀಸ್ ಅಲ್ಲಿ ಏನ್ ಗವರ್ಮೆಂಟ್ ವ್ಯಾಲ್ಯೂ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಇತ್ತು ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್
ಯಾವ ಆಧಾರದ ಮೇಲೆ?
ಸಬ್ ರಿಜಿಸ್ಟರ್ ಆಫೀಸ್
that is increased to 5 lakhs per acre in a meeting.
ಅದನ್ನ ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಜಾಸ್ತಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀವಿ.
So 1 ಲಕ್ಷಕ್ಕಿಂತ 5 ಲಕ್ಷ ಅಂದ್ರೆ ಎಷ್ಟು ವೇರಿಯೇಷನ್ ಇದೆ?
ಮಲಾಡ್ initially
According to it was 1 lakh per acre.
1 lakh per acre.
In the meeting it was enhanced to 5 lakhs per acre.
ಹೌದು.
So your estimation was wrong.
ಅಲ್ಲಲ್ಲ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಏನಿತ್ತು ಅದನ್ನ ತಗೊಂಡಿದ್ವಿ ಮೇಲಾಡ್ ಫಸ್ಟ್ ಇನಿಷಿಯಲ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ. ಸಾರಿ ಮೇಲಾಡ್ 1 lakh ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಗವರ್ಮೆಂಟ್ ವ್ಯಾಲ್ಯೂ ಅಲ್ಲಿ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಏನಿತ್ತು ಅದನ್ನ ತಗೊಂಡು ಇದ್ ಮಾಡಿತ್ತು. ದೆನ್ ಅಗೇನ್ ಇದು ಲ್ಯಾಂಡ್ಸ್ ಅಲ್ಲಿ ಸುಮಾರು ಜನ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಿರೋದ್ರಿಂದ ಮೀಟಿಂಗ್ DC ಹತ್ರ ಒಂದು ಮೀಟಿಂಗ್ ಮಾಡಿ ಅದನ್ನು 5 times ಜಾಸ್ತಿ ಮಾಡಿ 1:5.
ಯಾವ ವರ್ಷದ್ದು ಇದು?
2009 ಮೇಲಾಡ್.
ಗೈಡ್ಲೈನ್ ಅಲ್ಲಿ ಇರ್ಲಿಲ್ವಾ?
ಅಲ್ಲ ಅದ್ರ ಪ್ರಕಾರನೇ ಅಕ್ವಿಷನ್ ಅಂತ ಮಾಡಿದ್ದು.
ಅಲ್ಲ ಸೇಲ್ಸ್ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕ್ಸ್ ಅಲ್ಲ ಗೈಡ್ಲೈನ್ ಮೇಲೆ ಇವರು ಡಿಟರ್ಮಿನ್ ಮಾಡಿಲ್ವಾ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಆಫೀಸ್ ಅಲ್ಲಿ?
ಇತ್ತು ಮಾಡ ಇತ್ತು.
ಎಷ್ಟಿತ್ತು ಅದ್ರಲ್ಲಿ? ಅದೆಲ್ಲ ಬರ್ದಿಲ್ಲ, ಸುಮ್ನೆ ತಾವು ಕೊಟ್ಟಿರೋದೇ ಸರಿ ಅವ್ರು ಕೊಟ್ಟಿರೋ ತಪ್ಪು ಇಷ್ಟು ಹೇಳೋದು ಬಿಟ್ರೆ.
ಅದು ಬೇಕಾದ್ರೆ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಮೇಡ್ರಿ.
ತಾವು 1 ಲಕ್ಷ ಅಂತ ಹೇಳಿದ್ರಿ, ಅದನ್ನ ಮೀಟಿಂಗ್ ಅಲ್ಲಿ 5 ಲಕ್ಷಕ್ಕೆ ಏರ್ಸಿದ್ರು. That you accept, that means 1 lakh was definitely not the consideration.
ಹೌದು ಮೇಡಮ್.
Then it could be 10 lakhs also. He's saying 20 lakhs. So what is the method with determining the value?
Malad, in similar repetitions, there are many repetitions, Malad. ಇದು ಏನಾಯ್ತು, ಕೆಲವು ಕೋರ್ಟ್ಸ್ ಅಲ್ಲಿ ಮಿಸ್ಲೇನಿಯಸ್ ನು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು, ಎಗ್ನೆಸ್ಟ್ ಇಲ್ ರೇಟ್ ಬಂದ್ರು. ಕೆಲವುದ್ರಲ್ಲಿ ಮಿಸ್ಲೇನಿಯಸ್ ಅಲೋ ಮಾಡಿದ್ರು. ಅಲೋ ಮಾಡೋದ್ರಲ್ಲಿ ನಾವು ಅಗೇನ್ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಪಿಟಿಷನ್ಸ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಅಂಡ್ ಅದರಲ್ಲಿ ಒಂದು ಮ್ಯಾಟರ್ ಮಾತ್ರ ಡಿಸ್ಪೋಸ್ ಆಯಿತು. ಒಂದು ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸ್ ಆಗಿರೋದು ಈಗ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ. ವಿ ಹ್ಯಾವ್ ಪೇಡ್ ದ ಕಾಂಪನ್ಸೇಷನ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀವಿ.
ಎಷ್ಟು ಮಾಡಿದಾರೆ ಅಲ್ಲಿ?
ಅರೌಂಡ್ 85 lakhs or something. ಇನ್ ಆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಎಷ್ಟಿತ್ತು
ಅದು ಎಕರೆಗೆ ಎಷ್ಟೊಂದು ಡಿಟರ್ಮಿನ್ ಮಾಡಿದಾರೆ?
ಇಟ್ ವೇರೀಸ್ ಮೇಡಮ್. ಅದು ಸ್ವಲ್ಪ ಡಿಫ್ರೆಂಟ್
ಇದು ಹೆಂಗೆ? How do you determine that value? Please read section 10 of the act ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಹೌದು ಮೇಡಮ್. ಅದು ತಂದ ಲೆಟ್ ಮಿ ಪ್ರೊಡ್ಯೂಸ್ ಮೈ ಲಾರ್ಡ್. ಅದನ್ನ ಈ ಕೇಸಲ್ಲಿ ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರೆ ಅಂತ ಆಸ್ ಅ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನಿದೆ ಮೇಕ್ ದಿಸ್ ಅವೈಲಬಲ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್. ಅದನ್ನ ಕೊಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಇಯರ್ ಬೇಕು.
Objections ಹಾಕಿದಾರ ನೀವು?
ಹಾಕಿದೀವಿ.
Where is that meeting where it was announced to 5 lakhs?
That copy is not produced here, my lord. In all the cases it has been, wherever we have filed appeal, ಅದ್ರಲ್ಲೆಲ್ಲ we have produced, ಇದರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ನಾವು. ಅದು ಇದರಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
Not counsel for the respondent to place on record the proceedings of the meeting dated 10/8/2011, convened with the Deputy Commissioner Chitradurga, in which the value of the land was enhanced by 5 times. And counsel also to state on what basis the said amount was determined, and if there's any guideline value fixed, same shall be produced. The list on
11.
2 weeks at least. 15th, 18.
Bill 38, MR remitted. The first point, my lord, I will take notice for respond number, for other respondent. Respond number 2, 3, 4, 5.
DJ takes notice for R2 to R5. In matter, no?
This matter, my lord, show cause notice has been challenged. First notice and final notice.
Beginning of the road, state highway in the village section has was.
K and L. Final notice on ಹೇಳ್ತಾರೆ.
Page 34, my
It's
lord.
done that
2 guntas land has been used.
notices were illegal. Indiscriminately, some part of the village was in a reduced width, and where the petitioner's properties were coming, there was a road was widened up to 13.5 meters. That was based on that, the notifications were issued, notices were challenged. But said that project has been completed without touching the properties of the petitioners and other villagers.
Now, what is annexural? They're asking you for agreement to for agreeing to the compensation, or else they will proceed to refer it to the civil court. In what way are you agreed with this? If you are agreeable, if you're agreeable with the compensation, that's one thing. If you're not, it will go to the civil court.
No, my lord. Based on arbitrary increase and decrease of the width in the village section, notices were.
Where have you challenged the acquisition? Where have you challenged the acquisition?
Only notices have.
Only notices, sir.
Then read annexure K.
May I make one submission? ma'am?
Ah.
Now the project has been completed, said to have completed without touching the properties of the petitioner as well as the other villagers. In that regard, the petitioner was seeking the instructions from the information from the authorities. For that,
Either way, since you have not challenged the acquisition, what is the point in challenging the subsequent notices? If you are not agreeable for the compensation, they will send it to the civil court. That is all.
a week's time is granted, I will take instructions.
I'll refer it, I'll dismiss it saying that you're, it's open to either to accept it or to
Only 1 week time.
relist.
Amen. 39 and 40 adjourned, seal number 41, Sri Narendra D.V. Gowda.
Speaker, any, a different date, my lord, anytime.
Date code. 11th. Seal number 42 adjourned, seal number 43, Sri Rahul S. Reddy.
That's appear for the petitioners. There are two other similar matters, my lords. All the three matters may be.
For respondent 2 and 3 in this matter, my lord, for petitioner has given the WP copy without annexes in this matter.
Could you
Have a copy request to furnish. That's
relist along with
two
so and
sets.
so. Copies of the petition annexes we furnish to the council appearing for the respondents.
Biblical.
Seal number 44, Sri Sudhakar G.
An application for change of land use based on circular. they have
Who's
rejected
opposing
following
you?
the Supreme Court judgment.
Who's opposing you?
Case of-
Lakshmi
Filed an
Shah.
objections.
ಹಾಕಿದಾರ ಏನಂತ ಹೇಳ್ತಾರೆ?
Also, based on Supreme Court judgment, there is a circular is passed. Based on that circular, they have said that we will not forward your application because there is a circular and the circular has also been challenged. In this case, KHP allotted a industrial site to us.
ಅವ್ರು ಬೇಡವಾ? Relist.
11th. Seal number 45, Srimati Poonam S. Patil.
Recommended that held that acquisition is lapsed, and in fact, they have in 2000, way back in 2016, held that the matter should be placed before denotification committee. Till today, that's not seen the light of the day, Millards.
Appearing for the respondent.
Let's 1 to 4 is state, R5 is the for whom it was acquired. Possession is with us as per their own reports, Millards, and compensation is not taken. Therefore, we will be seeking on a.
KDP.
No, it's not KIDB.
In
1 to 4 is state. R5 is private respondent.
I file my statement of objections, my lord, because they
What is the
recently
prayer in the
amended their expectations.
So let's declare that the acquisition has been lapsed. In fact, Millards, the question of objections may not arise, Millards, for the simple reason. May I take a lot of attention to page
So
1?
no award is passed?
Its award was approved on 8/6/98. Preliminary notification was 1990, final notification 91. So even under the old act, Millards, it had to be passed within 2 years after final notification, the award, Millards. There also it lapses. Now the new act, Millards, which goes by saying before 5 years, award to be passed and compensation not taken and possessions with
The
us.
prayer indicates the preliminary was 26/3/1990.
Yes, Millards.
Final notification is 12/8/1995.
No, Millards, this correction, Millards, I'm correct. 7/1/1991 is the right date, Millards.
They have amended me.
7/1/1998. No, sorry, Millards, it's 12/8/91. 12/8/91 is the final notification. I stand corrected, Millards. Final notification is 12/8/91.
12/8.
Yes, award was approved on 8/6/98. But I will demonstrate notes or the,
What is the date of the award? What is the date of the award?
it is 8/6/98. What they've all along mentioned is the date of approval is what they say. We do not have the copy of the award as such. But their own reports say that possession is with us, if not collected a compensation. Therefore, they recommend, my lords, that it's lapsed.
They passed an award because you said the declaration was 12/8/1998. Then the award is even before that on 8/6/1998.
8/6/98 is the date of approval. May I, your lordships, take to one observation made by them, my lords, which is at page 198 minutes. The file notings at serial number 140 minutes. May I read that portion? Minutes? Page 198. May I read that serial number 140 minutes?
Yes.
Yes. ಅದರಂತೆ ಕಾನೂನು ಇಲಾಖೆ ಅಭಿಪ್ರಾಯವನ್ನು ಖಂಡಿಕೆ 77ರಿಂದ 90ರಲ್ಲಿ ಪಡೆಯಲಾಗಿದ್ದು, ಈ ಹಂತದಲ್ಲಿ ಪ್ರಸ್ತಾವಿತ ಜಮೀನು ಭೂ ಸ್ವಾತಂತ್ರ್ಯದಿಂದ ಹಿಂಪಡೆಯಲು ಅವಕಾಶವನ್ನು ತಿಳಿಸಿದೆ. ತದನಂತರ ಬೆಳವಣಿಗೆಯಲ್ಲಿ ಖಂಡಿಕೆ 19 ಟಿಪ್ಪಣಿಯಲ್ಲಿ ಮತ್ತೊಮ್ಮೆ ಕಾನೂನು ಇಲಾಖೆಯ ಅಭಿಪ್ರಾಯವನ್ನು ಕೋರಲಾಗಿತ್ತು. ಅದರಂತೆ ಖಂಡಿಕೆ ಅಭಿಪ್ರಾಯ ನೀಡಿದ್ದು, ಈ ಅಭಿಪ್ರಾಯದಂತೆ ಪ್ರಸ್ತಾಪಿರೋ ಭೂ ಸ್ವಾಧೀನ ಪ್ರಕರಣ ಭೂ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆ 2013 ಆಕ್ಟ್ ರೆಫರ್ ಕಲಂ 24(2) ರಂತೆ ಅಸಿಂಧುಗೊಂಡಿದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪ್ರಕರಣವನ್ನು ಡಿನೋಟಿಫಿಕೇಶನ್ ಸಲಹಾ ಸಮಿತಿ ಮುಂದೆ ಮಂಡಿಸಿ ಕೈಗೊಳ್ಳಬೇಕಾದ ಮುಂದಿನ ಕ್ರಮ ಬಗ್ಗೆ ಸಮಿತಿ ಸಲಹೆ ಕೋರಬಹುದಾದಂತೆ ಅನುಮೋದನೆ ಆಗಿದೆ. This is the government's thing on.
Secretary's order, but the dates that you gave does not indicate it there is lapse.
I will take lots of reports by the SLO, BDA and BBMP.
You said notifications of the year 1990.
Please.
Correct. Declarations of the year 1998.
Yes, award was
What is
approved.
also of the year 1998.
No, I repeat the dates once. Preliminary notification was 26/3/1990. Lots noted that. It's preliminary notification.
Yes.
Final notification was 12/8/91.
91.
Please, notes. But we do not have the copy of the
Award?
award, it says. Yes.
When was the award?
Award notes, we have the date of approval of the award, which says 8/6/98.
Where is the award?
Award copy we do not have, notes, the state.
I'll secure the instructions, because the whatever the writ petition furnished, it is not properly paginated, and I'm unable to follow the.
We didn't provide.
Copies for the beneficiary.
Please, notes.
B. Sridhar.
They have filed wakalat notes. Respondent number 5. It's private beneficiary in favor of whom the notification is passed. They have not taken possession.
To place on record the copy of the award said to have been passed pursuant to the declaration dated 12/8/1991 by the next date of hearing.
Them furnish proper writ petition.
We will give them proper only award if they could place on record, because we don't have the copy. Just for a date, to be fixed.
19.
Great.
19.
Number 46. Vinod Gowda.
The time ಕೇಳಿದ್ರು ಬೆಳಗ್ಗೆ. ಬೆಳಗ್ಗೆ ಯಾರೋ ಟೈಮ್ ಕೇಳಿದ್ರು ಅಲ್ಲಿ.
To the extent of.
ಟೈಮ್ ಕೇಳಿದ್ರು ಅವರು.
Monday. Next Monday.
47 adjourned. Number 48, Shri Uday KS.
Pay for this. Respond.
For 2 and 3 months.
I'm only seeking direction to prepare joint measurement sketch as per annexure D and in pursuance of annexure D and E, my lord. Petitioner's land was notified by the respondents for widening the road which exists, my lord.
What is annexure D?
Annexure D, my lord, it is a notice issued to prepare JMC.
It is issued by the ಭೂಮಾಪಕರು ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರ ಕಚೇರಿ ಕನಕಪುರ ತಾಲೂಕು ಕನಕಪುರ. Not the party to the proceedings, my lord, since the government has to consider the same.
In madam?
I'll assert time, because the file is also not given.
I seek for a date.
18.
Ask her which date is convenient to her. Because again it will be adjourned.
I'll secure the writ petition from him.
ನೀವ್ ಹೇಳಿ ಡೇಟ್ ಯಾವ ಡೇಟ್ ಹೇಳ್ತಿರೋ ಅದು ಹಾಕೊಳ್ತೀವಿ.
10 days.
18.
Like,
Number 49, Shri Vasant Kumar HT.
This is the second round of litigations, my lord. The one, I request for one indulgence, my lord, I require 10 days time. No, my lord, I am seriously objecting, not sufficient appeal has been given, my lord, this is covered by office court judgment, my lord.
He himself appears and take time 3 days, 4 days.
No, last second, this lordship was not sitting, it's called in quotal number 8, that's what it's urgent to today itself.
What is the next year, G?
Annexure G, my lord, is an endorsement issued to him demanding the sum of rupees 51 lakhs, my lord.
For what?
For payment, Junjama's case, my lord, Junjama's case, he had to be issued with the, here, alternative site, my lord.
Not all incentive site, not alternative site.
My lord,
My land has been acquired, my lord.
Junjama's case, my lord. Revenue site holders.
Yes.
That's the case, my lord, that's his case. So he has to be allotted an alternative site and we have to be, we have demanded a sum of rupees 51 lakhs. After the proceedings, after several proceedings, my lord, he has given representation, then he had to be considered and after considering allotment letter is given to him. my lord.
52 lakhs, ಯಾವ ಆಧಾರದ ಮೇಲೆ?
That is, as on the date of allotment, my lord, that's how they are fixed. I just want place on record my statement of objection, my lord. Because I need the signature of officers, my lord. What he is doing is,
As the land
ಅವರೇ
tax.
3
List.
days ಅವರು only one date may be fixed, my lord. On that day, I'll file and argue the matter.
19. 19. Number 50.
Both
Same.
of them, same.
Number 51, Shri Shiva Prasad Shattangoda.
Lord, serial number 51, I appear for the petitioner. I request for a short accommodation, my lords, in this matter.
I appear for the respondent, please. Number 52.
Obliged.
Shri Dayanand KG.
For respondent, my lords. The copy has been served today, my lords. Press time to obtain the necessary.
Number 53. Shyam Shekhar KH.
Kindly pass on.
What's after vacating?
My lords, this, my lords, we have filed on the last date of hearing, the Advocate General had appeared, my lords. And it was specifically agreed that it would be heard today, my lords. My lords, may please have it at 2:30, my lords?
2:30, I'll pass to.
2:30 minutes. Obliged.
I'll pass to 2:30, I have a hearing list, so therefore after that I'll take.
Please, deeply obliged.
Number 54. Shri
So
Suresh
I appeal
Babu.
for the petitioner, my lord. An extent of 700 square feet, my lord, was utilized by the BDA for formation of.
Out
100
for the
feet-
instruction from the BDM, my lords. May we
For
proceed
formation
after
of 100-feet road in the year 2014, my lord, till today, I am before the BDA requesting for an alternative.
My lords,
An
as
extent-
per his, my lords, in the year 2022 also, there are proceedings, my lords. Annexure F, page number 28, there are some proceedings is going on, my lord. I will secure instruction, I will submit, my lords. It may
Past
post
10
next
years,
week, my
I am
lord.
before the BDA, my lord.
My lords,
Let them at least pay the compensation or
to-
give me an alternative.
my lords, kindly turn to page number 28, my lords.
React bani ನೀವು correct.
Yes, my lords. It may posted next week, my lords, by then I will,
Immediately.
much of.
Number 55.
Lord, on 19th, Lord, 20th, I'm 19th. Obliged, please.
Much of.
I am filing memo saying that his land has not been utilized for expansion.
In prayer.
I am for the petitioner. I'll take one day time, my lord, I'll control. They say that it is not been utilized then, but
Day after tomorrow.
ಒಳಪಡುವುದಿಲ್ಲ ಅಂತ.
please.
Password ಎಷ್ಟು ಬಂದಿದೆಯಾ? 9 password. Nine. ಏನ್ ರಕ್ಷಿತ್ ಅಂತ ಹೇಳಿ.
Your Lordship, please to pass over that matter, 53, number 53, my lord. Can I request for tomorrow, my lord, if possible? My learned friend is here, my lord.
Tomorrow 2:30.
2:30 ಅಂತ ಹೇಳಲ್ಲ, tomorrow ಅಂತ ಹೇಳ್ತೀನಿ.
Tomorrow, please.
Madam, ಅದು 45 ಅಲ್ಲಿ 88 to place on record a copy of the award ಯಾವ ಇದ್ರದ್ದು? ಮೇಡಮ್ ಅಪಿಯರ್ ಆಗಿದೆ. 45. Award date ಹೇಳಿ.
Serial number 20 pass over ಆಗಿದೆ.
Sir?
Serial
With
So the plot
kind
is
leave of the
correct.
court, my lords.
Serial number
It's
11.
Serial number 19. Okay.
Serial number 11, my lord.
Which letter are you talking about?
Serial number 19, my lords, senior counsel's appearance may be first list, my lords, the morning. Sorry for that submission, my lords, but just a request. First list. Serial number 19. Senior counsel had appeared, my lords, his appearance may be noted. That's the only request. I'm sorry for the submission, my lords. It's highly obliged.
Number 7, my lord. 7, second list.
Time ಬಿಟ್ಟು ಏನೇನ್ ಬೇಕಾದ್ರೆ ಕೇಳಿ.
2 days time. ಇವತ್ತು ರೆಡಿ ಇಲ್ಲ ಸರ್. ನನಗೆ ಇವತ್ತು ಪರ್ಸನಲ್ ಇನ್ಕಮ್ ಬೆಳಗಿಂದ ಬೇರೆ ಮ್ಯಾಟರ್ ಇತ್ತು. 2 days.
ನೋಡೋಣ 2015 CRP.
ಅಲ್ಲ 2 days. ನಾನು ಇವತ್ತು ಇಲ್ಲ ಸರ್.
ನೋಡೋಣ ಇಬ್ರು ಒಟ್ಟಿಗೆ ಹೋದ ನಾನು ಓದಿಲ್ಲ.
ನನಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರ ಟೈಮ್ ಕೇಳಿದಾಗ 2 weeks ಅಂತ ಹೇಳಿದ್ರು. ಲಾಸ್ಟ್ ಟೈಮ್ ಅದರ್ ಸೈಡ್ ಟುಕ್ ಟೈಮ್.
Let us see.
ಒಂದು ಸಬ್ಮಿಷನ್ ಇಲ್ಲ. ಅವ್ರು 2 ವಾರ ಅಂತ ಕೇಳ್ತೀನಿ, ನನಗೆ 2 ವಾರ ಅಂತ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರು. ಅದಕ್ಕೆ ನಾನು ರೆಡಿ.
ಶುರು ಮಾಡೋಣ, ನೋಡೋಣ ಇರ್ರಿ ಒಂದು ನಿಮಿಷ. ಪ್ಲೀಸ್ ವೇಟ್.
ನಾನು ಶುರು ಮಾಡಿ.
ಪರವಾಗಿಲ್ಲ, ನೋಡೋಣ ಇಬ್ರು ಒಟ್ಟಿಗೆ ಶುರು ಮಾಡೋಣ.
ಅಲ್ಲ ದಯವಿಟ್ಟು ಅವ್ರು ನನಗೆ 2 ವಾರ ಅಂತ ಹೇಳಿದ್ರು.
Please wait.
Serial number 11, my lord, in list number 2, I have to make an application for impleading the state. I had informed the other side also, my lord, may I have it after 1 week, my lord. Serial number
The
11.
matter is reached, I'll make a note. Please wait.
Please.
Serial number 14, my lord.
My lord, serial number 9 in the second list, I appear for the petitioner. On record, counsel's father-in-law has passed away, Your Honor. Kindly grant a week's time, Your Honor.
Yes.
My lord, serial number 14, my lord. For the petitioner, my lord. Your lordship will list it next week, my lord.
ನೋಡೋಣ ಇರ್ರಿ 2014 10 ವರ್ಷ. Please wait, let us see.
Forward bench matters. Serial number 1, Sri Ram P. Gorpade. Forward bench matter. Serial number 2. Number 1, passed over matter. Serial number 9. Puneet.
Morning session, I was in the other court, my lord, I could not present. So, but I pray for a week's time, my lord, I have secured the record day before yesterday. I will file my former counter, my lord, and then my learned friend can argue.
ಅದೇನೋ ಹೇಳಿದ್ರಲ್ಲ ಅವರು.
But they say that, my lord,
Please, my lord, in connected matters.
and those are the cases, my lord, which were decided prior to passing of the award. Here, my lord, in this case, award is passed.
The notification ಸುಮಾರು ಜಮೀನು ಹೋಗ್ಬಿಟ್ರೆ ಇದನ್ನ ಏನ್ ಮಾಡ್ತೀರಾ?
My lord, only insofar as the petitioners therein was concerned, my lord. So,
Itself will go itself, isn't it?
and I am told that, my lord, in respect of this particular land, possession is taken and award is passed. Only endorsement which my learned friend is relying upon is annexure my lord, G, wherein it is says, my lord, there is no document, no documents are forthcoming to show that compensation is deposited. Only on that ground he is seeking for my lord, lapsing.
Surrounding lands are all quashed.
But I'll ascertain, my lord, if the entire scheme, my lord, is given up pursuant to the Honorable Court's order.
Give up or not, if you lost all the lands surrounding this area, what will you do?
My lord, if the other lands are developed, my lord, so I may have to. Otherwise,
Use the
my lord,
photograph, my
I'll,
lord, which it is still vacant.
The list.
about 10 days, my lord, sir.
Not in preliminary hearing itself, if I may request.
ಈ list ಹಂಗೆ ಬರುತ್ತೆ.
Please.
Please. Date 90. List number 2. Serial number 1.
ಕೈಂಡ್ ಅಲ್ಲ ಅವ್ರಿಗೆ ಥ್ರೋಟ್ ಇನ್ಫೆಕ್ಷನ್ ಆಗಿದೆ. ಡಾಕ್ಟರ್ ಅಡ್ರೆಸ್ ಓನ್ಲಿ 2 days. ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಇಟ್ ಅನ್ನು ತರಿಸ್ತೇ ಇಲ್ಲ.
ಟೈಮ್
ಅಲ್ಲಲ್ಲ ಇಲ್ಲ ನಾವು ಆರ್ಗ್ಯುಮೆಂಟೇ ಮಾಡಿಲ್ಲ. ನಮ್ದು ಇನ್ ಸೋ ಫಾರ್ as R3 is concerned, we have not started argument ಮೇಲೆ. ಅಲ್ಲಲ್ಲ ಅದರಲ್ಲಿ ಸ್ವಲ್ಪ ಸಬ್ಮಿಷನ್ ಮಾಡೋದಿದೆ. ತರಿಸ್ದಾಗ ಹಾಕೊಳ್ಳಿ. ಐ ಆಮ್ ನಾಟ್ ಚೇಕಿಂಗ್ ಮೇಡಮ್. ಇಸ್ ಬಿಕಾಸ್ ಡಾಕ್ಟರ್ ಹಸ್ ಅಡ್ವೈಸ್ ನಾಟ್ ಟು
Friday I said I will reserve it.
ಅಲ್ಲ
Because he said
ಅಲ್ಲ ಬಿಕಾಸ್ ಆಫ್ ಹೆಲ್ತ್ My lord, he is ready. Actually, yesterday also he was ready, my lord. Because of throat infection, could not speak. I request also my learned friend.
Arguments ಹಾಕಿ
ಅಲ್ಲ
ಸಾಕು.
Thursday submission ಮಾಡ್ತಾರೆ.
Now written arguments
ಅಲ್ಲ
ಹಾಕಿ,
ಅದರಲ್ಲಿ
I'll consider
we are
written
appearing for
arguments.
company, my lord. Therefore, I request, my lord.
Does it make whether it's company or not?
ಅಲ್ಲ ಅದರಲ್ಲಿ ಲಾಟ್ ಆಫ್ ಪ್ರಿಪರೇಷನ್ಸ್ ಆಗಿದ್ದಾರೆ. ಕೈಂಡ್ಲಿ ಓನ್ಲಿ 2 days.
File a written
My lord,
arguments.
ರಿಕ್ವೆಸ್ಟ್ ಮಾರ್ನಿಂಗ್ ಕೂಡ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರಿ ಕೇಳಿ.
ಇಲ್ಲ, ನನ್ನ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತೇನೆ, ಅವ್ರನ್ನ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ
ತಮ್ಮನ್ನು ಅಲ್ಲ ಗುರುವಾರಕ್ಕೆ ಹಾಕೊಳ್ಳಿ.
I'll reserve it, you file a
My
written
lord,
argument.
Thursday, my lord, kindly have it ಅಂತ ಹೇಳ್ತೇನೆ. Not, I will not,
Sir, brother.
I will not.
We have submissions to make.
ಮಾಡ್ಬಿಡಿ.
Thursday.
ಅವ್ರು ಮಾಡ್ಲಿ, ಅವ್ರ ತಾನೇ ಅವ್ರ ತಾನೇ ಅಕ್ವೈರ್ ಮಾಡ್ತಿರೋದು.
ಅಲ್ಲ
ಅವ್ರ
ಬಟ್
testimony
ಪ್ರಾಜೆಕ್ಟ್ ಪ್ರೊಪೋನೆಂಟ್ ಗೆ ನಾವಿದ್ದೀವಿ. ಪ್ರಾಜೆಕ್ಟ್ ಪ್ರೊಪೋನೆಂಟ್
ಅವ್ರ ಇಂಪಾರ್ಟೆಂಟ್ ತಾನೆ, ನಂಗೆ ನೀವಲ್ವಲ್ಲ.
ಪ್ಲೀಸ್ ಮೇಲೆ
ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿರೋದು ಅವರು.
ಇವತ್ತು ಅವ್ರದ್ದು ಗುರುವಾರಕ್ಕೆ ನಂಬರ್ರಿ. ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಅಲ್ಲ
ಮಾಡಿ ಸರ್.
ಲಾಟ್ ಆಫ್ ಪ್ರಿಪರೇಷನ್ ಆಗಿದ್ದಾರೆ ಸುಮ್ಮನೆ. ಯಾಕಂದ್ರೆ ಇನ್ನೇನಿಲ್ಲ, ಅದು ಸ್ವಲ್ಪ ದಯವಿಟ್ಟು
ನೋಡಿ
2 days.
ಅಲ್ಲ, ಅವ್ರದ್ದು ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ನನಗೆ ಇನ್ನು.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತು ಅವ್ರದ್ದು. ನಾನು ಅದನ್ನ ಲ್ಯಾಂಡ್ ಆಡಿಟ್ ಕಮಿಟಿ ರಿಪೋರ್ಟ್ ತೋರಿಸಿದ್ರು. ಅದ್ರಲ್ಲಿ ಬೈ ಕನ್ಸೆಂಟ್ ಬೇಸಿಸ್ ಅಂತ ಇದೆ. ಕನ್ಸೆಂಟ್ ಬೇಸಿಸ್ ಅಂತ ಆದ್ರೆ ನೀವ್ ಹೆಂಗೆ ನೋಟಿಫೈ ಮಾಡ್ತೀರಾ?
My lords, my lord, if that is the case, my lord, I can make submissions with reference to that land audit committee's, my lord, report. Can I pass on, my lord? The report that is, my lord, produced before your lordship is not the complete one. Some pages are missing there.
Only ಇವ್ರದ್ದು ಮಾತ್ರ produce.
ಅಲ್ಲ, ಅದರಲ್ಲಿ, my lord, the earlier part of the proceedings is very relevant for our case. My submission, my lord, with regard to consent is this, my lord. Consent acquisition is, my lord, something, my lord, which is.
The doubt that I had was you're not acquiring for industrial area. According to this proceedings, there's already a holding of about 120 acres by this private entity.
Yes.
Because they need some more land. You have been asked to issue for 28(1) notification. Whether that is permissible?
Yes, my lord.
To fill up the lacuna of private entities holding, you will be invoking eminent domain?
Lordship may kindly see, my lord, the object of the act is to be, my lord, appreciated. The object of the act is, my lord, to ensure that there is rapid and systematic development of industries in the state. My lord, land acquisition under the act is contemplated not only for forming industrial areas, but for also other purposes. My lord, other purposes is, my lord, for the purpose of developing amenities or industrial infrastructure facilities. So this is a case of that nature. As far as, my lord, acquisition for single unit is concerned, my lord, that is law is settled.
I'm not on that question of single unit. The proceedings indicate that they already have a substantial holding for their project. They were unable to acquire these 28 acres by themselves. So they come to you and you start acquisition proceedings. Isn't it? That is the sum and substance of.
Please, my lords, please, my lords. Why, my lord, this land is being acquired is also very relevant. Lordship may kindly see, my lord. No doubt, the project area consists of, my lord, 158 acres. 158.
It's not your project. It's not your project.
No,
You have nothing
it
to
is
do with
project of, my lord, third respondent, but, my lord, the project is approved by the single window agency, which is, my lord, my lord, a machinery created, my lord, under the Industries Facilitation Act for considering all industrial projects in the state of Karnataka. And, my lord, after considering the project, the committee, state high level clearance committee, my lord, considers all the, my lord, the specifications of this project and approves the acquisition of land.
Where is the approval?
Approval, my lord.
Let us see his application. Let us see the proceedings of the state high level committee.
Due to the respondent number 4, Karnataka Ejectment, which is the state high level clearance committee, I've prepared a memo along with the proceedings. The application form.
It has a SHLCC clearance?
Yes.
Give me one copy.
You have the application that he has submitted and also the proceedings?
Yes.
Industry specialization.
ಗೊತ್ತು ಅದಲ್ಲ ಇದು ಬೇರೆ
ಇದು ಬೇರೆ ನಾವು ಹಾಕ್ತಾ ಇರೋದು ಬೇರೆ. Lordships find it at page 72, item number 9, my lords.
Even this says through consent acquisition.
Maybe, my lord, I will submit with reference to my lord consent acquisition.
So there
Consent,
is no, therefore there is no order directing you to acquire it under the powers of the KDB Act.
no, my
We do
lord.
not say that acquire it under the provision of the KDB Act.
My lord, it is always acquisition is under the KID Act only, my lord, even for single.
Under the Act, you have the power to acquire it by yourself also. You can directly purchase.
That's what, my lord.
Therefore, not necessary that every land should be acquired under
We-
section 28.
My lord, lordship may kindly see, my lord. 128 acres is, my lord, their own land, but this land is, my lord, scattered in the project area. And one of the lands is the entrance to go to the project area. And, my lord, when there was, my lord, no possibility of any settlement and, my lord, getting those lands, it appears the third respondent approached the government, my lord, requesting to clear the project as well as approve the project with a direction to acquire the land by the KIDB. That is how, my lord, it has been done. My submission with reference to, my lord, the expression consent is, my lord, something different, my lord. My submission, my lord, it is really, my lord, a word which according to me, my lord, is used only to indicate that there shall be payment of compensation by way of consent or by way of agreement. That is the only meaning is, my lord, what I want to submit. And my submission is, my lord, supported by one or two, my lord, documents also that are on record. Can I request, my lords, to kindly take?
This is a proceeding conducted under the Industries Facilitation Act, isn't it? This is a proceeding conducted under the Industries Facilitation Act.
Yes, yes. That entity is.
What is the power of this committee to direct acquisition?
Well, our committee is constituted to approve the project with its recommend.
Where is the act?
Yes. Section 3, your lordship may kindly take. The state government may by notification constitute a single point clearance committee called State High Level Clearance Committee under the chairmanship of the Chief Minister, consisting of such members as may be specified therein. The committee shall examine and consider the proposals received from any entrepreneur relating to any industrial and other projects to be set up in the state with an investment of rupees 500 crores and above in each case. Member of the committee shall personally attend the meeting, and in case he is unable to attend the meeting, he may depute a senior level officer to attend the meeting with a written authorization to take appropriate decision in the meeting. Functions of the committee. The committee shall meet at such times and in such places and shall adopt such procedure to transact its business as may be prescribed. The committee shall examine the proposals for setting up any industrial undertaking referred to in subsection 2 of section 3 and shall take a decision and communicate its decision to the entrepreneur and the concerned departments or authorities within such time as may be prescribed.
So this is approval.
Concerned departments is not the word.
Then let us see 5.
Yes, Lord. The committee shall be the final authority in granting approvals for the proposals placed before it. The approvals given by the committee shall be binding on all the concerned departments or authorities, and such departments or authorities shall issue the required clearances within the stipulated time and subject to compliances by the entrepreneur undertaking of the provisions of the applicable central or state acts.
What is this clearances? It is defined.
Clearances, my lord, your lordship will find in this order. government order, your lordship may kindly take.
No, kindly come to the definitions, clearances. And it talks about applicable acts. So if the committee were to grant approval, that means the clearances, the approvals that is required under the applicable acts are granted by the committee.
Yes, my lord.
That is all. This can't be an authority to direct acquisition.
My lord, acquisition, my lord, is necessary because
It may be necessary, but what is the role of this committee? Kindly look at the preamble of the act.
yes, sir. In consideration, it is considered necessary to provide for the promotion of industrial development and facilitation of new
Preamble, an act to provide for promotion of.
Yes, by reducing procedural requirements and rationalizing documents and to provide for an investor-friendly environment in the state of Karnataka. The bill, among other things, provides.
The preamble, an act to provide for the promotion of industrial development and facilitation of new investments.
Yes.
To simplify the regulatory framework.
Yes.
By reducing procedural requirements and rationalizing documents and to provide for an investor-friendly environment.
Yes, sir.
So instead of going to each department asking for approvals, this committee is constituted whereby they will look at your project and if they approve it, all the clearances required under the applicable acts are deemed to have been granted. How can you use this to say that there's a direction to acquire?
Lordship may kindly see, my lord. Single window system is, my lord, a machinery created for clearing, my lord, the projects which contains several approvals to be granted by the government.
No, it is applicable acts is also defined. Whatever approvals are required under these applicable acts.
Yes, sir.
If the project is approved, it is deemed to have been granted. You don't have to go to every department and ask for such an approval.
That's what, my lord.
How is this?
That is the only, my lord.
How is this relatable to the power to issue a direction to you to acquire?
Lordship may kindly see, my lord. The project requires lands. The basic requirement of the project is, my lord, land. And when the project is approved by the state or the my lord, single window clearance committee, it has to, my lord, provide for the lands also. That is why I requested you.
Under this act, you may do whatever you want by yourself. Under the act, your entire basis is this SHLCC committee's decision.
No.
The power of this committee is regulated by the provisions of this act.
Yes.
If you can point out from this act that while giving clearances, they can direct you to acquire, I'll accept.
That's what section 5 says. All the clearances are binding on the, my lord, authorities.
Let us read the definition of clearances once again.
Section 5, my lords. The committee shall be the final authority in granting approvals for the projects placed before it. The approvals given by the committee shall be binding on all the concerned departments or authorities, and such departments or authorities shall issue the required clearances within the stipulated time and subject to compliances by the entrepreneur undertaking of the provisions of the applicable central or state acts and the rules made thereunder.
So therefore, if they approve the project, whatever clearance is required, the departments are bound to give it.
Yes, ma'am.
There is no question of satisfying them afresh.
Yes, sir.
Because there's one principle approval by this committee.
Yes, ma'am.
How can you relate this to the power to acquire?
My lord, power to acquire is not, we are not saying that power to acquire is exercised by, my lord, the single window agency.
What basis? On the
My
basis
lord,
of
this is the basis on which, my lord, the KIDB is going to initiate land acquisition proceedings. My lord, that is why on the basis of this clearance, the board has deliberated on this.
Clearance is in respect of the applicable acts, isn't it? Clearance is not to acquire. You don't require a clearance to acquire. You require a clearance under the specific act for them to start an industry, under the Factories Act or under whichever act. That they're giving it to a single place. How can you use that to say that this is the direction to acquire?
Can I clarify this, my lord? The acquisition under the act is of two types, my lord. One is for development of industries and another is for, my lord, development of infrastructure or in favor of single unit complexes. That is, my lord, the way in which, my lord, land is acquired under the KID Act. As far as, my lord, the development of industrial areas by the board on its own, there is no need for any clearance because the board can itself do it. When, my lord, it is a matter of acquiring land for a single unit complex or for one entity, then comes the issue on what basis we have to initiate the acquisition proceedings. So this single window system has been, my lord, put in place by the state to consider such proposals and grant clearances. And, my lord, the
ಆಕ್ಟ್ ಹೇಳ್ಬೇಕಲ್ವಾ ಅವ್ರು ಏನಾರ
ಅಲ್ಲ ಅದಕ್ಕೆ ನಾವು ಏನ್ ಮಾಡಿದ್ವಿ ಈಗ ಮುಂದೆ ಏನಾಯ್ತು ಅಂದ್ರೆ ಕ್ಲಿಯರೆನ್ಸ್ ಆದ ನಂತರ ದ ಬೋರ್ಡ್ ಹ್ಯಾಸ್ ಪಾಸ್ಡ್ ಎ ರೆಸೊಲ್ಯೂಷನ್. Board has passed a.
The resolution, the basis of the resolution is this particular clearance.
Yes, that is.
This committee had no jurisdiction at all to say acquire. How can you initiate acquisition proceedings? But for this decision of the committee, you would never have passed a resolution. It is for you under the act to independently think, I want to establish industrial area or an infrastructure amenities, therefore I will invoke my powers under chapter 7. That is one thing. Now, if you were to say that I did this only because of SHLCC, then.
Lordship may kindly permit me to make this submission, my lord. There must be some basis for the board to initiate land acquisition proceedings. And, my lord, as far as initiation of land acquisition proceedings on the basis of recommendations of the single window agency, my lord, the law is settled. My lord, right from BPL, my lord, case, the apex court has held that single window agency system is a system which enables the board to acquire and allot the lands in favor of different entities, and, my lord, that has been, my lord, the law that is being, my lord, considered altogether. Here is a case where, my lords want to know from me whether you can acquire a portion of the land required for the project when the other portion is not the subject matter of land acquisition. My lords, my submission is that the land acquisition of this particular extent has become necessary only because the owners were not ready to, my lord, part with their lands, and the project was to be, my lord, implemented. So the project has been approved, and, my lord, one of the recommendations or, my lord, decisions taken by the committee is to go ahead with the land acquisition proceedings. After that, what the board has done is, my lord, it has passed a resolution and it has decided to acquire lands in favor of, my lord, several entities, including the present one. And that is how, my lord, the acquisition has started. And in my respectful submission, my lord, I will refer to, my lord, BPL case where the apex court has considered all these issues. Judgment. Huh? ಎಲ್ಲಿದೆ? ನಮ್ಮ ಹತ್ರ ಇದೆ. ನಮ್ಮ ಹತ್ರ ಇದೆ.
Which is the para which relates to acquisition by virtue of a clearance from this committee?
BPL case. ನಮ್ಗೆ ಕಾಪಿ ಬಿಟ್ಟು ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರಲ್ಲಿ ಆಫೀಸ್ನಲ್ಲಿ.
ನಾವು ತೋರ್ಸಕ್ಕೆ ಅಂತ ಕೊಟ್ಟೆ ಅದಕ್ಕೆ ಬೇರೆ
ಕಾಪಿ citation.
This was a case in which allotment, the lands were already acquired by KADB, and for that they sought allotment.
Yes.
That is not the case here. So how can this BPL case be of any relevance? It was a public interest litigation where the KADB had acquired vast tracts of land, out of which an application was made by BPL for allotment, and you granted the allotment.
But I am on the point of, my lord, the decision-making powers of single window clearance committee. And, my lord, what the apex court in that case has held is that single window system has the, it has come to stay.
I am with you. The act, the moment you grant an approval, clearances are granted.
Yes.
But how can you deduce that you have that they have given you the dictum to acquire?
And after that, my lord, Narayanappa.
It may so happen that you may already have an industrial area acquired. Then they may say allot. That may also be within their power. But to acquire land.
But, my lords, your lordship may kindly see, my lord, there is, that's why I submitted, acquisition happens in two ways or for two purposes. One for the purpose of development by the board itself, or for other purposes. Other purposes include not the requirements of single unit complexes. And my lord, after this, and I would request your lordships to kindly take my compilation. On this, my lord, issue, there are three decisions starting from 1974 of our own High Court, where the court has said that we can acquire the lands for even a single unit. And we can also receive advances or deposits from them to defray the expenses of acquisition. That is, my lord, 1974, Karnataka, KLJ, page number 71, my lords.
Yes.
Heggappanavaru Markandappa, paragraph number 5.
The court upheld the move of the KDB to negotiate with you even before acquisition proceedings under this judgment.
Yes.
And this was before the 2003 Act came into force. That Industries Facilitation Act came into force.
Yes, earlier to, my lord, Industries Facilitation Act, my lord, all these issues were covered by an executive order.
We are concerned after 2003.
Yes, yes.
So after 2003 judgment is recorded regarding
Alla,
relation to the Industries Facilitation.
ಅಲ್ಲ 2003 ಗಿಂತ ಮೊದಲು ಇತ್ತು, ಅದರ ನಂತರದಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, ಅದನ್ನೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. And my lord, your lordship may kindly take the next decision is also 1997. If your lordship my lord want me to take to
More keen on judgments rendered in context of 2003 Act. The other act, the other judgments of the earlier period may not be relevant for the argument that.
lordship may kindly see, my lord, earlier to 2003 single window system was there, but that was there, my lord, by way of an executive order. It was not, my lord, made into a law, and that was being operated by KIDB for acquisition of the lands. That is what has been discussed in 1997, my lord, Karnataka law.
The simple argument is SHLCC has the right to give you a direction and you have acted accordingly. Ashte alva?
My submission is this, my lord. My submission is this, that the single window clearance committee has the power to approve the projects and make its recommendations to KIDB in the matters of land acquisition. And
has the power to approve the projects and make its recommendation in the matter of land acquisition.
yes, my lord.
Yes.
Can I request my lords to kindly take page number 6 of my compilation, my lord, wherein a specific question with reference to single window acquisition was also framed and
ಎರಡು compilation ಕೊಟ್ರಿ ಯಾವ್ದ್ರಲ್ಲಿ?
ನಂದೇ ಈಗ ಲೇಟರ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದು, ನಂತರದಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು. Para number 8, my lord, page number 424, that will be index page 12, my lords. With index page 13, my lord.
Regarding question number 2.
Yes, ma'am.
Para 10 alva?
Question number 1 only, my lords. Question number 1 only.
Yes.
Can I request your lordships to kindly come to my lord in 424, page number 424 of the decision, that is index page 13, my lords.
Which?
My lords, index page 13, your lordship may take.
Yes.
The scheme and provisions of the act, your lordships got it. No? The scheme and provisions of the act do not, in my opinion, suggest that an area can be deemed to be an industrial area or an industrial estate only if more than one industrial unit are established within the same. it is possible, in my opinion, for even a single industrial unit to constitute an industrial estate. That is because the definition of the term industrial area is wide enough to include an industrial estate also. To the same effect is the view taken by Malimat J. in Heggapanavar Markandappa and others versus State of Mysore and others, where his lordship has observed as under. As long as the acquisition of the land is for the purpose of the act, that negotiations were made with individuals concerned before taking steps for acquisition under the act cannot by itself be regarded as a circumstance justifying an inference that there has been a fraud on power. The essential question to be determined is as to whether the acquisition is really for the purpose of the act or it is only a camouflage for achieving some other object. As already mentioned, a notification was issued by the state government declaring the area in question as an industrial area. The lands were acquired for the purpose of establishing an industry. The expression industrial estate means any site selected by the state government where the factories and other buildings are built for use by any industry or class of industries. Even if a particular place, a single industry is established, the same would answer the definition of the expression industrial estate as defined in section 27 of the Act. The preamble itself clearly states that one of the objects of the Act is to promote the establishment and orderly development of industries in industrial areas. If therefore the lands in question were acquired for the purpose of establishing an industry by Harihar Polyfibers with a view to secure a planned and orderly development of industries in that particular area, it cannot be said that the action taken for acquisition of the lands amount to fraud in power. Question 1 is answered accordingly.
I have no problem in accepting the fact that it can be, your act can be used to acquire land for one single entity. I have no doubts about that at all. So all these judgments really do not help the point that you're trying to make, that the SHLCC is a committee which can direct you to make a
Yes,
recommendation.
my lord. Latest judgment of the apex court is there, my lord. MSPL case. Before that, I wanted to take your lordship to 2006 also, where, my lord, acquisition was, my lord, for a
I'm with you on that. You can do it. There's
Yes,
no
sir.
difficulty about it.
My lords, my submission is this, my lord. It is only an input. The clearance of the single window agency is only an input for the board to initiate land acquisition proceedings. My lords may kindly appreciate that the power is always available to the government to initiate acquisition proceedings. What is the basis for acquisition is, my lord, something that has to be considered. If your lordships, my lord, go to the General Land Acquisition Act, we have this part 7 of the Land Acquisition Act, which provides for acquisition for companies, and it lays down a procedure, my lord, of making agreement and, my lord, report, etc., etc. Only after satisfying that, my lord, the final notification can be issued under that act. Here, my lord, it is, my lord, a simplified procedure of acquisition for the purpose of industries or industrial estates or, my lord, industrial units. Board, my lord, requires some, my lord, inputs for the purpose of initiation of land acquisition. For that purpose, my lord, the single window clearance, my lord, is going to be used as, my lord, one of the inputs for initiation of land acquisition. And, my lord, why, my lord, what happens thereafter is also to be considered, my lord, to understand whether the single window clearance can be actually a matter for the board to consider. You will also make kindly, my lord, only on the basis of, my lord, the single window clearance, the board or the government are not going to acquire the land, my lord, for a single unit. We have to, my lord, follow the procedure prescribed under section 28 in spite of, my lord, a clearance being there, because that is the statutory requirement, my lord. That is how, my lord, in spite of single window clearance, the board is obliged or the government is obliged to, my lord, take recourse to the land acquisition process under the KID Act. So the question, my lords, are asking is whether the single window clearance is binding on us. My lord, section 5 says that it is binding on us, and, my lord, it's not a case where, my lord, the powers of the single window clearance committee are in question, my lord. Yeah, para. Lordship may kindly now take this, my lord, MSPL case. Just equal to one day copy. Para number 22, my lords. In this case, my lord, the issue was whether the land acquisition can take place for a single unit on the basis of clearance also. I am reading, my lord, the para 22, my lord, with lordship's permission. In the present case, as stated in the chronology of events, the MSPL had initially moved an application under the 22, my lords. Sorry, I don't have the page number.
22.
In the present case, as stated in the chronology of events, the MSPL had initially moved an application under the 2002 Act. During the consideration of the said application by the state government, MSPL shared its projects of two industries by inducting AISL, a fully owned subsidiary of MSPL. The introduction of AISL was accepted by the state government and necessary applications were given by AISL. The SHLC had earlier approved both the projects, and one of the recommendations was for acquisition of land under the 1966
That is
Act.
what? There was a recommendation of acquisition under the 66 Act.
66.
Specifically. Here it is not under the 66 Act. They simply say consent acquisition. So you can't import these words and say, no, I have now been granted the power or the recommendation to invoke the provisions of the Act.
Lord, your Lordship will also appreciate that the clearance says that acquisition is to be by the KIADB. KIADB will not acquire the land, my lord, under any, my lord, enactment
This
except,
judgment-
my lord.
This judgment, the recommendation.
Yes.
Your argument is not to that effect.
No, I am saying that
Section 5 binds you.
my lord,
The recommendation which you may or you may not accept.
Lords, may kindly see, my lord. It is a recommendation by the board is my submission also. My lord, your lordships asked me how actually you can acquire on that basis. That is why I referred to section 5. My lords, it is an input, my lords, for the board to, my lord, apply its mind and take a decision as to the requirement of initiating acquisition proceedings. Yeah.
Yes.
Then, my lords, para 23. Then KIDB consider the recommendations of the SHLCC, Karnataka Udyog Mitra and the state government, and accordingly acquired the land as per the procedure prescribed under section 28 of the 966 Act. It is this acquisition of land for MSPL and AISL which is under challenge in these proceedings. The division bench, having quashed the acquisition, as also notifications under sections 1(3) and section 3(1) along with section 28 of 1966 Act is now for consideration in the present appeals. Now, my lord, your lordship may kindly come to my lord number 4. Whether the acquisition for single company could be said to be.
I am with you on that.
Yes.
You won't have to.
Yes, my lord. So my submission to your lordship is this. After the recommendations, the board has considered, my lord, the project, and it has passed a resolution. Then, my lords, your lordship may kindly take 2 documents that I have filed today.
Compilation with the judgments.
Staple ಮಾಡಿ ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್ 4/3 ಡೇಟ್ ಇದೆ ಒಂದು 2 ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ರಿ ಈಗ
ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಕೊಟ್ರೆ ಅಷ್ಟೇ
ಕೊಟ್ಟಿ ಏನಪ್ಪ ಕೊಟ್ರಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್
ಅವ್ರು ಕೊಟ್ಟಿದ್ರು
ಪ್ರದೀಪ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಲ್ಲ ಇವ್ರು ಕೊಟ್ಟಿದ್ದು.
Page number?
My lord, your lordship may kindly come to page number 19.
Yes.
This is, my lord, meeting number 274 dated 1/7/2006.
What is this?
Karnataka Kaigarika.
The project snapshot ಅಂತಾನೆ ಅದು. ಅದ್ರದ್ದಲ್ವಾ ಇದು? This is a part of that patch at page 13.
ಅಲ್ಲ ಬೋರ್ಡ್ ರೆಸಲ್ಯೂಷನ್ ಇದೆ.
ಇನ್ನೊಂದು ಮೆಮೊ.
ಈಗ ಇನ್ನೊಂದು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇರೋದೇ 2 ಮೆಮೊ ಕೊಟ್ರು ಅಷ್ಟೇ.
ಚಿಕ್ಕದಿದೆ. ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 19.
Number?
19, my lords.
Yes. Statement showing the list of proposals cleared.
ಅದಕ್ಕಿಂತ ಮೊದಲಿನ ಪೇಜ್ ಕೊಡ್ರಿ. ಕರ್ನಾಟಕ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿಯಿಂದ ರಾಜ್ಯದಲ್ಲಿ ಏಕ ಘಟಕ ಸಂಕೀರ್ಣಗಳಿಗೆ ಜಮೀನನ್ನು ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುವ ಬಗ್ಗೆ ಪ್ರಸ್ತಾವನೆ. ಕೈಗಾರಿಕಾ ಪ್ರದೇಶಗಳಿಗೆ ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳಬೇಕಾದ ಜಮೀನುಗಳಲ್ಲದೆ ಏಕ ಘಟಕ ಸಂಕೀರ್ಣಗಳಿಗೆ ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳಲು ಗುರುತುಪಡಿಸಿರುವ 22 ಪ್ರಕರಣಗಳ ಪಟ್ಟಿಯನ್ನು ಅನುಬಂಧದಲ್ಲಿ ತೋರಿಸಲಾಗಿದೆ. ಏಕ ಘಟಕ ಸಂಕೀರ್ಣಗಳಿಗೆ ಬೇಕಾಗುವ ಜಮೀನನ್ನು ಸ್ಟೇಟ್ ಹೈ ಲೆವೆಲ್ ಕಮಿಟಿ ಹಾಗೂ SLSWCC ಯೋಜನೆಗಳಿಗೆ ನೀಡಿರುವ ಅನುಮೋದನೆಯ ಪ್ರಕಾರ ಭೂ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆ ಪ್ರಾರಂಭಿಸಲಾಗುವುದು.
That's why I said the SLSWCC did not give approval. The SLCC gave approval only for acquisition by consent.
Consent I will not come to.
Your entire basis is on a misconception that there was an approval for acquisition.
No, acquisition, my lord, as I submitted, acquisition, my lord, approval, my lord, is of the project and the project requires lands.
When granting approval to the project, like you said in the other case, the recent case, they may make a specific recommendation to acquire the lands under the 66 Act. But here in this instant case, it is specific. Therefore, you can't again go back and say, this is giving me the power to exercise my power of eminent domain.
Lordship may kindly see, my lord, the recommendation is to acquire lands and give it to, my lord, respond number 3.
Your understanding.
My lord, your lordship,
Going 2 steps ahead of the committee. Committee never thought in your lanes.
ಇಲ್ಲ ಐತಲ್ಲಪ್ಪ ಅದು ಎಲ್ಲ ಐತೆ ಇಲ್ಲ ಇಲ್ಲ ಇದೆ ಅವ್ರು ಕೊಟ್ರಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದರಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಆರ್ಡರ್ ತಾವು ತಗೊಂಡ್ರೆ ಇದರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವರು ಸಿಂಗಲ್ ವಿಂಡೋ
ಯಾವ ಗೌರ್ಮೆಂಟ್ ಆರ್ಡರ್?
ಪೇಜ್ 74 is the government order. ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ಏನ್ ಮಾಡ್ತೀವಿ 74 ಅಂತ ಹೇಳುತ್ತೆ ಸ್ವಾಮಿ. ಇದು 74 ಇರ್ಲಿಕ್ಕಿಲ್ಲ ಇದರಲ್ಲಿ, ಏನು ನಮ್ಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವರು. ಇದರಲ್ಲಿ Lordship may kindly see this.
ಹೇಳ್ತೇನೆ ನೋಡಿ, before the KADB initiate consent acquisition.
Consent ಬಗ್ಗೆ ನಾನು
committee should scrutinize the land requirements and that it should ensure that is consistent with the zoning regulation of the BDA. So this is not the government order permitting you to acquire. They are saying for consent acquisition also, you should take the decision of the what is this? Land audit committee. Thereafter, you can undertake consent acquisition. So if they don't grant you approval, you can't go forward at all.
That is there, my lord. Approval is there.
No, for consent acquisition, not for acquiring the lands under the act.
Lord, consent acquisition, Lord, I'll explain to you, Lordship, Lord. I am on the first point. Lord, what I want to, my lord, submit on the basis of this document is this. This document, my lord, approves the project of third respondent in an area of 158 acres. That is the first thing. Second thing, my lord, it says that before the Karnataka Industrial Area Development Board initiates consent acquisition, the land audit committee should scrutinize the land requirement and that it should be ensured that it is consistent with zoning regulations of the Bangalore Metropolitan Regional Development Authority. So after this, the matter goes to the land edit committee, my lords. Land edit committee, my lord, report or proceedings are also given to your lordship, my lord, just now. Isumir. The document I have, my lord, given today along with memo. Your lordship just saw the resolution of the board.
Page number 6, huh?
Resolution ಅಲ್ಲ ರೆಸಲ್ಯೂಷನ್ ಗಿಂತ ಮೊದಲು ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ
There,
ಇದೆ ಪೇಜ್ ನಂಬರ್ 2 ನಿಂದ ಶುರು ಆಗುತ್ತೆ ನನ್ನ
land audit committee starts at page number 2.
yes my lords. Proceedings of the third land audit committee meeting held on Wednesday so and so at 3 so and so. My lord, what I want to, my lord, submit to your lordship, my lord, on the basis of these proceedings is this. My lord, issue of consent. Consent, my lord, in my humble submission, does not mean that, my lord, there should be consent for initiating land acquisition proceedings. What, my lord, the consent means is this. Consent means the method of payment of compensation shall be by way of agreement. That is the only inference that
There is no consent for payment of compensation. It will fail.
my lord, it doesn't mean that, but it only, my lord, means that there should be settlement of compensation by agreement.
No settlement.
Yes,
Then according to acquisition should fail.
my lord, meeting will not fail because your lordship may kindly see, in spite of this, my lord, the government has issued 28(1) notification, my lord, after this date only.
We'll come to the notification afterwards.
Yes, sir.
You are now trying to contend that consent acquisition means only regarding the consent for the compensation. So if there's no consent for the compensation determined, then there's no agreement, there's no acquisition at all.
My lord,
That will not.
my lords, your lordship may kindly see, my lord, acquisition is different and, my lord, the payment of compensation is different. And, my lord, acquisition, my lord, happens, my lord, it reaches finality even before payment of
Land
compensation.
audit committee, the SHLCC committee are specialized bodies. When they use a particular term, we'll have to follow that. We cannot interpret it in our own way. They would have simply said acquire it under the 60s as in that case. When they specify both the land audit committee as well as the SHLCC committee that it shall be consent acquisition, how can you even invoke section 13 or 28?
My lord, my submission is this, my lord. The land audit committee's proceedings themselves are clear to support my submission that, my lord, the consent acquisition is relatable to compensation by way of agreement. That is why I want to read, my lord, certain portions. Paragraphs 1, 2, and 3 of this, my lord, proceedings. That may help, my lord, in
Yes.
understanding that. Kindly come to, my lord, para number 1, page number 3. It was very, my lord, at a very, this land audit committee was constituted, my lord, just
No statutory force.
2, 3, that's what it says. That's what, my lord, the proceedings also say. It was a very recently constituted, my lord, committee at that point of time. It was the third meeting of that committee. That's why they always, my lord, they in fact say that the committee is not guided by any fixed rules or, my lord, guidelines. That's what it says. Para number 1. Land audit committee is a recent creation to vet requirements of land required.
Read from the beginning, initially.
Yes, initially the members of the committee had discussions in the context of certain issues raised by the Principal Secretary Revenue Department relating to policy framework for determining extent of land for different industries and also the need to impress on the applicants that they can take recourse to section 109 of the Karnataka Land Revenue Act to purchase lands in open market. The Principal Secretary to Government C&I Department clarified certain issues as follows. Land audit committee is a recent creation to vet requirements of land requirement by investors, entrepreneurs in Bangalore, Mysore, and Mangalore districts in the event they wish to take recourse to acquisition under KIAD Act. While it could be very desirable to encourage entrepreneurs, investors to seek clearances under section 109 to purchase lands for different industrial purposes, the problem of doubtful titles to land requiring extensive due diligence especially in and around Bangalore, was driving prospective entrepreneurs to take recourse to acquisition route through KIDB, as this method ensured a clear and valid title. Sometimes landowners also sought to seek acquisition route for part of the lands integral to their requirements due to difficulties experienced in purchasing the same. However, in single unit acquisition, KIDB was following a policy of acquisition through agreement as to ensure landowners get the market value for the lands without recourse to litigation, etc. Besides, conditions of allotment of KIDB was such that the allottee will have to put the land to use to the purpose intended, else the allotment could be cancelled and land resumed. While there was admittedly no laid-down policy to guide the committee as yet, TechSoc had developed certain indicative guidelines for requirements of different industries, and it was the Land Audit Committee which would have to factor in the experience gained from dealing with individual cases and develop a coherent policy in due course. So far, the Land Audit Committee had only 2 meetings. So, para 2, my lord, clearly refers to the process. It says that KIDB route is actually required only to ensure hassle-free land acquisition proceedings and early settlement of compensation payable to the landowners, that too by agreement. So, my lord, the consent acquisition or, my lord, the expression which is used there may not strictly mean that, my lord, for issuing preliminary notification also there should be consent. Because, my lord, the very nature of land acquisition, as you lordships know, my lord, is compulsory acquisition, which is antithesis of, my lord, the consent. Consent will not be there in any land acquisition. What is required is not a public purpose or a purpose which, my lord, satisfies the requirement of law. That is what, my lord, I want to submit. So,
according to consent acquisition means acquire under the KIDB Act. That is long and short of it. That is your argument.
Yes, this is one limb of my argument, and the other limb is, my lord, your lordship may kindly see the resolution of the board.
Yes.
Resolution of the board also does not, my lord, say that it is to be a consent acquisition only. So,
not concerned about your resolution. The entire basis even for your resolution is this decision of the committee. It is not independent. If suppose there is no reference to the decision of the committee, you're right. Your entire resolution is based on that particular committee's decision only.
lordship may kindly see, my lord, this is with reference to 22, my lord, industries, and, my lord, the respond number 3 is one of the industries which is, my lord, listed there at serial number 7. And, my lord, when, my lord, such a large number of industries required land and it was decided to go for acquisition in favor of all these companies, my lord, the board has definitely, my lord, taken into consideration the requirements. And, my lord, the other decision is with reference to, my lord, public purpose. Public purpose, my lord, it appears, my lord, a submission was made that there is no public purpose. My lord, public purpose is held to be a purpose which benefits the public at large, and that is to be considered as a public purpose, even though the acquisition is for a single unit. My lord, this is a project, according to the, my lord, project report, which seeks to provide employment to a large number of people, and almost, my lord, at that time 500 crores investment in the state. So that is, my lord, a public purpose for which the land is being acquired. And further, my lord, single unit, my lord, acquisition, as my lords observed just now, is also recognized, my lord, by the law. And, my lords, this is Pratibha Nema's case. My lord, your lordship, can I request my lords to kindly take my compilation, citations, list of citations. This is Mr. Pradeep Kumar's compilation.
Page number?
Page number 40, my lords.
40.
Yes.
Yes.
Can I request my lords to kindly come to paragraph number 19, page number 44.
Yes.
These decisions establish that a public purpose is involved in the acquisition of land for setting up an industry in private sector, as it would ultimately benefit the people. However, we would like to add that any and every industry need not necessarily promote public purpose, and there could be exceptions which negate the public purpose. But it must be borne in mind that the satisfaction of the government as to the existence of public purpose cannot be lightly faulted, and it must remain uppermost in the mind of the court. Then your lordship may kindly come to the next decision. Page number 49, your lordship may kindly. Can I request my lords to kindly come to para number 10 on page 52, my lords. Yes. Be that as it may, it cannot be gainsaid that providing access to the temple is not a public purpose. The exercise of power under section 4(1) of the Act, therefore, is neither colorable nor mala fide. It is true that this court in Tata Cellular versus Union of India by a bench of 3 judges, considering the scope of judicial review of the administrative action, grant of license by tenders, held that the administrative actions of the state or its instrumentalities are amenable to judicial review. As mentioned earlier, when the state governments have exercised the power under section 4(1) for the public purpose, and the public purpose was mentioned therein, the exercise of the power cannot be invalidated on grounds of mala fides or colorable exercise of power, as the public purpose is shown and the land is needed or is likely to be needed, and the purpose subsists at the time of exercise of the power. It is primarily for the state government to decide whether there exists public purpose or not, and it is for this not for this court or the high courts to evaluate the evidence and come to its own conclusions whether or not there is a public purpose, unless it comes to the conclusion that it is a mala fide or colorable exercise of power. In other words, the exercise of power serves no public purpose or it serves a private purpose. My lords, may kindly also see the next paragraph, my lord, which is also relevant in this case. There, my lord, there were negotiations that were unsuccessful before initiation of the land acquisition. My lord, the apex court approves that also, my lord, that it can be resorted by way of compulsory acquisition. It is true that an attempt was made on an earlier occasion to purchase the property by negotiation, but it was turned down by the charity commissioner and refused to grant permission. Consequently, the trust was constrained to approach the government requesting it to acquire the land. The government did not consider the circumstances and exercised the power. The Act does not give power to negotiate by private sale or even during pending acquisition proceedings. Negotiations by private sale could be made in the event the need to determine the market value under the Act would be obviated, and compensation would be determined in terms of agreement reached between the land acquisition officer and owner of the land or person having an interest in the land, subject to the prior approval of the government. Therefore, the failure to purchase the land by negotiation and exercise of the power under section 4(1) thereafter by no stretch of imagination be considered to be a mala fide or colorable exercise of the power. Therefore, we do not find any infirmity or illegality in the notification published under section 4(1) warranting interference. ಯಾವ್ದಿದು? Para number, I think, para 30. Then I am told that, my lord, contention was raised that simultaneously 3113 and 28(1) notification cannot be issued, my lord. I don't need, my lord, to stress on that. The other thing is, my lord, the question is whether acquisition of land amounts to deprivation of right to livelihood under Article 21. That has also been, my lord, answered in Chameli Singh's case, because, my lords, that is also, my lord, one of the citations, my lord, that I have relied on. There, the apex court says that since the land acquisition is subject to payment of appropriate compensation, that is settled. So here also, my lord, out of 7 or 8, my lord, petitioners who had approached the court challenging land acquisition, almost all have, my lord, agreed for receiving the compensation, and, my lord, they have withdrawn the writ petition. And here are, my lord, only these are the only 3 cases where, my lord, the acquisition is, my lord, being seriously, my lord, challenged. And, my lord, this is
The total extent that they own?
12 acres. 12 acres, something,
12 acres.
out of
All
20,
3 of them.
29.
Roughly half.
Roughly half. And, my lord, the land is at the entrance, and without this land, the project, my lord, cannot be, my lord, implemented. My respectful submission to lordships is this, my lord. At every stage, every procedure required is followed. And, my lords, the KID Act does not, my lord, restrict the payment of compensation. Section 29, my lord, takes care of, my lord, all the claims that can be made by a landowner in lieu for compensation in lieu of not the land acquisition. And there is scope for, my lord, negotiation under section 29 too. And, my lord, in fact, we had issued the notices also that form part of your lordship's, my lord, records. Before, my lord, the meeting could be held, they have rushed to the court, and, my lord, they have challenged the land acquisition. That is how, my lord, the matter is before the lordship's.
Yes, madam. Committee.
Sir, on behalf of the Yogamitra, I've been made a party because I'm one of the members who granted approval to the project proposal, the proposal of respondent number 3. Insofar as the arguments are concerned, my lord, I will adopt the arguments of the learned senior counsel. Very briefly, my lord, an application is placed before the Karnataka Yogamitra, which is then placed before the State High Level Clearance Committee based on the project, my lords. After which it is then placed before the Land Audit Committee to see what would be the land requirement for the project.
So under the act, is there any provision for them to indicate the lands that are required to be allotted to them? Under the act?
It would be section 5 of the act itself, my lords, the power of the committee.
Again, we come back to the first question, clearances.
Yeah, my lord,
Getting
those
getting the land allotted is not a clearance.
Correct. So now that would just be an in-principle approval that is accorded by the State High Level Clearance Committee. Pursuant
So if I accept your argument, then there's no direction that you can give to them to acquire land.
be recommendatory, my lord, as your lordship said, as the senior counsel also stated, it would be recommendatory. My lords.
My lord. Correct, my lord. My lord, reason is this, my lord. Allah, adralli.
You can't argue better than Mr. Sabrad. He's a person who's fighting for you.
My lord, Allah.
If you succeed,
Allah.
you succeed. If you don't succeed, you don't succeed.
ಅಲ್ಲ ಹಾಗಲ್ಲ ಸ್ವಾಮಿ ನನ್ನ ಒಂದು ಆಪರ್ಚುನಿಟಿ ಥರ್ಸ್ಡೇ ಆಫ್ಟರ್ನೂನ್ 2:30 ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಹಾಕೊಳ್ಳಿ ಅಲ್ಲ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಅಲ್ಲ ಮೈಲಾಡ್ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮೈಲಾಡ್ ಬಿಕಾಸ್ ಆಫ್ ಥ್ರೋಟ್ ಇನ್ಫೆಕ್ಷನ್
I don't want this presence.
ಅಲ್ಲ ನಮ್ಗೆ ಆಪರ್ಚುನಿಟಿ ಅಲ್ಲ ಒಂದು ಆಪರ್ಚುನಿಟಿ ಒಂದು ಲಾಸ್ಟ್ ಆಪರ್ಚುನಿಟಿ 2:30ಗೆ ಥರ್ಸ್ಡೇ ಹಾಕೋಣ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಮೈಲಾಡ್ ಬಿಕಾಸ್ 2 days
One submission.
ಮೈಲಾಡ್ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ
With respect to
Allah,
WP 4257 of 2007, except, and this is a connected matter, except saying the principle which lordship could appreciate. This division bench judgment wherein the principle of eminent domain cannot be pressed into service for a private individual or private concern. Haribas is the past case. That is, it is not yet challenged. It covers, it is actually on the para 32 to 42.
Ashwat Narayan, one
Please. And Google view of the entire land is.
Except this 6 acres, sir.
Kodi, Cyber Court of. The Google view of the land proposed to be acquired may looked into. This is very adjacent to the village, just 200 feet, not even 200 feet, and abutted by a tank.
ಮೈಲಾಡ್ Day after tomorrow for
Written
ಅವರ
argument-
ಅಲ್ಲ ಇಷ್ಟು ದಿವಸ ಅಲ್ಲ ಸುಮ್ಮನೆ
Written arguments
ರೆಡಿ
okay.
ಆಗಿದ್ದಾರೆ ಅದರಲ್ಲಿ
No.
ಒಂದು ಆಪರ್ಚುನಿಟಿ ಅಲ್ಲ ನಮಗೆ ಪ್ರಾಜೆಕ್ಟ್ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ ಅಂದ್ರೆ ನಮಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ ಸುಮ್ಮನೆ ನಮಗೆ ಪರ್ಸನಲ್ ಆಗಿ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಡ್ವೊಕೇಟ್ಗೆ ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೊಂತಾರೆ ಅದಕ್ಕೆ
Written argument
ಒಂದು ಆಪರ್ಚುನಿಟಿ ಸುಮ್ಮನೆ ಅವ್ರು ಥ್ರೋಟ್ ಇನ್ಫೆಕ್ಷನ್ ಡಾಕ್ಟರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೂಡ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ ಅವ್ರು ಮಾತಾಡಕ್ಕೆ ಆಗಲ್ಲ ಇವತ್ತು ಬಂದೇ ಅಲ್ಲ ಬೆಳಿಗ್ಗೆ
ಶಾಸ್ತ್ರಿ
ಮೈಲಾಡ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಫಾರ್ ಫೈನಲ್ ಆಪರ್ಚುನಿಟಿ ಟು ಸೇ ಮೈಲಾಡ್ ಸಮ್ ಮೈಲಾಡ್ ಲಾಸ್ಟ್ ಮೈ ಕೈಂಡ್ ಇಂಟೆಲಿಜೆನ್ಸ್ ಮೈಲಾಡ್
ಶಾಸ್ತ್ರಿಗಳು
ಮೈಲಾಡ್ ಒಂದು
no 3
ಇಲ್ಲ
times.
ಅದು
Don't
ತುಂಬಾ
force my.
ಆಗಲ್ಲ ಸುಮ್ಮನೆ ಅವ್ರಿಗೆ ಅವ್ರು ಮಾಡಿದ
Said no,
ಬೇರೆ
I-
ಕೋರ್ಟ್ಗಳಲ್ಲೆಲ್ಲ
I said you can file written arguments. If you want, you file written arguments, I'll consider that.
ಅಲ್ಲ
I'll wait for you for a week for the written arguments and then proceed. ಹೇಳಿ ಶಾಸ್ತ್ರಿ.
ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಸ್ವಲ್ಪ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಅಲ್ಲ ಕೇಸ್ ಕ್ಲಾಸ್ ಮೇಲೆ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕು
ಆಯ್ತು
ಒಂದು ಆಪರ್ಚುನಿಟಿ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ 2:30 ಹಾಕೊಳ್ಳಿ ಸುಮ್ಮನೆ ಒಂದು
ನಿಲ್ಸಲ್ಲ ನೀವು ಹೇಳಿ.
ಅಲ್ಲಲ್ಲ ನಿಲ್ತದೆ ಅಂತಲ್ಲ ಆಗಲ್ಲ ಮಿಸ್ಟೇಕ್ ಆಗುತ್ತೆ ಪಾರ್ಟಿಯಿಂದ
For- for-
ಮಿಸ್ಟೇಕ್ ಆಗುತ್ತೆ
Petitioner.
ಲಾಯರ್ ಶುಡ್ ನಾಟ್ ಬಿ ಸಫರ್ ಒಂದು ಆಪರ್ಚುನಿಟಿ
What is the suit for?
Petitioner,
tomorrow
suit is for a declaration, my lord, by the plaintiff petitioner. Declaration, my lord, that it is under the Waqf Act. Suit was originally filed, my lord, before the civil judge Mysore. That was transferred, my lord, to the Waqf tribunal because the subject matter, my lord, there is dispute about this.
Suit is dismissed.
Suit is dismissed. Not much case for me, my lord, but I will take your lordships through the relevant. The case of the plaintiff, my lord, is that he is the absolute owner of the suit schedule property. My lord, there is plaint A schedule. Plaint A schedule consists of a bigger property. Door number 2192 at Madhvacha Road, KR Mohalla, Mysore. Measuring, my lord, a bigger extent. Item number B, my lord, is a makan, what is called as a Dilbar Shah Wali Makan. That is, my lord, 20 feet into 18 feet. It is in this property. What I say is, this Dilbar Shah Wali Makan was established by the grandfather of the plaintiff in his property, but entire property was not Waqf. He had only this gori of a saint established, but doesn't mean that entire property is so B schedule alone, where gori is there, is the Waqf, but not the rest of the property. That is A schedule, my lord.
But B schedule is a part of A schedule.
B schedule is part of A schedule. B
A
schedule
schedule is the larger property of 375.
is a part. Is a part. That is B schedule, my lord, is Dilbar Shah Wali Makan. B schedule. That is situated in the A schedule.
The center of A schedule property.
Center of the location is there. My lord, my case is, my lord, Budansa purchased the suit property on 22/8/1889 under exhibit P2 sale date
22/8,
1889.
1889.
89, not about 93 years earlier to the filing of the suit.
Mudan Shah.
Budan Sab.
Mudan Sab.
On his death, my lord, it was inherited by his son, Muhammad Ghaus. Muhammad Ghaus' daughter is the present plaintiff, Tahira Begum.
Yes.
Plaintiff contends, my lord, that Budan Sab was also Mutawalli.
Exhibit P,
P2, my lord, exhibit P2.
22/8/89.
Correct, correct.
The entire A schedule property. which-
Entire A schedule property. Then, my lord, Budan Sahab was acting as Mutawalli of this Dilbar Shah Wali Makan. And after his death, Muhammad Ghaus was functioning as the Mutawalli. And that is how, my lord, so far as Makan is also concerned, was under our management and position all throughout is our assertion. Now, my lord, the case of the defendants is, this is a entire property is a Waqf property. It was notified as a Waqf as per exhibit D5, my lord, on 1/4/1965. 1/4/1965 by a gazette notification. And there was a suit, my lord, earlier
a scheme suit in OS number 2 of 1915. OS number 2 of 1915-1916.
Filed by?
Filed by my lord certain devotees of this Dargah. It is a scheme suit. There was an order in that scheme suit. So it is a Waqf.
Scheme was framed by the civil.
Scheme was framed by the district judge.
Do you have the date?
My lord, the date is they have
And,
not produced the order, my lord.
Budan Sahib was a party to this?
My lord, the difficulty is they say that, but they have not produced the order passed by the district judge. We do not know whether, my lord, this A schedule was included in that suit. And the like, my lord, we don't get because
Either way, gazette notification is not challenged by you.
Gazette notification was not challenged. That is one thing, my lord. But there, my lord, you may see Exhibit D5. Exhibit.
Once this notification become final, how can your suit for declaration be maintainable after?
For Muslims, my lord, there is difficulty
Except,
because
yes.
within 1 year from the date of notification, under the act, they have to challenge it.
After 37
the,
years.
Suit is very much later. No, my lord, Exhibit D5, my lord, is one thing which your lordship make.
But right or wrong, it is notified. Now can you challenge it?
My lord, point which I could make out is the notification is only, my lord, Dil Barsha Wali Makan, not, my lord, for entire property. That is what, my lord,
No, this is located in the center.
It is located in the center. That's a difficulty, actually, my lord.
Where is the discussion by the trial court?
Page 17.
Yes.
Judgment, page 17. Para 25.
Isne paragraph
25.
Para 24. Even para 24 also some part. Para 25, entire thing has been.
All right, para 24 onwards, my lord. Para 25, he refers to original suit and all that. But para 24, my lord, I may read from para 24. As there's a typed copy also, my lord. The earlier copies of his objections, I filed a typed copy. As stated supra, para 24. Plaintiff is mainly claiming a scheduled property on the basis of sale deed said to have been executed in favor of our grandfather Budan Sahib. Said sale deed is produced at Exhibit P2 and Exhibit P32. Exhibit P32 reveals that Budan Sahib purchased the suit scheduled property. And it appears that there were two properties earlier. And therefore, both the properties were described in Exhibit P32 sale deed. But the property numbers are not shown. The said sale deed was executed on 22/8/89. But it appears that the door number was assigned at that time. No door number was assigned at that time. Therefore, the property number or door number are not shown in Exhibit P32. But boundaries of two properties are shown as situated at Kiar Mahalla, bounded on the east by vacant space of Madara Sabi, west by house of Zut Fakara Begum and Havaldar Kasu Muhammad, north by road and south by road. This north by road, south by road, even now, not same boundaries exist. And another vacant site is described as measuring east to west 14 yards and north south 24 yards. And the second property is situated towards eastern side of the first property. The boundary of the first property alone is given in the sale deed. The power of attorney holder, son of plaintiff, is examined as PW1. In the plaintiff para number 3 of the plaintiff has contended that after purchasing the said property by Budan Sahib has constructed a place of workshop in a portion of the plain scheduled property and functioned as the mutawalli. But PW1 is the son of plaintiff, clearly admits in page 13 of his cross-examination that said Dilbar Shah Wali Makan tomb might have been constructed about 125 years back. This PW1 was cross-examined on 22/2/2013. If that is the case, there must be tomb or place of worship earlier to 1889. On 22/8/89, when Budan Sahib purchased the property, PW1 further clearly admits in the next breath at page 13 of his cross-examination that under Islamic Sharia, the tomb cannot be sold or purchased by any person. The defendants have mainly claimed the entire suit schedule property on the basis of Gazette notification. The defendant have produced the Gazette notification Exhibit D5. At serial number 48 at Exhibit D5, Gazette notification dated 1/4/1975. The present property is described, and column number 2 it is described as Dil Barsha Walid Dargah, Sunni, situated Muhammad Wali Road, KR Mohalla, Mysore city. The father of the plaintiff, Muhammad Gauss, has been appointed as Mutawalli, and his name is shown as Mutawalli in column number 4 of said Exhibit D5. In column number 10, it is clearly shown as by a scheme. The learned counsel for defendant number 2 and 4 vehemently urged that the suit property was earlier managed in.
I think para 34, I think you admitted that, yes, para 34.
Para 34, my lord.
PW1 is your husband, I think, no?
No.
Yes.
PW1, my lord, is the son of the plaintiff.
Please read para 34.
34. It's pertinent to note that the present PW1 had filed one affidavit before Karnataka Board of Waqf, Bangalore, and it is produced Exhibit D3. In Exhibit D3 at para 3, PW1 has clearly stated that after the demise of Budan Saab, his son Muhammad Gauss became the Mutawalli of the said Dargah, and he was performing all the daily and periodical services, including the annual Sandal and Urus of Dargah, and PW1 has sought to appoint him as Mutawalli. In para 3, he has clearly stated that Gazette notification was published under section 4 and 5 of the Waqf Act 1954. Said Gazette notification became final and conclusive. In the last para, page 3, PW1 has claimed to appoint him as Mutawalli of the said Dargah. These contents are clearly reveals that Muhammad Gauss, father of the plaintiff, was Mutawalli, and subsequently plaintiff also claims to appoint her as Mutawalli.
Now
And
that
even,
you admit the Gazette notification become final and conclusive, then what else remains?
my lord, so far as
Yeah, subscribe
this
signature.
Exhibit D5, I find, my lord, it describes only Dil Barsha Wali Makan.
That is not
Entire
the-
property is not
The
described.
affidavit does not indicate that. You are now making the distinction. This is not the, he admits wholeheartedly.
His, my lord, Mutawalli we were doing.
No, he also admits the Gazette notification.
Gazette notification li father and Mutawalli in torstare.
La, Purti, he says it become final and conclusive.
It is final and conclusive to the extent of building, my lord, that
It's not your plea. Let us look at your plaint. Is that your case? That only a portion of the property was notified and the remaining property remained with you? How can you have access to that
in the-
property if the entire property? Because your property wouldn't have given.
Plaint, my lord,
ಏನ್ ಆತರ ಬರ್ದಿಲ್ಲ.
page 6 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. Para 6 in the ಮೇಲೆ, para 5 last ಸ್ವಲ್ಪ. The defendant number 2 had no right except area covered under the Makan. Under such circumstances, it became inevitable to the plaintiff to issue notice dated 31/8/1996 to the second defendant. Para 5 middle. Second defendant, whereunder second defendant was intimated of the fact that the second defendant was only concerned with the Makan, which occupies the measurement of 20 feet into 18 feet in site number 2192 belonging to the plaintiff. Under such circumstances, it was notified by the plaintiffs to the second defendant that she had no objection whatsoever to reserve an area of 20 feet into 18 feet at the center of the plain schedule property to be continued to be used as Makan to the worship by the disciples, and she should be allowed to manage the said Makan also as its Mutawalli. However, the plaintiff made it certain that beyond Makan, with the above referred prescribed area, the other property had belonged to the plaintiff, or with the Waqf board also had no right or claim. In that view of the matter, plaintiff required the second defendant to address a letter to the corporation to the effect that the Khata of the Makan be retained in the name of Makan, while the Khata of the other properties surrounding the Makan be retained in the name of Budan Sahib, the grandfather of the plaintiff. The defendant number 2 was required to note the fact that notice had been issued to the plaintiff was treated to be one under section 56 of the act. ಅಷ್ಟೇ ಅದರಲ್ಲಿ
ಬಟ್ ಈ ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಸ್ಕೀಮ್ ಸೂಟ್ ಹೇಳ್ತಾರಲ್ಲ ಅದು, ಅಲ್ಲಿ ಡೈಲಿ ಫೀಸ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ರು ಆ ಜಾಗದಲ್ಲಿ ಅಂತ.
ಸ್ಕೀಮ್ ನಲ್ಲಿ ಸರ್ ಅದರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಪೇಜ್ 27 ಅಲ್ಲಿ ಹೇಳ್ತಾರಲ್ಲ.
27.
Sir, exhibit D9, 10 and 11 blood are the documents in
Your
that
father
regard.
himself was a signatory to the survey. So therefore, what else remains? Surrounding the Dargah antane ಇದೆ notification ಅಲ್ಲಿ. He is a signatory to the, and they suspect your oral gift also.
Sir, oral gift is suspected, my lord, because it was sent to the forensic expert, Hyderabad. Hyderabad forensic expert is of the opinion that the first upper portion of the stamp paper, the lower portion of the stamp paper are different. This lower portion is attached to the upper portion stamp. The upper portion is 1966. This gift we say in 1979. So the area of gift is, my lord, disbelieved by the trial court. This exhibit D9, 10 and 11 on which are the documents on which they have rely upon, my lord. They are all not certified xerox, but there is nothing which goes against my client. There is only, my lord, there is an application filed in exhibit D9, an application filed to remove the existing committee members. My client's father was also an existing committee member then. And ultimately, after some time, my lord, that was compromised. Some 3 new members are inducted into the committee of Mutawallis. Then that proceeding that is closed. Then in the meanwhile, thereafter, this act came into force, Waqf Act came into force. The district judge closed the proceedings, stating that new act has come into force. I have no role to play now. Scheme suit has nothing to do as on now, because Waqf has come, entire scheme management is to be done by the.
This revision is filed challenging the dismissal of a suit which had been filed by the petitioner, seeking for a declaration and for a permanent injunction. The petitioner filed a suit contending that the suit property had been purchased by her grandfather Budan Sahib and registered sale dated 22/8/1889, and after his death, her father Mahmud Ghaus had succeeded to the same. It was a further case that her father had executed a hiba in favor of her, and she had thus become the owner of the property. She contended that defendant number 1 and the Waqf board, defendant number 2, were asserting their rights over the property, and she was therefore constrained to file the suit. The Waqf board contested the suit by stating that the suit property was notified as a Waqf property under the Gazette notification dated 1/4/1965. And in the light of this Gazette notification, which remained unchallenged, the plaintiff could not put forth the plea that she had acquired title to the said property. The trial court, on examination of the entire evidence adduced before it, has recorded a finding that a survey was conducted in the year 1963 of the suit property, and to the said survey report, the father of the plaintiff himself was a signatory. It is also found that in the Mahajar, exhibit D7, conducted by the survey officer, The property was shown as Dilbarsha Wali Dargah and its surrounding open space, bounded on the west by Madhavachar Road and on the east by Sandakatte Road. The tribunal has also taken note of the fact that the merger indicated that a sum of rupees 2,640 per annum was being received from the said Makan as income. And since the father of the plaintiff had signed the said merger, it was clear that the property was a Waqf property and the claim of the plaintiff could not be accepted. Next paragraph. The trial court has also relied upon the survey reports to come to the conclusion that it was not only the tomb area which was notified as a Waqf property, but also the surrounding space. The trial court has taken note of the admission of the plaintiff regarding the survey and has come to the conclusion that a conjoint reading of the survey report and the notification would clearly indicate that the entire property had been notified as a Waqf property. Next, apart from the above, the trial court has also taken into consideration the fact that a scheme had been framed by the District Judge Mysore in OS 2/1915-16 as per Exhibit D11, and it was therefore clear that the property claimed by the plaintiff could not be her private property. In my view, the findings taken up to the trial court are just and proper and are based on a correct understanding of the evidence adduced before it. And there is no warrant for interference in a revision by this court. Consequently, petition is dismissed. Yes.
Submission, respondent number 1 ಇದರಲ್ಲಿ ಕಾಜ್ಲಿಟ್ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ R1 ಗೆ.
ಇರೋದಿರ್ಬೇಕು ಸರ್.
PU Usman.
Number 3, Shri T. Srinivasa.
Petitioner, my lord. Small causes suit. Defendant's revision petition. Suit for recovery of money based upon two pronoms, which came to be decreed and ordered that this defendant needs to pay a sum of rupees 61,000 along with interest of 6% per annum. My lords may kindly appreciate, it is the contention of the defendant that he had availed a loan from the mother of the plaintiff in a sum of rupees 31,000, and towards that repayment, he had given two checks as two pronotes as security. He had repaid the loan by giving 3 checks. That is admitted in the course of evidence.
Your client had executed a pronote in favor of the plaintiff. That is admitted.
No, in favor of blank pronotes, blank signed pronotes was given in favor of the plaintiff's mother.
Plaintiff's mother.
Plaintiff's mother. And towards repayment of the loan, he had given 3 checks for a sum of rupees 31,000, 10,000, 10,000 and 11,000. And 2 checks were honored, that is admitted. The account statement is produced by the plaintiff and the defendant, and that also is admitted by the plaintiff as well. So also it is suggested in the cross-examination of DW1, that is the defendant, that this defendant was having money transaction with his mother. That is suggested in the course of cross-examination. And now, based upon by misusing those 2 checks, it is said that I have received a sum of rupees 50,000, that is 25,000 and 25,000 on the same day, that is on 1/4/2008, and I have executed 2 pronotes on the same day.
Apart from the 3 pronotes, apart from the 3 checks.
Apart from the 3 checks.
Let us read the plaint.
Hello?
Plaint government senate.
Plaint government, it doesn't state anything about this one, but it is the evidence. It is in the evidence, it is elicited in the evidence, cross-examination of PW1.
So Pramila Rao had given you 3 checks for 31,000.
I had given to Pramila Rao for having towards repayment of the loan.
La Srimati K. Pramila issued 3 checks peri number so and so antantra.
Illala,
Page 14.
I had issued 3 checks to Pramila Rao, who's the mother of the plaintiff. And I produced exhibit D1, which is my account statement.
The mother was not alive.
Mother was alive.
Did you summon her?
No, she is not.
Because that is your defense, isn't it?
Was my defense, but
If you don't summon her, what is the reasoning given by the trial court?
trial court doesn't discuss about the evidence at all by page number 26, man, typed copy of the judgment. Para 11. In oral evaluation of the oral and documentary evidence placed by both the parties, the plaintiff, in order to prove his contention, has got marked exhibit P1 and 3 pronotes and exhibit P2 and 4 consideration receipts. The defendant has admitted that he has signed exhibit P1 to 4, but contended that he has given exhibit P1 to 4 documents as security to the mother of the plaintiff, one Srimati K. Pramila Rao, towards the repayment of the money he had owed to her, and that there was no transaction between plaintiff and himself. Further, the defendant, Srimati K. Pramila Rao, had not returned the check.
No, at least did you summon the witnesses to this pronote?
Those witnesses were also not examined.
Did you summon them?
The plaintiff admits in the course of cross-examination that he'll examine the witnesses, attesting witnesses to the pronoun.
You have not summoned them Tane, to say that, to question them.
But
You
he does,
admit the signature on the pronotes.
I admit the signatures saying that I had given blank pronote.
What do you do? ಏನ್ ಕೆಲಸ ಮಾಡೋದು ನೀವು?
I am doing medical stores ನಡೆಸ್ತಾ ಇದ್ದೀನಿ.
ಅವ್ರೇನ್ ಮಾಡೋದು?
He says that he is a contractor and is doing contract business. And regarding the evidence, there is no discussion about the evidence, cross-examination as well as the evidence let in by the defendant also. Cross-examination, it is clear he admits that he himself, for that matter, in the cross-examination of DW1, admits that I was doing money transaction with his mother as such. I had money transactions with his mother anta ಒಪ್ಕೊಳ್ತಾರೆ.
ನಿಮ್ ರಿಪ್ಲೈ ಅಲ್ಲಿ ಹೇಳಿದಂಗೆ ಅರ್ಥನೇ ಆಗ್ತಾನೆ. You reply to the notice. My client had kept several transactions between your client's mother, an on-demand pronote dated 21/4/99, and also several payments were made by my client and endorsed the same by your client's mother dated 26/3/2008. My client had issued 3 checks. ನಂಗೆ ಅರ್ಥ ಆಗಲಿಲ್ಲ. What exactly are you trying to say?
The 3 checks were towards repayment of the money which this defendant owed K. Pramila.
Made several transactions, several payments were made, which is duly endorsed ಅಂತಿರಲ್ಲ, ಎಲ್ಲಿದೆ ಅದು?
ಏನಾದ್ರ ಬಗ್ಗೆ ಇಲ್ಲ. While court's judgment, there is virtually no discussion about the evidence placed by this defendant.
When did you clear the debt is not forthcoming?
Exhibit D1 is the statement of accounts.
No, that is what she has given.
I have given. Exhibit D1 is the statement of accounts and he admits the same.
This is in 2008.
2008 December.
This pronote is much later, isn't it?
That is earlier. 4/1/2008 is the pronote.
All right, for 50,000, if you have 3 checks, what about the remaining amount? Person who has given a check, will he not ask for return of the pronotes? If actually he has given it.
He had asked for the return of the pronotes, but
ಎಷ್ಟು ತಗೊಂಡಿದ್ ಸಾಲ ಅಂತಾನೂ ಹೇಳಲ್ಲ ನೀವು. ಅವ್ರ ತಾಯಿ ಹತ್ರ ಎಷ್ಟು ಸಾಲ ತಗೊಂಡ್ರೆ ಎಷ್ಟು ತೀರ್ಸ ಅದನ್ನು ಹೇಳಲ್ಲ ನೀವು. 31 ಸಾವಿರ ರೂಪಾಯಿ ರೆಕಾರ್ಡ್ ಇದೆ, ಅಷ್ಟು ಮಾತ್ರ ಹೇಳಿದಾರ. ಸಾಲ ಎಷ್ಟಿತ್ತು ನೀವು ಜಾಸ್ತಿ ಇದ್ರೆ
ಜಾಸ್ತಿ ಅಂತ
ಹೇಳ್ಬೇಕು ತಾನೆ. ಈ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅವ್ರ ತಾಯಿ ಹತ್ರ ನಾನು ತಗೊಂಡಿದ್ದೆ, ಇಷ್ಟು ನಾನು ತೀರ್ಸಿದ್ದೀನಿ, ಅದೇನು ಹೇಳಲ್ಲ ನೀವು. And you admit that there was a transaction, you admit there's a pronote that you sent, 2 pronotes.
admit
Then
that
they
these 2 pronotes were given as security. And he also admits in the course of cross-examination that I was having money transaction with his mother.
Now that is an admitted fact. Should you not say which is the transaction, how much you had borrowed from his mother, what was his mother doing, when did you repay, how much was paid? Nothing is there. The fact that there are transactions is now admitted.
Please.
You are saying you had no transaction with the plaintiff, but the plaintiff has 2 pronotes. You don't examine anybody else.
The plaintiff admits that in the course of his cross-examination, the attesting witnesses will be examined and he admits.
ಇಲ್ಲ ನೀವು ಹೇಳಿದ್ದು ಸುಮಾರು ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್ ಇದು, ನಾನು 31 ಸಾವಿರ ಕೊಟ್ಟೆ ಅಂತ. ನೀವು ಯಾವಾಗ ಸಾಲ ತಗೊಂಡ್ರಿ, ಏನಕ್ಕೆ ಸಾಲ ತಗೊಂಡ್ರಿ, ಏನು ಹೇಳಲ್ಲ ನೀವು. ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೀರಾ. We don't know whether the check is in relation to this loan amount or something else. We don't know. And what does the mother do?
Mother, she is a housewife. I said.
Why would you borrow money from a housewife? You are in the pharmaceutical business. ನಿಜ ಏನೋ ಬೇರೆ ಇದೆ. ನೀವು you want to take advantage of the fact that there are 3 checks indicating payments of 31,000.
That is not.
Nothing, even in your evidence, there is nothing indicating as to when you took a loan, when you repaid the loan. ಏನು ಬರ್ದಿರ ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ಓದಿ. ನಿಮ್ಮ ರಿಪ್ಲೈ ಹಂಗೆ ಇದೆ, ಎವಿಡೆನ್ಸ್ ಹಂಗೆ ಇದೆ. ಹೂಸ್ ಅಪೋಸಿಂಗ್ ಯು?
ವಿಕ್ಟರ್ ಮನೋಹರ್.
ಎಂಟ್ರಿ ಮಾಡಿರ್ತಾನೆ ನಿಮ್ಗೆ ಏನಾರು ಇಲ್ಲಿ?
Entry matter admit ಆಗಿದೆ.
ಏನಾಗಿದೆ
Admit
ಮತ್ತೆ?
to stay of the impugned order.
ಇಲ್ಲಿತ್ತಾ? I don't see any ground in your favor. ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ತೀರಾ?
ಪ್ರಯತ್ನ ಮಾಡ್ತೀವಿ.
All the money that I owed Shivi came, Pramila was paid. Pramila had towards security of the repayment, 3 checks had secured 2 blank promise notes. ಎಷ್ಟು ಅಮೌಂಟ್ ಏನು ಹೇಳಲ್ಲ. ವ್ಯವಹಾರ ಅಂತೂ ಆಗಿದೆ, ಎಷ್ಟು ಅಂತ ನಿಜ ಹೇಳ್ತಿಲ್ಲ ಇಬ್ರು ಅಲ್ವಾ? I'll have it tomorrow, let him come.
Please. ನಾಳಿದ್ದು.
6. See number 4, Shri VP Revision.
Waiting for the respondent. On the last date, restored this revision petition, which was dismissed for non-prosecution, my lord. Suit for recovery of money, my lord. Dismissed by the trial court on 18/3/2014.
Bank suit is dismissed?
Bank suit is dismissed on the ground of limitation and also on the payment made by the defendant. And exhibit D1 is the document record, the finding recorded by the honorable trial court may kindly be perused at para number 16 of the impugned judgment, my lord.
Since the defendants have proved the point number 2 stating that this suit is barred by limitation.
Page number,
Page number, I don't know, computerized copy I marked.
paragraph.
Para 16, my lord. Since the defendants have proved the point number 2 stating that this suit is barred by limitation, the question of deciding the point number 1 in favor of plaintiff bank does not arise. However, it is necessary to say about the admissions given by the PW1 in cross-examination in regard to the liability of defendants. The PW1 in cross-examination has clearly admitted a suggestion that as on the date of suit, principal loan amount of the defendant becomes 50,318. And further, he has stated that as per Exhibit P7, balance amount outstanding on the date of suit was 45,172. That is as per Exhibit P7. The Exhibit D1 maintained by the plaintiff bank in respect of loan clearly shows that on 6/2/2009, rupees 51,165 was transferred from so-and-so to the loan account number so-and-so. The said account was closed. The bank entry made in Exhibit D1 on 6/2/2009 shows that 51,165 has been adjusted, transferred towards small cause court number 16, so-and-so case number, the loan account. Therefore, it is to be said that the outstanding loan amount has been paid by the defendants because the plaintiff bank has failed to prove that the entire liability of the defendants has not been discharged. The PW1, now respondent defendant.
ಯಾರು petitioner ಯಾರು?
Petitioner VB ರವಿಶಂಕರ್. ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ತಾವು ಹೇಳಿದ್ರಿ ಸ್ವಾಮಿ ಅವ್ರು ಬರ್ಬೇಕು, ಇಲ್ಲ ಅಂದ್ರೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ತಗೋತೀವಿ ಅಂತ, ಆದ್ರೂ ಅವ್ರು ಬಂದಿಲ್ಲ. ರೆಸ್ಟೋರ್ ಮಾಡಿದ್ರೆ ಲಾಸ್ಟ್ ಡೇಟ್ ನಲ್ಲಿ, ಲಾಸ್ಟ್ ಮಾರ್ಚ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದು ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್. ಇದ್ರಲ್ಲಿ ದುಡ್ಡು ಕಟ್ಬಿಟ್ಟಿದೀವಿ. ಎಕ್ಸಿಬಿಟ್ D1 ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್ ನಲ್ಲೇ ಅವ್ರು ಮರ್ಕೊಂಡಿದ್ದಾರೆ ಈ ಕೇಸ್ ನಂಬರ್ದು ಎಂಟೈರ್ ಅಮೌಂಟ್ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದೆ ಅಂತೇಳಿ. 2008 ಸೂಟ್ ಇದ್ರ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ರು ಇಲ್ಲಿವರೆಗೂ ಮೇಂಟೈನ್ ಮಾಡಿದ್ದಾರೆ. ತಿರ್ಗಾ ಸಮನ್ಸ್ ಸರ್ವ್ ಮಾಡಿರೋದೇ 2013 ಅಲ್ಲಿವರೆಗೂ ನಮ್ಗೆ D2 ಇದಾಗಿಲ್ಲ. ಮತ್ತೆ ಅವರು ದೇವರಾಜ್ ಅಂತೇಳಿ ಕೇಸ್ ಹಾಕ್ತಾರೆ ಡಿಫೈನ್ ನಂಬರ್ 2, ಅದು ನೋಡಿದ್ರೆ ವೇದರಾಜ್, ಅದನ್ನ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ 2013 ಅಲ್ಲಿ. 5 ವರ್ಷ ಬರೀ ಸಮನ್ಸ್ ಸ್ಟೇಜ್ ನಲ್ಲೇ ಇಟ್ಕೊಂಡು ಆಮೇಲಿಂದ 2013 ಅಲ್ಲಿ ನಾವು ಬಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಕೊಟ್ಟ ಮೇಲೆ ಮಿನಿಟ್ಸ್ ಮೇಲೆ ಕೇಸ್ ನಡೆದಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಅವ್ರ ಅಪೀಲ್ ಗ್ರೌಂಡ್ ಅಲ್ಲೂ ಕೂಡ ಇದು 51,165 ಪೇಮೆಂಟ್ ಮಾಡಿರೋ ಬಗ್ಗೆ ಯಾವ್ದೋ ಗ್ರೌಂಡೇ ತಗೊಂಡಿಲ್ಲ. ಎಕ್ಸಿಬಿಟ್ D1 ಲಾಸ್ಟ್ ಎಂಟ್ರಿ ನೋಡಿ ಸ್ವಾಮಿ, 6/2/2009 ಪಾಸ್ಬುಕ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಒರಿಜಿನಲ್.
The bank is in revision. The bank had instituted a suit seeking for recovery of rupees. Just amount?
90,970.
90,970 with future interest rate of 18.25% per annum. It was a case of the bank that had sanctioned a loan for rupees 3,55,000 to the first defendant, and the second defendant had stood as a surety to the said loan. It was stated that the first defendant had also executed a promissory note on 31/1/2003 agreeing to repay the loan amount in 36 equal monthly installments for rupees 12,005. And he had hypothecated his equipment such as ultrasound diagnostic system and also executed a hypothecation deed in favor of the bank. It was stated that since the first defendant had failed to make several payments, he was called upon to acknowledge his loan liability, and he had accordingly acknowledged that he was liable for the outstanding amount by executing a document on 8/3/2006. Executing another promissory note on 8/3/2006. It was stated that since thereafter also, the first defendant defaulted in making the payments despite a demand notice being issued to him, the bank had no other option but to file the suit. which incidentally was filed on, ಯಾವತ್ file ಮಾಡಿದ್ದು?
Suit.
2008 ಅಂತೆಲ್ಲ ಹೋದ್.
ಹೇಳ್ತೀನಿ.
Is it on?
20th December 2008.
2008. So the case of the defendant was that the suit was barred by limitation as it was not filed within 3 years of the loan being sanctioned, that is within 3 years from 8/3/2003. It was also stated that the bank had got an amount of rupees 51,165 transferred from the SB account of the defendant number 1 on 6/2/2009 after the filing of the suit towards the full and final settlement of the loan, and therefore the loan had stood discharged. It was the specific case of the first defendant that the bank had assured him that it would withdraw the suit since the loan account was closed, but the suit was not withdrawn and was continued to be prosecuted. In other words, the case of the first defendant was that the loan was time barred since the suit had been filed on 20/12/2008 in respect of a loan availed in the year 2003. And also on the ground that the loan stood discharged by the transfer of the sum of rupees 51,165 from the loan from the SB account of the first defendant. Next one. The trial court, on consideration of the evidence, has recorded a clear finding that the acknowledgement of debt wide exhibit P7 was actually signed on 8/3/2006. The trial court has taken note of the admission of PW1 during the course of his cross-examination, in which he has admitted that it was true that the defendants had executed exhibit P2 to P8 in favor of the bank on 8/3/2003. And it has therefore come to the conclusion that the allegation, that the contention that the debt was acknowledged on 8/3/2006 could not be accepted. It is thereafter taken note of the fact that the acknowledgement of debt made in the year 2006 would be of no avail in view of Section 18 of the Limitation Act. Next, as regards the claim on merits, the trial court has noticed that as per Exhibit D1, which was maintained by the bank in respect of the loan availed by the first defendant, so it indicated that on 6/2/2009, a sum of rupees 51,165 was transferred from the account of the first defendant, the SB account of the first defendant, to the loan account of the first defendant, and an entry was made that the account was closed. The trial court has noticed that the bank entry made in Exhibit D1 regarding the transfer and adjustment to its loan amount indicated that there was no loan amount outstanding. In my view, in the light of the clear admission by PW1 that the acknowledgement of debt was made 6 years, was made beyond the 8/3/2006, Allah? On 8/3/2006, that is beyond 3 years. And having regard to the further fact that the tribunal has noticed, the trial court has noticed that there was a transfer of 51,000 from the SB account of the first defendant to the loan account, and an entry is found that the loan was closed, the trial court was perfectly justified in dismissing the suit. I find no reason to entertain the suit. Revision is therefore dismissed.
Bill number 5, Shri Chandan S. Rao. Please.
Plaintiff's revision.
Nobody's here. Nobody's here. Yes.
Plaintiff's revision. Suit was filed for recovery of 55,000. Suit is partly decreed.
ಎಷ್ಟಕ್ಕೆ?
2,750 ರೂಪಾಯಿ.
ಏನ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಏನು?
Transaction, there were 3 transactions. This 55,000, according to the plaintiff, she has paid in cash. There were 2 more suits, 1,50,000 each. Both were decreed. The same defense was taken by the defendant in both the suits. Suit is decreed.
ಅದೇನಾಯ್ತು? ಅದ್ರ ಮೇಲೆ ರಿವಿಷನ್ ಹಾಕಿಲ್ಲ?
ಏನು ಹಾಕಿಲ್ಲ. It is attained finality. The learned trial judge says 2 post-dated checks were given by the defendant. The plaintiff has not presented it for clearance. Therefore, presumption has to be taken against the plaintiff for not presenting the checks.
Why did you not present the checks?
Checks ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ನೀವೇನ್ ಕೆಲಸ ಮಾಡ್ತೀರಾ?
ನಾನ್ ಮನಿ ಲೆಂಡರ್.
ನೀವು ಸುಮ್ಮನೆ ಇದ್ಬಿಡ್ತೀರಾ?
ಹಾ,
ಸುಮ್ಮನೆ ಇದ್ಬಿಡ್ತೀರಾ?
ಅಲ್ಲ,
ಕೊಡ್ತಾರೆ, ಚೆಕ್ ಇಟ್ಕೊಂಡು
ನೋಟಿಸ್ ಕೊಟ್ಟೆ. On their request, in fact, 2 coordinate benches heard this matter. I am ready to give the interest. 50,000 ಕೊಡ್ತೀನಿ ಅಂತ ಅವರು ಹೇಳಿದ್ರು. ಯಾರು? ಸುಂದರೇಶ್ ಅವರು. ಅವ್ರಿಗೆ ಏನಾಗಿದೆ? He has undergone a brain surgery about 3 weeks ago. He is not attending the court. Maybe ಅದಕ್ಕೆ ಅವ್ರ ಕೊಲೀಗ್ ಬಂದಿದ್ರು. Mr. Sundesh has undergone a brain surgery about 4 weeks ago. He is not attending the courts right now. It was heard by 2 coordinate benches. 50,000 ರೂಪಾಯಿ ಕೊಟ್ಬಿಡಿ ಅಂತ ಹೇಳಿ ನಾನು ಒಪ್ಕೊಂಡಿದ್ದೆ. Just bringing to the notice of this honorable court.
What is his defense?
Defense says that he has cleared the loan amount. Now, Lordship may kindly have a look at internal page 4917, 4918, ಎರಡಿದೆ ಸೂಟು.
ನೀವೇನ್ ಕೆಲಸ ಮಾಡ್ತೀರಾ? ನೀವೇನ್ ಕೆಲಸ ಮಾಡ್ತೀರಾ?
ನಾನು ಇದು ಮನಿ ಲೆಂಡ್.
ಅಲ್ಲ, ಸಾರಿ, ಡಿಫೆಂಡೆಂಟ್.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಾವು ನೋಡಿದ್ರೆ ಅವ್ರು ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಾವು ನೋಡಿ, 1 second. ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಈ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಶೆಡ್ಯೂಲ್ ಆಫ್ ಪೇಮೆಂಟ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ, ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 5 ನಲ್ಲಿ. Paragraph number 5 of the return statement. Otherly, if your lordship may kindly come to B, 7,500 through check bearing number to Sri Mahesh. Mahesh is my son. He's got nothing to do with this transaction. 2 checks, ಅದರ ಮೇಗಡೆ ತಾವು ನೋಡಿದ್ರೆ, ಅದೇ ಪೇಜ್ ಅಲ್ಲಿ ಮೇಗಡೆ ನೋಡಿದ್ರೆ 19/8/2009 2 checks were given by the defendant. 30,000 one to 25,000 one. 19/8/2009. ಆ ಚೆಕ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ದಿ ಲರ್ನೆಡ್ ಟ್ರಯಲ್ ಜಡ್ಜ್ ಸೇಸ್.
ನನಗೂ I find it very hard to believe that come to page 16, para 4. That you had collected interest as stated by the defendant in reply notice dated 21/5/2012. The plaintiff till 31/3/2012 has received rupees 2,050 per month. That is, the defendant has paid a sum of rupees 88,000 in cash, apart from payments received through checks in the name of the plaintiff, her son and her son's firm name.
That is the finding of the trial court, which is erroneous. If your lordship may kindly have a look at the cross-examination of DW1. DW1 cross-examination ನೋಡಿ ದಯವಿಟ್ಟು. 2 ಸೂಟು ಅದನ್ನ ತಾವು ನೋಡಿದ್ರೆ 4917, 4918. It is a part of the record. 4917 ಅಲ್ಲಿ, if your lordship may kindly come to the internal page number 5 of the judgment in OS 4917, internal page 5. Same schedule, payment store. Internal page 5 ಬನ್ನಿ ದಯವಿಟ್ಟು. DW1 cross-examination ಬಂದ್ರೆ.
Please wait for a minute.
Reading al ಹೇಳಿದೀವಿ, she has requested ಅಂತ. In fact, in the other two matters also, she had given post-dated check, the defendant. The plaintiff had not presented those checks.
Please read from para 15. Page 22.
Para. Admittedly, the suit is filed for recovery of rupees 55,000 on the basis of two checks which are given by defendant for security of the loan dated 19/8/2005 for rupees 55,000 with interest. As above stated, the defendant clearly admitted that he has received 55,000 from plaintiff on 19/8/2009 and also admitted that he has issued two checks for security purpose. The only content defendant that he has paid rupees 55,000. Defendant has paid a sum of rupees 2,77,500. 250, and he has also clearly stated that he has paid through check as under, check bearing number so and so, so and so. That schedule is there. Then, in this regard, the defendant has produced Exhibit D1 statement of account which discloses that on 7/9/2009, 9,750, on 5/12/2009, 7,500, so and so, so and so debited to Vijayalakshmi's account. Admittedly, these payments are made subsequent to 19/8/2009. Then, the plaintiff filed rejoinder and stated that the amount mentioned in the written statement is not the amount given by her. It is true, it is the amount due by the defendant to her husband. The amount mentioned in the written statement is no way concerned to the plaintiff. In cross-examination also, she has stated that the amount deposited to her account, as mentioned in Exhibit D1, is not related to her, so it's through transaction. It is it is concerned to her husband's transaction, but the plaintiff has not produced any documents for the defendant has borrowed loan from her husband. Further, if the defendant borrowed loan from the husband of the plaintiff, definitely the defendant had issued check in the name of the husband of the plaintiff and not in the name of the present plaintiff. D1 clearly shows that after 19/8/2009, the amount is rupees 53,250 is debited from the account of the defendant to the plaintiff's account. As above stated, the plaintiff has not placed any document to show that the above deposited amount is related to food transaction, is not related to food transaction. Plaintiff also produced Exhibit P9, copy of the complaint filed by the present defendant before the police station, and on as per the complaint, first the defendant has borrowed rupees 1,50,000, second time rupees 30,000, third time rupees 25,000, totally 2,05,000. During the course of cross-examination, defendant stated that the said complaint is not related to the present case. Further, in Exhibit P8 rejoinder, the plaintiff himself admitted the defendant has borrowed only rupees 55,000. So much being the case, Exhibit P9.
Then what is your case? You have received this 53,250 after 19/8/2009.
19/8/2009, there were 3 transactions. Your lordship may.
Where have you said in your plaint that there were 3 transactions? And did you state in the plaint that you had received this amount? Did you narrate all those transactions in your plaint?
Plaintally, if your lordship may kindly have a look at para 7 of the plaint. Plaint. Paragraph number 4 of the plaint. Defendant has approached plaintiff in the month of June 2000, requested to pay some rupees 55,000 family commitments.
So there is nothing about the earlier transactions at all.
Clear transactions too. 2012 I filed 2 suits, 47/17 and.
You stated that in the plaint.
Idal hedi.
For you to correlate that transaction with this transaction, if you don't state all that in the plaint, so whenever something is given, you're saying, no, it relates to my husband or to some other transaction. You should say so in your returns, in your plaint.
This plaint, it does not, the pleadings.
Then
are
you're
not
not truthful then. Because this trial court is right. Even in the police complaint that you gave, you say some other complaints.
No.
Some other amounts. Then you say, no, they are not related to this particular case.
Your lordship may kindly have a look at those two judgments that has been produced in the trial court. 4717, if your lordship may kindly have a look at.
No,
49,
judgment like first facts ಹೇಳಿ ನೀವು. What is the case that you made out?
Same defense.
Your
of
case was,
defendant.
you had given a loan of 55,000. It is admitted.
Please,
It is also admitted that 2 checks were given as security.
security.
Now there is documentation to show that 53,250 has been debited to your account.
That
Now
according.
you are trying to get over all that by saying, did you narrate that these amounts which were debited were in relation to my husband's account?
That does not reflect in the plaint.
ಮತ್ತೆ ಇನ್ನೇನ್ ಬಿಡಿ. ಹಂಗಾರೆ you are not being truthful to the court.
Internal page 4917 judgment, one ನಿಮಿಷ ದಯವಿಟ್ಟು.
Judgment ನೋಡ್ಕೊಂಡು ಏನ್ ಮಾಡೋಣ ಹೇಳಿ, ಇದನ್ನ ಹೇಳಿ first.
Same parties though, same defense.
ಆದ್ರೆ ಏನಂತೆ? So can I rely upon the governments there and
I am only trying to say that the defendant is the same. He has,
you got a decree there, be happy. You have a decree here for lesser amount, be happy with it, that is all. ನೀವು ಅಲ್ಲಿಂಗಾಯ್ತು ಇಲ್ಲಿಂಗಾಯ್ತು ಅಂತ ಈ ದಾವಲ್ಲಿ ಏನ್ ಮಾಡ್ತೀರಿ ನೀವು?
I cannot improve upon the case because PW1 has admitted in the cross examination saying that that amount is on a different transaction pertaining to the defendant or husband. Of course, the husband is not summoned. And as your lordship rightly pointed out, that it does not form a part of the pleading as well. I cannot go beyond the pleadings. I can only impress upon your lordship saying that.
ಬಿಡಿ ಹಿಂಗ ಫ್ರೆಂಡ್ಸ್ ತಾನೆ ನೀವು 10 ವರ್ಷದಿಂದ. The suit is, the revision is by the plaintiff challenging the part decree granted in her favor. Next, the plaintiff had instituted a suit for recovery of rupees 55,000 from the respondent. The respondent admitted that he had taken a loan of rupees 55,000 and had also issued 2 checks in the sum of rupees 30,000 and 25,000. Alva?
Please.
Next.
1982.
The trial court, come on, appreciation of the evidence has noticed that as per Exhibit D1, a statement of account, it was clear that the following sums were paid. Illide, page 23, tab.com. The trial court has noticed that these payments were made after the loan was given on 19/8/2009. Loan ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದು?
June 2009. Loan ಕೊಟ್ಟಿರೋದು June 2009. Paragraph number 4 of the thing. Para 4, June 2000. Two posted date checks are dated 19/8/2000.
The trial court has noticed that the amounts were paid after the issuance of the 2 checks on 19/8/2009, and altogether a sum of rupees 53,250 had been paid to the plaintiff. And as a consequence, there remained only a balance of rupees 2,750. And it has accordingly decreed the suit with costs. Next. Not counsel sought to point out that the amounts that were stated have been paid by the defendant were in relation to some other transaction, which was the subject matter of 2 other suits. And therefore, the finding of the trial court cannot be sustained. It is to be stated here, the plaintiff was totally silent about the other transactions that the plaintiff had with the defendant, or the transactions that the defendant had with the plaintiff's husband. In the absence of any plea that there are other transactions, the arguments now sought to be advanced cannot be accepted. Since the trial court has recorded a clear finding that the sum of rupees 53,250 had been paid after the issuance of the 2 posted checks, it is clear that the trial court was justified in coming to the conclusion The order of the loan amount of 55,000, a sum of rupees 53,250 had been repaid, and they remain to be repaid only a sum of rupees 2,750. I find no reason to entertain the revision. Revision is therefore dismissed. Please.
Bill number 6, Shri Mahesh Arupin.
Suit is for recovery of the advance amount.
Recovery of?
Advance amount paid. Plaintiff was the tenant under the defendant's plot on payment of rent of 12,400 per month and advance amount of rupees 1 lakh. Then Malad on 4/12/2013, plaintiff issued notice saying that Malad he is going to vacate the premises by 3 months from the date of notice. But
that is 3/3.
Yes, Malad. But on 20th January 2014 itself, Malad, second defendant came, it is a outhouse, Malad. Second defendant, that is, first defendant is the husband, second defendant is the wife, Malad. They are the owners of the premises. This premises in question is a outhouse. They are living in front portion. The second defendant, Malad, locked the gate of the premises, Malad, and it was difficult for the daughter of the plaintiff, Malad, to go to school. Therefore, Malad, a complaint was lodged on 20th January 2014 to the jurisdictional police. I have produced a copy of the complaint also. After receiving the, I requested the police, Malad, to help me to vacate the premises because I wanted to, I don't want to stay, Malad, because of this trouble. I vacated the premises with the police help on 20th January 2014 itself. At the time of vacating, Malad, he assured that the advance amount will be paid on 1/2, but it was not paid. Then legal notice was sent on, Malad.
No assurance in writing.
Yeah, no assurance, Malad. Then legal notice was given to him, Malad, on 10/2/2014. It was received, Malad.
Legal notice for what?
For refund of the amount, Malad, by deducting 20 days rent. It will come to 91,000 and odd. But it was received, this legal notice was received on 13/2/2014. This date is important. Neither the amount was returned nor reply was sent to me, Malad. Then on 24/3/2014.
Stop here for a minute.
Please, Malad.
On 4th of December 2013, you said you will vacate in 3 months.
3 months, but
was there a lease agreement between the two of you?
Malad, lease agreement, Malad, it was a 11-month agreement, Malad. I have produced that copy also, Malad.
What does it say about vacating? Should you give him an advance notice?
Malad, advance notice has to be given, Malad, 3 months notice.
So this this notice that you gave on 4/12.
Yes.
Is in accordance with the terms of the lease agreement.
But because of this, yes, Malad, I will come to Malad.
So for 3 months rent, you are bound to pay.
Malad.
And if you vacate for whatever reason.
Yes, Malad.
Because it is not preceded by a notice. You'll have to give this 3 months rent. How can you escape that liability?
Malad, up to December, I have paid the rent, Malad.
No. December, you gave a notice
Yes,
saying that I will vacate in 3 months.
Yes, Malad.
As required under the terms of the lease agreement. So 3 months you cannot escape. Even if you go out early, you still have to pay the 3 months notice.
Yes, Malad. That's
So then what is the?
Then, Malad.
How much is the rent?
Malad, 12,400.
ಎಷ್ಟಾಗತ್ತೆ ಅದು?
36,000.
ಅಡ್ವಾನ್ಸ್ ಎಷ್ಟು ಕೊಟ್ಟು?
Advance 1 lakh.
62,800 ರೂಪಾಯಿ ಆಗುತ್ತೆ. ಮಿಕ್ಕಿದ ಬಾಕಿ ಏನೇನಿತ್ತು?
ಮಿಕ್ಕಿದ ಬಾಕಿ ಏನೂ ಇಲ್ಲ. ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಬಿಲ್ಲು ಎಲ್ಲಾದು ಕಟ್ಟಿದೆ. He has not produced any evidence.
ನೀವು ದಾವಾ ಹಾಕಿದ ಎಷ್ಟಕ್ಕೆ?
Please, Malad.
ನೀವು ದಾವಾ ಹಾಕಿದ ಎಷ್ಟಕ್ಕೆ?
91,200.
So according to the terms of the lease agreement, he has to repay 62,800.
Lord, I leave it. So far as that is concerned, I leave it. According to me, Lord, since.
What was his defense?
Lord, his defense is that, Lord, that is what I want. The dates I want to give, Lord. Suit was filed on 24/3/2014. After filing suit, Lord,
So
he
you did
sent.
not, you gave him just 1 month notice. You filed the suit.
Yes, Lord. Then, my Lord, on 3/4/2014, Lord. That is on 4/4/2014, he sends the reply dated 3/4/2014. Saying that, my Lord, I vacated the premises on 1/3. And he called me to his office. And in the office, he has refunded 50,000 rupees after deducting the damages. What damages I don't know.
Refund 55,000.
50,000
50,000 rupees.
in front of DW 2 and 3.
Who are they?
Well, they're the local persons, one Nagaraj and another Keshavamurthy.
Why did you not give him check?
Well, it was a cash in the office. They came and requested me to give the cash.
Acknowledgement from them.
ನಾನು ತಗೊಂಡಿಲ್ಲ.
Already gone to the police station. They had already issued a legal notice. How
Sure.
can you just give cash and say I've refunded? Okay.
ಅಲ್ಲ ಕೇಳಿದ್ರು ಯಾಕಂದ್ರೆ ಅವರು ದೇ ಆರ್ ಫ್ರಮ್ ಅವರ್
ಈ ತರ ವೈಮನಸ್ಸೆ ಇದ್ದಾಗ ಕೊಟ್ಬಿಡ್ತೀರಿ ನೀವು ಸುಮ್ನೆ?
ನಮ್ಗೆ ಯಾರೋ ಇಬ್ರು ಮೂವರನ್ನ ಕರ್ಕೊಂಡು ಬಂದಿದ್ರು ಅವ್ರುನು. ನಾನು ಅದಕ್ಕೆ 2 ವಿಟ್ನೆಸ್.
It's, you're not a layman, you should have taken some receipt.
Correct, but
If there's nothing, then pay that remaining amount.
they came to the court and given an evidence as DW 2 and 3
Unless there
stating
is
that
proof, Vijay Kumar, that you repaid. 3 months I'll accept because the lease agreement indicated 3 months notice. So January, December, January, February, 3 months they have to pay. Remaining will be 62,800.
ಅಲ್ಲ 62,000 ಅಲ್ಲಿ as per the agreement, one ನಿಮಿಷ. As per the agreement, they have to give 1 month rent as a painting charges. They also admitted in the cross examination.
Plus 12,000.
ಆಮೇಲೆ ಒಂದು 2,000 3,000 ರೂಪಾಯಿ ಇತ್ತು ಎಲೆಕ್ಟ್ರಿಕಲ್ ಅಂಡ್ ವಾಟರ್ ಚಾರ್ಜಸ್. ಟೋಟಲ್ 50,000
ರೂಪಾಯಿ ಕೊಟ್ಬಿಡಿ, ಕ್ಲೋಸ್ ಮಾಡಿ, 50,000 ಕೊಟ್ಬಿಡಿ.
ಸ್ವಾಮಿ 50,000 ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಮೌಂಟ್ ಅನ್ನ ಇಬ್ಬರ ಎದುರುಗಡೆನೆ ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದ್ರ ಜೊತೆಗೆ ದಿಸ್ ಮ್ಯಾಟರ್ ವಾಸ್ ಪೋಸ್ಟೆಡ್ ಬಿಫೋರ್ ದಿ ಸೋ ಮೆನಿ ಬೆಂಚಸ್. ಅವತ್ತು ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು ವಿಜಯ್ ಕುಮಾರ್ ಒಂದು 15,000 ಕೊಡಂದ್ರು. ಕೊನೆಗೆ ಅವ್ರು ಒಪ್ತಾ ಇತ್ತು. 1 ನಿಮಿಷ ಸರ್ ದಯವಿಟ್ಟು ಪ್ಲೀಸ್. ಅಲ್ಲ 1 ನಿಮಿಷ ಸ್ವಾಮಿ.
ಅದು ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರೆ ಚೆನ್ನಾಗಿರ್ತಿತ್ತು. ಇವಾಗ penalty.
ಅಲ್ಲಲ್ಲ ನಾನು ರೆಡಿ ಇದ್ದೆ. ಕೊನೆಗೆ ಇವರು ಮಾತಾಡಿ ಅಂತ ಹೊರಗಡೆ ಕಳಿಸಿದ್ರು. ಹೊರಗಡೆ ನಾವು ಮಾತಾಡಿದ್ವಿ. ಹೊರಗಡೆ ಮಾತಾಡಿದಾಗ ಕೊನೆಗೆ ಇವ್ರು ಒಪ್ಲಿಲ್ಲ. ಕೊನೆಗೆ ಸಾಹೇಬ್ರು ಏನಂದ್ರು 12-13ನೇ ಕೋರ್ಟಲ್ಲಿ ಇನ್ನೊಂದು 10,000 ಆಯ್ತು ಸ್ವಾಮಿ ತಾವೇನು ಹೇಳಿದ್ಕು ನಾನು ಬದ್ಧ ಅಂತ ಅವತ್ತು ಹೇಳಿದೆ. ಇವರು ಒಪ್ಲಿಲ್ಲ. ಇವತ್ತು ಸ್ವಾಮಿ ಇಟ್ಸ್ ಅ ರಿಯಲ್ ಫ್ಯಾಕ್ಟ್ ಮಿಲರ್. 1 ನಿಮಿಷ ನನಗೆ ಅವಕಾಶ ಕೊಡಿ. ಅಲ್ಲಲ್ಲ 1 ನಿಮಿಷ ಸರ್ ಪ್ಲೀಸ್ ಪ್ಲೀಸ್. ಅಲ್ಲ ನಾನು ಅಲ್ಲಲ್ಲ 1 ನಿಮಿಷ
Please relax.
ಸ್ವಾಮಿ. ಅವರು from the date of agreement, if he has not paid the rent within the date, ಅವ್ರು ಏನಾದ್ರೂ ನಮ್ಮ ಮನೆಗೆ
ಅದೆಲ್ಲ ಹಳೆ ಕತೆ ಆಗೋಯ್ತು, ಬೇಡ ಇವಾಗ ಹಳೆ ಇದಕ್ಕೆ
ಸ್ವಾಮಿ ನಾನಂತೂ ಕೊಟ್ಟಿದ್ದೀನಿ. ತಾವು ಕೊಡ್ಲೇಬೇಕಂತ ಹೇಳಿ ನಾನು ಕೊಡಕ್ ರೆಡಿ ಇದ್ದೀನಿ ಅಷ್ಟು. ಅದಕ್ಕಿಂತ ನಾನು ಹೆಚ್ಚಿಗೆ ಏನು ಹೇಳ್ತಾ
50,000 ಕೊಟ್ಬಿಡಿ, ಕ್ಲೋಸ್ ಮಾಡೋಣ. ಜಾಸ್ತಿ ಬೇಡ ಇದು. ನೀವು ಲಾಯರ್ಗಳಾಗಿ
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀನಿ. ಎಲ್ಲ ಇಬ್ರು ವಿಟ್ನೆಸ್ಗಳು ಕೋರ್ಟಿಗೆ ಕರೆಸಿ ಹೇಳಿಸಿದ್ದೀನಿ. ಅವ್ರನ್ನು
ವಿಟ್ನೆಸ್ಗಳು ಹೇಳಿಸ್ತಾರೆ. ನೀವು ಈ ತರ ಜಗಳ ಆಡೋ ಸಿಚುವೇಶನ್ ಅಲ್ಲಿ ನಾನು ಕ್ಯಾಶ್ ಕೊಟ್ಟೆ ಅಂತ ಹೇಳೋದು ನಂಬಕ್ ಆಗ್ದಿರೋ ಕೆಲಸ. ನೀವು ಖಂಡಿತ ರಸೀದಿ ತಗೋಬೇಕಿತ್ತು, ಚೆಕ್ ಕೊಡ್ಬೇಕಿತ್ತು. ಅವಾಗ ಮಾತುಕತೆನೆ ಬರ್ತಿರ್ಲಿಲ್ಲ.
ನಿಜ, ಬಟ್ ಫೇತ್ ಆನ್ ಹಿಮ್ ಬಿಕಾಸ್
50,000 ರೂಪಾಯಿ ಕೊಟ್ಬಿಡಿ, ಕ್ಲೋಸ್ ಮಾಡಿ.
ಇಂಟ್ರೆಸ್ಟ್
ಜಾಸ್ತಿ ನೀವು ಡೋಂಟ್ ಪುಷ್.
ಆಯ್ತು
ಸರಿ ಸ್ವಾಮಿ, ತಾವೇನು ಹೇಳ್ತಾರೆ ನಾನು ಬರ್ತಾ ಇನ್ನೇನು
ಯಾವತ್ತನ್ನು ಕೊಡ್ತೀರಾ?
ಅಲ್ಲ ಅದು ಐ ವಿಲ್ ಅಂಡರ್ಟೇಕ್ ಟು
ಬೇಡಿ ತಿರ್ಗಾ ಜಗಳ ಆಡ್ತೀರಾ ನೀವು?
ಇಲ್ಲ ಚೆಕ್ ಕೊಟ್ಬಿಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ. ಎನಿ ಡೇಟ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ, ಆನ್ ದಟ್ ಐ ವಿಲ್ ಗಿವ್ ದ ಚೆಕ್. ನೈಸ್.
ಡಿಡಿ ತಂದು ಕೊಟ್ಬಿಡಿ.
ಸರಿ ಸ್ವಾಮಿ.
Number 7, TD Nagraj.
Number 2 and 4.
7. Next date on date.
Others will be repeated next Monday.
Serial number 8, right, it's settled. We have to file a joint memo
D1,
tomorrow.
8 tomorrow.
Sixteen ಅಲ್ಲ sir?
ಎರಡು 16.1 ಎರಡು ಇದು. ಎರಡು ಕರೆಕ್ಟ್ ಮಾಡಿ.
ಇದು ಮಾಡಿದ್ದೀರಾ? ಇದು ಮಾಡಿದ್ದೀರಾ ನಾವು? ನೋಡ್ಬೇಕು.
Next.